I mentioned one Lojima matter.
Yes, please.
Grateful to you.
My lord, one hearing matter as per your lordship's comment.
No, not now.
No, but I have given notice.
Let us see today if there is a resolution. We'll stop adding altogether. We'll not even add applications.
My lord,
We'll wait for today.
my lord, with
Applications, yes.
my lord, with notice to other side, I am mentioning hearing of matrimonial.
And an order for 10, please hand over, yes.
My lord, with notice to other side, I am mentioning hearing of
My lord, may I
matrimonial.
mention one WPLRT matter? May I mention one
I have come
WPLRT?
Can both of you speak together?
My lord, kindly take up, my lord.
We are not taking up. Yes.
My lord, may I mention one WPLRT matter under the heading motion?
Matter relating to matter your lordship
Oblige, your
is
lordship.
to give liberty to mention the before appropriate mention. The order, my lord.
No.
My lord,
Liberty is there, but we are not adding now.
my lord, may I permit? My lord, order 39 rule 1 to reject partition suit. Order 39 rule
What are you
1
mentioning? For what? Under which heading?
to be mentioned, my lord.
For what?
There is a section 5. So,
So why to be mentioned as an application? Mention it as an application.
my lord,
Yes.
May I be permitted to mention a matter for restoration? The matter was
Application.
Lordship, may I be permitted to mention Group 1
Appeal.
Group 1.
For leave to file without certified copy.
Yes.
My lord, may I be permitted to mention one first appeal of 2018 for
Hearing, please don't mention. Yes.
May I have a lordship time leave only for the matter to be commenced to be mentioned for only one direction. Your lordship was pleased to pass an order directing the appellant, that is the state, two directions. Deposit the amount in para 12 and the LCR will come, messenger and cost. The deposit has been made within time. The messenger process is ready, but there has been some lapses. As there was a time period of 1 week, that 1 week was not there.
To be mentioned, for extension of that time.
Yes. Only
My lord,
Your deposit will accept.
it's ready. I'm
my lord,
ready.
this is for application, my lord.
Application. Call on.
My lord, with my lord's permission, can I mention one matter? My lord, for hearing, my lord, first appeal.
No.
My lord, there was a direction, my lord. There was a liberty given to us, my lord.
Yes, call on the list.
I am for the appellant in 1 to 11. A similar matter.
Reckon board এক থেকে 11 Foreign case.
These are similar matters, my lord, arising out of a land acquisition proceeding, my lord, section 18 reference. A similar matter has been, my lord, heard by your lordship and judgment has been delivered. So we mentioned, my lord, these matters because, my lord,
Mr. Banerjee, what is the ratio there in our judgment?
your lordship fixed, my lord, a certain sum to be the land acquisition compensation, 5,52,000, and remanded the matter back to the, my lord, trial court for calculation, for, my lord, calculating the total amount and interest if payable upon leading
It arises
further
out of the same acquisition proceedings.
same acquisition proceeding, but they said that they shall pay for a SLP. They took time on the last day.
Yes, what do you say?
My lord, on the last occasion, when the matter was, my lord, taken up. Now, my lord, the argument was advanced that same acquisition proceeding, one matter already disposed of by your lordship by delivering judgment, so others may be the same, the fate will be same.
Yes.
Now, my lord, we prayed, we put the court that some time be given so that because we have to file the SLP. SLP has been filed. My lord, this is, my lord, the letter of intimation.
What is the stage of the SLP?
My lord, stage, my lord, the
Diary number, SLP number has
Diary number is.
my lord, the SLP file, he said, but my lord, it is under process. Kindly, my lord, give us.
We cannot hold on indefinitely for that. You have filed very well, yes. But then it will be easier for you, Mr. Shen. If you pass judgments on this, you can challenge altogether. No, actually, because these are from the same acquisition proceeding. How can you shut our eyes to that?
Kindly give us some more time when it is already in process. I think, my lord, at least 4 weeks time, lordship, kindly grant us 4 weeks time. Already, it is not that no step has been taken. Step has been taken. Kindly give us some time, lordship. Otherwise, what will be my lord?
Yes, we'll keep it as on 18th of December, Mr. Banerjee.
18th.
As well.
Yes.
My lord,
No, there are 4 other appeals, my lord, which are not included in this list, my lord. I'm giving the numbers. They may also be.
same acquisition proceeding.
Same acquisition.
Please give the numbers.
Now, my lord, the only thing may I pray. In the meantime, would your lordship be kind enough, my lord, to direct us, my lord, to
complete
file our,
list.
my lord, the paper book, at least one or two paper books so that we can file the paper. In the meantime, I shall.
In these matters?
In this matter, paper book has not yet been, my lord.
They are the appellants. So you file a paper.
They are most of the matters state at the appellant. We are also appellant in some of the matters.
Very well. These are the other.
Total 15 matters, my lord.
No,
Apart
which
from-
which ones have not been?
1 to 12 আমরা আছি নাকি?
1 to 11.
You have given all the numbers, but which are not appearing in
I'm
the
giving
list?
the phone numbers, Lord. I'm giving the phone numbers.
আমরা কোনখানটা
এক
অ্যাপিলেন্ট?
থেকে 12 আজকে ওটা
এক-
অন্য আরো
ও,
চারটে
ওই-
বলছে, অন্য চারটে বলছে।
ওই চারটে আমরা অ্যাপিলেন্ট নই।
I'm giving the numbers to your Lordship.
Learned counsel appearing for the petitioner submits appellant. Learned counsel appearing for the appellant in FAT 266 of 2020 submits that the না স্যার সবকটাই একসঙ্গে একটা অর্ডার করে দিন। In all the above, all the above appeals arise out of a single acquisition proceedings with regard to other appeals arising out of which this court has already passed judgments. For sub next para, learned counsel for the appellant in FAT 266 of 2020 submits that accordingly all the present appeals as well as 4 other appeals, comma, the numbers of which are being supplied immediately by the appellant, comma, be disposed of by similar judgments. Full stop. Next
Right.
para.
It
Learn-
is their contention.
No, how contention?
Learned counsel appearing for the state submits that since specially petitions have been filed against the judgments already passed by this court, comma, this court may stay its hands and grant 4 weeks time for ascertaining the outcome of the said SLPs, comma, which have already been allotted diary numbers. Full stop. In support of such contention, comma, a communication by the learned advocate of the Supreme Court appearing for the state is handed over in court and kept on record. Full stop. Keeping in view the pendency of the SLPs, comma, we direct these matters along with the 4 matters which are the numbers of which are to be handed over today by learned counsel, comma, to be listed together under the same heading on December 17, 2025.
Get
I'm grateful.
Thank you. বোর্ডে ততক্ষণ 12-13 দেখাও 12-13 দেখাও।
I am for the respondent.
Yes,
Matter is appearing at my instance, my lord.
why Mr. Nag?
My lord, kindly sees the order dated 2nd July 2025, my lord. No, my lord. Page 5, my lord. Page 5, Lordship will find paragraph 26. A status quo order was granted. Now, my lord, they are enjoying the interim order.
2nd June or July?
2nd July, my lord. 2nd July 2020.
আচ্ছা আচ্ছা
Now, my lord, paragraph 26, Lordship will find.
yes,
Lordship disposed of the stay application.
status quo.
Status quo order was granted. Now they are enjoying the interim order.
Yes,
Now, my lordship sees 29 and 30. The trial court record shall be brought by patient maintenance at the
Yes.
cost of the applicant. It's not deposited till date.
by the appellant.
By
You
the
want to
appellant.
deposit now?
Not deposited.
You want to deposit or
Then within 8 weeks. There was nothing default is mentioned. Now they are enjoying the interim order. The situation is that I am suffering and my mother who is 72 years old is suffering for this. Now, here if lordship can grant me, I will fast prayer would be dismissal in case if not,
no, we can then put it and ask for a revised let us see the office report.
my junior, where is that? He said, the Olovana has not been
Cost has been deposited rupees 30 bringing the trial special mission has been deposited late. We are accepting that.
Oh.
It has been deposited.
All I am saying,
Service was dispensed with.
service.
So only special messenger cost that has been deposited. We are accepting that and directing the office to take steps accordingly for bringing the
Lordship
trial.
and paper book be prepared at my instance and
If you want that, we will grant you that liberty.
lordship grant that
Very well.
if
Learned
the cost may be shared by them
No, that will be different.
we
Either
will
they
do that.
prepare or you prepare.
We will do that. We will do that at our cost.
You are for
Within
the
4 weeks.
respondent, obviously. Learned counsel appearing for the respondent submits that despite a specific direction being given on July 2, 2025 to the appellants to deposit special messenger cost as well as for filing of paper books, comma, nothing in that regard has been done by the appellant. For sub next para, however, comma, from the office report dated November 18, 2025, we find that the appellant has deposited special messenger costs, comma, however, comma, belatedly. Full stop next para. We accept such late deposit of special machines at costs. Full stop. The office shall accordingly take steps accordingly on the basis of such costs to expedite the calling for the trial court records. Full stop next paras. On the prayer of learned counsel for the respondents, comma, who submits that the respondents are suffering due to the delay, comma, we direct the respondents to prepare and file the requisite number of paper books instead of the appellants within 8 weeks from the date of
We will do that within 4
within 4 weeks from the date of service of notice of arrival of the trial court records on the learned counsel, learned advocate for the respondents. Full stop. The office, comma, for such purpose, comma, shall serve notice of arrival of the trial court records on the learned advocates for both the appellant as well as the respondent numbers 1 and 2.
Liberty to mention maybe given.
Liberty is already there.
Oh, Lordship, Lordship. I'm grateful.
Thank you.
Much.
Matter I am the
When does the interim order expire, Mr.
Lordship, the interim order will expire on 30th November. The part had matters,
Expired on 30th November.
it will expire on 30th.
Say that.
Lordship, the part had matter, Lordship, kindly.
Part had not before this bench. That is a difficult. It was marked as part hard. Don't think so.
Then subsequently
Yes, yes, hard in part. But then we have to cancel the part hard. We have to fix another date for that. We have to see to Justice Kumar and
part had type bench and all.
whenever we take up that matter, এটা একটু নোট করে রাখবেন তো এটা যখন জাস্টিস উদয় কুমার সঙ্গে বলবো টু বি মেনশনড দিয়ে দেবেন ফর ক্যান্সেলেশন অফ পার্ট হার্ড
my lord, at that time of hearing of the trial court, my lord, I could not produce all the documents, but only one documents of acquisition that was. Now, my lord, I have got all the documents of the
Do you
acquisition.
want to prepare a supplementary paper book incorporating that?
No, my lord, there is no any filed any paper book, my lord. That order was not passed, my lord. Your lordship was pleased to.
So far,
give the
our
matter
submission
for-
is concerned, Lordship, almost completed. Now, Lordship,
If you want to use those papers, Mr. They give advance copies to them and rely on
Yes,
them.
my
If
lord.
they don't have any objection, we'll take those.
Yes, my
Or
lord.
you can file an affidavit in connection with
Affidavit, my lord. Otherwise, those documents will not additional evidence.
and also for your learned advocate on records protection.
Yes, my
And
lord.
those documents should come on oath.
Yes, my lord.
Somebody has to take responsibility.
Yes, my lord. Otherwise,
We know.
we will face some difficulties.
Yes, very well.
Lordship, those documents, Lordship, subject to your Lordship's
You
consent.
don't know what documents they are.
Lordship, those documents were not placed before the Honorable Single
Full
Judge.
to.
And Lordship,
what?
this Honorable
Not
Singh-
placed before the learned single judge.
No,
No, my lord. Only one paper of acquisition was there.
Then, Mr. We cannot permit that.
now, Lordship,
Papers which are not before the learned trial judge, unless it's an order for
My lord, that is according to that, my lord, acquisition.
then
that
you
is
have to
a-
an order for 27 because it was not before the learned single. You know that, Mr.
Yes, my lord.
Because we are in appeal. We cannot take it
Only for
first.
that reason, my lord, I want to.
No, it would assist the court, maybe them also, but then file an application for under order for 27. We'll extend the state till disposal of the appeal.
Yes, my lord.
The interim order granted earlier is extended till disposal of the appeal. First of Can 1 of 2025 is accordingly disposed of. First of next para, learned AGP, additional government PIDA submits that certain documents which are of direct relevance to the present adjudication could not be produced before the learned single judge. First of accordingly, learned additional government PIDA seeks to produce such documents before this court, comma, which is objected to by learned counsel for the appellants on the ground that those were not before the writ court. Push up. Next para. In such circumstances, comma, we grant leave to the state to file a proper application under Order 41 Rule 27 of the Code of Civil Procedure, incorporating additional papers if the state wishes to rely on the same with an advance copy to the learned advocate for the appellants as well as for the respondent numbers 1 to 3. Push up next para. Liberty. No. Very well. Since it further appears that the matter was heard in part before a different bench comprised of one of us within bracket Bhattacharya J, comma, the file may be placed whenever the said bench sits, comma, for the purpose of cancellation of the part heard. Whenever that bench sits, in the meantime, you do these things.
Yes, my lord.
Whenever that bench sits, please appear and we'll direct this appeal to.
Also, I'm praying for also leave to file an objection to his application.
Acha, very well. আরেকটা line add করে দিন, affidavit in opposition and reply, if any, in connection with such application for production of additional evidence shall be exchanged in the meantime, prior to the hearing of the appeal. Whenever it appears, just mention that application number also, so that we can cancel the pattern and direct that application to appear alone.
Yes, my lord.
Thank you.
15, your lordship, this is the part heard lordship. This matter was taken up for hearing.
Give us half a second. Yes.
Lordship, lordship.
না WP যেটা থেকে arise
Act for her.
have you got copies of the paper books?
Yes, we have got it.
Very well.
We
Then
have
we'll
already
direct them to file on the next day before the court. We'll keep it next Thursday. We'll direct the paper books to be filed in court.
Court, court.
Since you have already got copies, and we'll take up the matter.
Next Thursday, my lord.
Yes.
Next
If the paper book contains all the necessary
yes,
papers of the
yes.
writ petition, then we'll take up on that.
Much obliged, my lord.
We'll not call for the records of the writ. Very well. It appears from the office report dated November 18, 2025 that the paper books have not yet been filed. Although learned counsel appearing for the Howrah Zilla Parishad as well as the contesting respondents submit that they have been served with copies of paper books prepared by the appellants. Full sub next para. Accordingly, since none appears for the appellants at the time of call, let the matter stand adjourned till November 27, 2025 to be listed under the same heading, when requisite copies of paper books shall be filed in court by the learned advocate for the appellants for the matter to be taken up for hearing.
Much grateful, my lord.
Thank you. Coconut oil.
Yes, your lordship.
Yes, Mr. Rajan.
But I was on legs on the last day.
Yes.
But to start off with, I'll start a little differently today. Lord, I believe, Lord, as far as infringement is concerned, although I had not showed the judgments, Lord, I had said it's not applicable. It's no point, Lord, spending a day and a half, Lord, dealing with that. So, Lord, let me take the bull by the horns, my Lord, and take the case of passing off. Now, there, my Lord, I'll put things within a very short compass. Lord, Your Lordship will not be troubled with the act. Lord, I'll take 5 minutes on not facts and then go straight to it, not tackle it using their judgment. Although, Lord, the juniors have taken out 22 odd judgments, I think, Lord, one judgment cited by them should take care of it. So, Lord,
what is the main, if there's any landmark judgment or one judgment which?
So they have relied on that as the landmark judgment, and the linchpin of their argument is based on that.
Oh.
So I'll not take care of it from there.
Thank you. Yes.
Now, I'll give your Lordship a chart of the judgments with some comparative pictures. So, Lord, I answer your Lordship's query, which was what if the get-up is the same, but they have clearly different names?
Yes.
That was the one question which had fallen from your Lordship. Lord, I have prepared not a list of judgments with the photographs and the relevant paras, so I don't have to place them. I'll give it, not just to shorten it, nothing else.
Absolutely. Thank you.
I can place all of them.
No, please.
Now, Lord, the case on passing off, Lord, is like this. Lord, number one, I don't think I need to repeat the principles, but still, Lord, for the sake of completeness, Lord, it is an action in deceit. It's a common law right. It is superior to the not statutory right. It's wider. Now, the action is basically an action for deceit. If one goes by the ancient judgments, not going back to not late 1800s, right up to now, not earlier it was a triple test. Some say now it's become five not tests, but the basic of it is not there has to be a goodwill and a reputation. Without that, not they can't be passing off is what is one school of thought believes. Second is not there must be a misrepresentation. And third is it must result in damage to my goodwill. These were the basic tests. Now, these have also been watered down, particularly in India. Not that it's very material for this, but what the judgments now say is, look, a prior user will always succeed against a later user. So its priority of adoption is one thing which one looks at. Two, dishonesty, it's not necessary to prove dishonesty, but if one can show dishonesty, that is usually the end of the matter. Last is not, and this has a bearing on the first test, not this goodwill and reputation. Not the earlier judgments have proceeded on the basis that it comes with long years of user. But our Indian courts, not particularly the Supreme Court, has kept that issue, or rather not changed that issue a little bit, saying that sometimes one can get that not goodwill by a very small period of user also. Sometimes it may be as short as a day. It depends on the kind of advertisement, goodwill, publicity, etc. So this is not the long and short of an action in passing off. Now, Milord, in our case, again, without taking a lordship into the documents, Milord, I'm just giving a lordship the overall.
Bachat, for
Yes.
that,
Yes.
short use but goodwill, for that probably your turnover or your sales may be a relevant factor.
But what I would say is not the Indian judgments are not very clear on it, but yes, there are judgments which make that very clear also. In fact, there's a series of Bombay and Delhi judgments, not again accepted by the Supreme Court. Supreme Court doesn't say it independently, but it quotes them. What they say is, not one acquires a trademark by mere adoption and use eo instanti. So the moment I use it, the expression used is eo instanti.
But eo instanti then takes away all these.
I know. I'm just not. I gave you a lordship both sides of the picture. It's not relevant to our case.
Yes.
So there are judgments which say that. Which is why that test of priority in use and adoption. And which is why knowledge, honesty, dishonesty, these become factors, practical factors your lordship looks at. The judgments are clear. Each matter is an individual matter, which is a question of fact. Your lordship will decide on the facts of each case. It is not as if there's some uniform.
Not yours.
No, I know. I was just double checking.
All of us do that whenever someone. Yours was also on.
No. Mine is perennially on silent, which is why people complain
Exactly
that I
happens
don't
to me
receive
also.
phone
I
calls.
forget to switch.
I have some nasty habits. One is that I don't look at WhatsApp.
Oh,
so that creates a problem for professionals because most people not use that.
but you can get over some of the problem by marking that option. Whether red or unread, it won't be shown. It won't be shown to the other side. So some of
it's WhatsApp is
you
something.
won't know whether you looked at it.
WhatsApp is something I've avoided for other reasons. It's like I avoided a mobile phone till the entire world had it. So, now,
Yes.
so to go back, these are the general principles of passing.
Now the tests have been diluted. We understand. Yes.
None of this will matter really. I'm just giving a lordship the overall. Now, in our case, again, I summarize the case. We are admitted prior users. There is no dispute about that based on their date of user in their trademark application and the bills and invoices we have put in. There is no dispute. I'm the prior user. So he is second in the market. There can be no dispute. Second is your lordship has then looked at the bottles.
Mr. Bachat, what was the period of your prior user approximately?
Long prior. But
in decades.
About 49 goals. I'll give you a lordship that sometime in 2000.
In
the plastic bottle.
In decades.
Yes. In plastic bottles are in 2004. I forget the date. I'll give it to you, lordship.
No. Exact date is not. Yes.
Trademark Shalimar from 1940s, but plastic bottle. 2006, and the invoices are there. and invoices.
My lord, just to interrupt Mr. Bachawat, there is a resolution, my lord, which has been passed by the bar not to participate in any judicial proceedings.
Mr. Bhattacharya will continue hearing. If you choose not to, then we are in the midst of arguments.
No,
And we are not being
because-
able to add matters in the list due to the pendency of this. If you don't want to do, we won't force you. But
Lord, I think if there's a resolution passed by the bar library also, adopted by us.
I do not know about bar
we did
library,
not have the
but bar
time to
association.
adopt. Did not have the time to adopt.
তুমি একটু খোঁজ নিয়ে নাও না, খোঁজ নিও। Lord, if there is a resolution by the library, we always adopt. Not that will happen. It's a question of time. I'll get maybe 5-10 minutes. Not let me
use that.
Let me use that. ये তুমি একবার কাউকে
আচ্ছা আর লিস্টে আমরা কোনো অ্যাপিল অ্যাড করব না
কাউকে পাঠাও জানেন
ফর ইটারনিটি যতদিন আমাদের বেঞ্চ আছে yes
now Lord, number one, prior adoption.
Yes.
Number two, Lord, your lordship has seen the bottles. I have a blue, I have a yellow. He has adopted both of them.
Plastic bottle since 2006.
Yes.
Yes.
Now, shape, color, get up is the same. Content, according to me, the inside content, theirs is hair oil, mine is edible oil, according to them. But then I showed your lordship that is evidently false because 99% of their sales is mine, not is edible oil.
Yes.
Now, contents, according to them, are different. Number two, according to them, not the writings on the bottle are different trademarks. Mine is Shalimar and Lord, his is KMP. So the writing is all that, not differentiates. Now, Lord, adopting two things I point out here, Lord. The writings are different over here. Now, this is not an action, my lord, against the word mark. My action is an action based on get up. Now, it's a question which was put to my learned friend, which he didn't clearly answer. Does the get up include shape or not? It was not answered. Now, I'll show your lordship. Lord, get up is the complete thing. It includes shape, it includes color, it includes color scheme, and it also includes the label.
General impression given is what matters.
Correct. It's the overall picture. It's the overall picture. I am not targeting any individual thing. So when my learned friend argues, I will get a monopoly on the container, plastic container, answer is no. I am saying that the complete picture is the same or deceptively similar.
So they may use a different shaped plastic bottle and different impression given.
Absolutely. And that's what the House of Lords judgment, my learned friend, relies on says. But in fact, it's very interesting when I take your lordship through the judgment. But before getting into the facts of our case, let me just summarize that case. But what happened there was, there was a container of a lemon, plastic shaped lemon bottle, which sold lemon juice. So, two interesting things which arise there are, look, if you cannot get monopoly over the word lemon for lemon juice, then can you get monopoly over the container or the shape of a lemon? This is really the interesting point decided over there. The second thing is, look, there was a clear finding by the trial court who also granted an injunction that any person who read the labels would know that the goods of the defendant are not the goods of the plaintiff. Very clearly spelt out. Judgment holds it in no uncertain words that no one can be deceived by reading the label. In spite of that, injunction was granted. The appellate court did not interfere, and the brand names were both different. The plaintiff was Jif Lemon.
Yes.
The defendant was Real Lemon. Now, appeal court injunction not refused, and matter went up to the House of Lords. 5 learned judges, 3 of them give opinions. Appeal not dismissed, upholding the injunction, where exactly each of these points my learned friend argues were brought up and rejected. Which is why I was surprised my learned friend cited the judgment despite saying Mr. Bachawat had warned us not to rely on this judgment. He started off saying it, but I am tempted to. Now, the facts there were this. It's important because there was a English company which started selling it. Now, there were many others who also tried to sell it in England, many others. But for commercial reasons, didn't succeed. So there was no one who had uninterrupted use of these lemon containers. Now, the defendant had a US company where it had a registered, it had registration. And it was selling it in similar shaped bottles, not identical. So, while this was shaped like a lemon, that had little bubbles on it. So it looked more like a grenade, if your lordship remembers. So it looked more like a grenade. So then they decided to come into England. And they came up with 3 different models called Mark 1, Mark 2, and Mark 3, of this particular container for the lemon juice, which were also the same color. Lemon will always be a lemony color, I suppose. So now, when they came up with the first one, I'll call it Mark 1, the plaintiffs came to court and sought an injunction where, the defendants gave an undertaking that they will not release any other model, Mark 2, Mark 3, without giving 28 days notice. So, they gave 28 days notice and the matter came to court. Trial court did not grant interlocutory injunction. Appellate court granted interlocutory injunction. So, the injunction was in place and then the suit came to be heard. So, this is the first difference. This was a case of a trial after evidence, post-evidence. Which is why when my learned friend says you have to establish this, that and the other, the law is very clear. At the interlocutory stage, I only have to show prima facie that it has become distinctive by user. And the judgments are clear. Long years of user make it distinctive. Now, the second important thing there was, or distinction was, please remember, the dispute and the entire core of the controversy was, can you claim lemon for lemon juice? You can't ever get registration of lemon as a trademark. So can you indirectly then get the container? That was an issue. Now here, that's not the case. My container is not shaped like a coconut. So that issue doesn't arise. It's irrelevant according to me. But even in that context, the observations on it are very important in our case, and I'll take your lordship into it. So, this is the second aspect of the matter. Now, thereafter, an argument is made that, look, by filing an action in passing off, and though you don't have registration of that device or the container or the word, you are indirectly getting a monopoly over the container itself, the lemon container, even though you have not registered it as a design and you cannot. That was the argument made. And there were various sub-layers to that argument, all very interesting. But the court said, look, in an action for passing off, I'm not seeking a monopoly on the containers. I'm not in the business of selling containers, nor is the defendant. It is one thing if you are selling empty containers. It would be a different issue. But the moment he tries to sell oil in a container similar to mine, that is when, he is guilty of passing off. And there's a duty cast on him. Once he knows what my container looks upon, there's a duty cast on him to differentiate. And differentiate in such a manner that no one will get deceived. And the test not being that of what my learned friend says, a careful consumer who will look at the label. Not that of a person who will look at the label, but a man who has gone into the supermarket in a hurry. That's the test they use there. Not our Supreme Court has used it. Other words. So this is what it says. So it says, look, there's no monopoly being granted on the container. You go sell the containers empty, no problem. But the moment you try to sell coconut oil in a container similar to mine, you are hit. Yes. So this is the long and short of the judgment. I'll place it. But it takes care of every limb of the argument my learned friend has made. Every limb. Generally, resolution.
So the next limb can be covered before the news comes.
So this is one part. Now, let me just take care of his other defenses. We have all the judgments. We'll place it. I think the time will maybe a little short. Now, another limb of my learned friend's argument was he displayed a number of yellow-colored bottles to say, look, this is common to the trade. Now, that is also taken care of in Jif's Lemon's case by saying common to trade doesn't mean what you're saying or doesn't mean what you think. It means it is so common in use and so descriptive that you could not have adopted it. So then to translate it into the Indian authorities say it's not enough to say common to the trade. The burden is on you to show there are many other producers, so much so that it is now common property. Not to use an example, Hawaii was a Bata trademark. Then, at some point of time, everyone started making those Hawaii slippers, and in trade, it came to be known as Hawaii Choti. And the excise department actually had a classification called Hawaii, and that's when it became publicized juris. So, Bata could no longer claim it. So that is the kind of situation. Now, what the judgments on that says, it's not sufficient to say it's common to the trade. It is not even sufficient to produce bottles. You have to show that they have in continuous use, fair amount of use, and more important, prior to my use. Because if I have started it, the fact that I am someone selling 10 bottles in some village, someone selling it in a corner of, let's say, Kerala, I am not supposed to know it. I am not supposed to go after everyone. He must show commercial use on an extensive scale prior to mine, and the burden is on him. Those judgments are there. So, this case of common use also therefore goes, and that perhaps is the long and short of all of his defenses. Infringement does not apply because there is no action, there is no order on the injunction. Number two, you can't get monopoly of the container argument. Number three, common to the trade. These are
So you can just deal with those judgments and we can get it over with them.
I'll do that right away.
Yeah, we can start it now. Yes.
I'll do that right away. Before that, could I just give your lordship the chart?
Yes.
Just to illustrate, any number of judgments, completely different trademarks, similar get-up. ঠিক আছে, ওটা হ্যাঁ বার করে দিই, একটু কপি দাও other side copy. No, copy of this note for the other side. Thanks. আর নেই না? You have it on your iPad. You have it on, just take it on your iPad. If you don't have another printer, it doesn't matter. But I'm sorry, it's very small print. Very small print. আছে তো সেম তো করতে পারবেন তো please take it from me, we have the pictures, but the pictures in some of them are not in the judgment. So only where the picture is in the judgment, we have put it here. Right. We have put it here. But with the others, we have pictures, and I'll show it to your lordship. Get up was the same. Trademark is completely.
If it is not in the judgment, then don't show it. Better not to show.
Very well. No, refer to, but the picture is not in the judgment. Available from other internet sources, but
better not to rely.
Very well. So I'm not relying on those, but where the pictures are in the judgment, we have put it. Yes. So, Apollo tires, your lordship will find, again, different trademarks. The trademark was the, item number 4.
Yes.
Gorbachev, is important in our case. I'll tell your lordship why item 3. It's to do with shape of bottle. Completely different trademarks, paras of the judgment are mentioned. The bottles were similar, and the marks were different. So, injunction granted based on get-up. Then, item 4, Apollo, again, on get-up, different trademarks. Ferrero, is again, I think, it's a chocolate your lordship is familiar with. Ferrero Rocher, everyone is possibly seen, in some form or the other, and hopefully eaten. So, it has a unique shape of a box.
Yes.
And the attempt was made to sell it under a completely different name. And there again, on passing off, because they were using the same kind of wrappers, same size of chocolate and everything, overall impression was the same. So, injunction in that one. Then, the judgments I'll hand up in a compiler. Then, important one is Marico.
Coconut oil.
Picture oh, I see. But again, Marico was interesting because it dealt with the coconut oil. And both used similar bottles, but that is available on some other copies, not from the reported judgments. Right. Then SRMB, again get up, different trademarks.
Yes.
the one with the picture, my lord, item 8, your lordship will find, my lord, that Nivea versus Joy. So, my lord,
In all these cases, injunction was granted.
yes, these are all cases where injunction is granted.
Yet it was infringement.
Then, my lord, your lordship will see, no, my lord, passing off also.
Acha, because
Passing off.
right hand column says court held a prima facie case of deliberate infringement. In bold. 8.
My lord, it was also passing off. my lord.
Anyway, we'll look into the judgments
Yes.
themselves.
Not, this is not only illustrative to show your lordship, these are cases where not trademarks were different. Not item 9, Bacardi, not Bacardi, Brisa and Freeze. Now, not again the same kind of not bottle and everything.
Yes. Look is also deceptive. Definitely.
And then not James and James on the next page.
Oh, acha. Oh, there was James also.
And then not Parachute, Marico.
Yes.
Last one. There, judgment is there.
I'll just show that. And then not the last one, by mistake, not the print has not come. But I'll just give it, not it's there in the judgment. Not this is what the two products look like. And different brand names. I'll just give that page not later. This is there in the judgment itself. So, Lord,
this is the last one.
Yes, Lord.
So you can just give a
Gloria.
photocopy of this page.
Yes.
Just give a photocopy of this
Yes,
page
yes,
and
I'll do that.
give
I'll do
the citation also.
I'll do that.
about
So, I'll do that. Lord, it's
Get a photo.
unreported.
All wrong. Better.
No difficult.
So, Lord, this is
No, L'Oreal. This is
L'Oreal.
This is SCC online is there. So that
Lord, it's
we
actually
consider that
not in the SCC online. It's been taken from the Lord, High Court site, High Court
you have
website.
given a citation.
Lord, apparently this citation is wrong.
Wrong. Then we'll mark it. Others.
बोल भी तो आगे यार.
Very good.
That's why आगे तो भूल छिलो ना.
Very good.
So, Lord, this is the situation now.
Similar cases.
So, Lord, this is the situation, and Lord, as far as judgments are concerned, you guys have all the judgments handy. No, wait. Lord, what I'll do is these judgments I'll put in a separate compilation. Those I'm not using.
You are relying on these judgments. Yes.
I'll put them in a separate compilation.
Right, right.
The judgments which I'm using for not the argument, not I'll put separately. So I'll make two not different
What
compilations.
are the other judgments?
Not the other judgments are to take care of not the arguments she has made. For example, not I'll just indicate and I'll not. First is not. We had said disclaimer and all that infringement. So we are showing the not judgments that a disclaimer is irrelevant in a passing of action.
How many?
No.
Don't multiply too many judgments, Sir Achal. Because these you might
In that
not
case, not what I'll do is the infringement chapter that he's done. I'll not.
yes, the main judgments, the landmark judgments, are one or two by way of example. Because here
In
these
that case,
judgments
let's
you can
even make
understand.
it shorter. Not your lordship will find one of those judgments in that list. No, action Gorbachev.
Gorbachev is on that.
Yes. So, Lord, I'll cite that. I'll reduce the other judgments.
Yes.
And then, Lord, your lordship can mark 3 over there, which I'll place. Not one is Gorbachev, the other is the Colgate. Lord.
Yes.
And the third is that, Lord, that cream, Nivea. Bischoff versus and RHS. Sorry.
Yes.
Yes, but I'll show only 3 from them, Lord, I think.
Thank you.
ছেড়ে দাও না ছেড়ে দাও জজ বলছে না করতে ছেড়ে দাও now do something no now Lord the judgments Lord on this not first common to the trade. Let me get rid of that because the major chunk of my argument hereafter will be showing their judgment and taking care of. But very quickly, Lord, it is not sufficient to show that there are some bottles in the market. He has to give proof of availability, market share, where it is available. It is no defense to say that there are others. He must establish it's common to the trade and show Lord bills and availability in the market. So, Lord, for that, Lord, I'll show your lordship, Lord, a judgment not of this court upheld by the Supreme Court, the outer the Assam roofing. Not 2016, volume 68 PTC 37, and your lordship can note the para 88. I'm just giving that. Yes. তারপর ওই জিবা আর ইয়ে দিও ডিমান্ড ডট sorry,
No difficulty.
But in the meantime, would your lordship make a note of the 3 judgments I rely on this point?
This point is?
No, I'll keep it to 1. Not, let's not. The common to trade. Not, I'll keep it to 1. Not, no point not multiplying the authorities. ছেড়ে দাও। এটা কি দিচ্ছ তোমরা? এটা সুপ্রিম কোর্টটা। এই সুপ্রিম কোর্ট। Will you do something? Do something.
What is the citation? If you can give us the citation.
But 2016.
Yes.
Volume 68 PTC, page 37, para 88. Lord, please let permit us to get a little organized. Lord, in the meantime, what I'll do is their judgment is over there.
Can we get PTC in SEC online? No.
Yes. Yes.
We'll get it.
Yes.
That's sufficient.
Alternate SEC online citation.
Lord, if your lordship wants the SEC online citation, I'll give that
please
also.
do that also. That will be.
Okay.
SEC online can.
2015 SEC online CL 6581.
Right.
But in that, it will be para 89.
Correct.
But let me not cut out the confusion. Let me go to their judgment and take care of it. Lord.
Yes.
এগুলো তোমাদের ব্রিফ এখানে কোথায় চলে Yes. But please take that Jif Lemon's case, which was cited by Mr. Bhattacharya. Not the cause title goes Reckitt and Coleman versus Borden.
Yes.
It's the longest judgment, and not the judgments by at least not 2 long judgments by 2 of the law lords.
Yes.
Does your lordship has the not the WLR version or the RPC version?
RPC.
Oh, hell. So match.
No difficulty.
Anyone has
Maybe
the RPC version. আমার কাছে আমাকে ওরা WLR টা দিল। Could I just have one look at it to see how the paras or the
we
page
think that will be
numbers
better,
Otherwise,
easier for us. One of the paragraphs are identified. If one of the paragraphs are
WhatsApp করে আমায় অন্যটা দিল, ও আমায় WhatsApp করছে। হ্যাঁ ঠিক আছে আমায় ওটা WhatsApp.
If you can identify some
please.
one of the middle paragraphs, then we can find out the rest.
Yes, please just give me one moment.
Yes, absolutely.
Oh, so this starts with the trial court. Trial court বাদ দিয়ে appeal courtটা কোথা থেকে শুরু হচ্ছে? House of Lords টা একবার দেখবে? Now this has not the trial court judgment starting with that. Slade, এই এখান থেকে আসবে। দেখো না, একবার দেখো। Slade তো means trial court এই অবধি। অবধি। ডেট তো ট্রায়াল কোর্টে কিংডম হ্যাঁ এটা আবার কোর্ট অফ আপিল yes now I think yeah got it got this আবার উল্টো অর্ডার আছে this is where it starts ডট ব্রিজ থেকে শুরু হবে কোন পেজ বলো 402 yeah
খুলেই দেবে
yes not in fact not theirs has the trial court the appeal court and then the House of Lords not It starts from here, Lord Bridges.
Yes. Right. Okay, 402.
একটা copy দেবে so I can take them to the relevant pages. It will be easier. But if your lordship is at page 402, there's a para beginning the idea of selling preserved lemon juice in plastic containers designed to look as real as the real thing is such a simple, obvious, and inherently attractive way of marketing the product. It seems to me utterly repugnant to the law's philosophy with respect to commercial monopolies to permit any trader to acquire a de jure monopoly in the container as such. So, my lord, please see where it starts at. It says you can't get a monopoly, but if the effect is a monopoly, it will be. That's how they conclude. So, my lord, it starts with that. And, my lord, I won't trouble your lordship with all of it, but if your lordship, my lord, comes to about line 40.
Yes, 40.
Yet there is a paradox to our quota. Not just above line 40. Not lines beginning with, yet there is a paradox.
Yes,
The trial judge found that a buyer reading the labels proposed to be attached to the appellant's Mark 1, Mark 2, or Mark 3 containers would know at once that they did not contain Jif lemon juice and would not be deceived. So this is a finding of fact by the trial court. Not after that they grant an injunction. But he also enjoined the appellants from selling their product in those containers because he found, to put it shortly, that housewives buying plastic lemons in supermarket do not read labels but assume that whatever they buy must be Jif. The result seems to be to give the respondents a de facto monopoly of the container as such, which is just as effective as a de jure monopoly. A trader selling plastic lemon juice would never be permitted to register a lemon as his trademark. But the respondents have achieved the result indirectly that a container designed to look like a real lemon is to be treated per se as distinctive of their goods. So that's the paradox over here. If I could find a way of avoiding this result, I would. But the difficulty is that the trial judge's finding of fact, however surprising they may seem, are not open to challenge. Given those findings, I am constrained by the reasoning in the speeches of my noble and learned friends, so and so and so and so, to accept the judge's conclusion cannot be faulted in law. So he says the legal test is correct. With undisguised reluctance, I agree with my noble and learned friends that the appeal should be dismissed. Now, my lord, the reasoning comes, my lord, not in the next judgment, but not in the third judgment.
Yes.
And not the later judgments. So, my lord, I won't trouble your lordship with the next 2 pages. It is going into the facts that there were numerous other traders, but no one else had been able to survive the market for long. Now, my lord, the other party's brand name, just do something. Just the first and second. Yes. Lord, if your lordship comes to page 404, I want this part.
We can come to 406, probably the issues. Or...
But just to show a lot, this 404, one line, that's all.
Yes,
yes. Around line 35,
Lord,
their mark was real lemon, and which was a registered mark in the US.
Right.
Real lemon juice is there marketed in plastic squeeze containers of lemon color, but of a shape which more nearly resembles the familiar Mills hand grenade. So this was the Milord fact situation here. Then, Milord, if your lordship comes to page 405, about midway down, against about line 25.
Yes.
Your lordship will find it, not the description, it contains 75 ml of juice which was adorned with yellow leaf-shaped neck label, which was slipped over the nozzle, on which the word real lemon appeared in prominent green print. So name not specifically, not displayed just like KMP, that argument. Then, my lord, interim reliefs granted. Not those are the next 2-3 paragraphs. I won't trouble your lordship. Then, my lord, the summary of the law of passing of, my lord, which I also gave your lordship at page 406.
Yes.
And if your lordship would go about 5 lines down, Lord, against Placitum 20, just below that, the law of passing off can be summarized in one short general proposition: no man can pass off his goods as those of another. More specifically, it may be expressed in terms of elements which the plaintiff in such an action has to prove in order to succeed. There are three in number. But those three tests I gave your lordship, I won't bother your lordship. Goodwill reputation, misrepresentation, and damage. I won't trouble your lordship. Then, my lord, if your lordship comes to Lord, the authorities, Lord, your lordship will find, Lord, parabenius principal findings. Yes. Lord, if your lordship then, Lord, comes to page 408.
Yes.
And, Lord, it's referring to 1988 FSR. And if your lordship then comes, Lord, further down to this as regards shopping habits. Additionally, Tolai, yes. Lord, if your lordship comes to 409.
Yes.
Lord, just after Platinum 25 or line 25, as regards shopping habits, he observed.
Yes.
And he's giving the test here at 512. But the question is not whether the judge himself would be deceived by the plaintiff's get-up. The question is whether, in light of all the admissible evidence, the judge is persuaded that an ordinary average shopper shopping in places in which the article is available for purchase and under the usual conditions under which purchase is likely to be made is likely to be deceived. One is typically dealing with a shopper in a supermarket in something of a hurry, accustomed to selecting between various brands and when there is such a choice, but increasingly having to choose in relation to a wider range of items between the supermarket's own brand and one other brand and no more. Then, my lord, if your lordship then comes to 503, the primary attack, not page 410.
Yes.
So now the argument made is that a careful shopper can never be deceived. And that is not rejected. I'll show your lordship. Not their primary attack, not page 410.
Got it.
Not, their primary attack starts from the judge's initial finding that at least so far as Mark 2 and 3 versions are concerned, there would be no difficulty whatever in a careful shopper who read the appellant's label coming to the conclusion that that which the appellants were offering in their lemon-shaped containers was not the respondent juice. So, not very clear over here. If one reads the label, Lord, it can't be. Then, Lord, the subsidiary argument is the next para, not the first. Is not they say these are the legal consequences which follow from there. There are three which are put. I'll just place that very quickly. The first is that what the respondents are seeking to protect is not a trade goodwill associated with the get-up of the product which they can sell, but the product itself. So this is one argument. And Lord, they split it, make it a little clearer in the last portion of that paragraph. Line starting with what the respondents are seeking to do, it is said, is to separate the article sold from the label under which it is sold and treat the article itself as its own trademark by protecting a claim to monopoly in the mark. So, this is interesting. The argument being, let us say I have something like what it's an interesting argument. In a get-up action, it is this whole get-up I'm not doing. Now, the argument made by the defense is, now what you are doing is, although you are claiming the whole, you are removing this part and you are claiming only the rest. Therefore, you can't get an injunction. You are saying, look, I don't have a right over this. So you're removing this. And in effect, you are getting, this is
trying to reach the product itself.
Correct.
Claiming a...
in this case, the product, of course, being the plastic bottle. They are saying you are trying to get a monopoly on the plastic bottle itself.
So the article, not
you
the
claim
product.
this as a whole. You claim this as a whole, but when it comes to it, doesn't suit you. You remove this. You say, okay, this is not the same. Yet I have a right over this, which you can't get in law. This is really not the argument being made here on different levels. There are not about 9 or 10 different arguments made. I'll show that to your lordship. So this is what they were trying to say here. And then your lordship will find, in the next para, the argument so attractively put by Lord Alexander starts, that would be page.
Yes, got it.
Yes. starts from a principle which is common to both parties, which is neatly expressed in the following short passage from the judgment of Lord Cranworth, not again going back to 1856.
Yes.
I apprehend that the law is perfectly clear that anyone who has adopted a particular mode of designating his particular manufacture has a right to say, not that other person shall not sell exactly the same article, better or worse, or an article looking exactly like it, but they shall not sell it in such a way as to steal, so to call it his trademark and make purchasers believe it is the manufacture to which the trademark was originally applied. Now, Lord, please see this is almost 200 years ago, 175. Lord, so Lord, the law of passing off has its roots not in common law going back not right then. And it's of course evolved a lot, but the language is not very understandable, if I may put it, not as compared to the language in this judgment, which your lordship will find at times very difficult and complex. So it is said, the distinction between the manufactured article itself, which anyone is free to copy in the absence of patent protection, and the special trade insignia used to designate its trade origin, which the courts will protect, is clearly brought out in the speech of Lord Macnaghten in Wheaton, etc., not again 1900s. The article itself, it is submitted, constitute the special insignia of its origin. All that the law will protect are such capricious additions of features as may be adopted. So, my lord, this is the argument made. Then, my lord, if your lordship takes the next para, and your lordship will find again William Edge is quoted, my lord, halfway down that at page 411, line 10. It is clear, at least from the decision of House of Lords in William Edge, that where the article sold is conjoined with an object which, while serving the functional purpose of enabling the article to be more effectively employed, it is of a shape or configuration which has become specifically identified with a particular manufacturer, the latter may be entitled to protection against deceptive use in conjunction with similar devices, etc., fashioned in the same or closely similar way. So, my lord, as far back as 1911, the court is recognizing that there can be a monopoly or a right to protect a shape. This is not to do with shape. Then, my lord, the central question is in the next para. My lord, I find it, however, necessary to pursue the question further. For there is, to my mind, a fallacy in the argument which begins by identifying the contents with the container and is summarized by the central proposition that you cannot claim a monopoly in selling plastic lemons. Well, of course, you cannot anymore. Then you can claim a monopoly in the sale of dimpled bottles. The deception alleged lies not in the sale of plastic lemon or dimpled bottles, but in the sale of lemon juice or whiskey, as the case may be, in containers so fashioned as to suggest that the juice or the whiskey emanates from the source with which the containers of those particular configurations have become associated in the public mind. Now, this is coming from that John Hicks case, not dimple whiskey. Then, Lord, it is no doubt true that the plastic lemon-shaped container serves, as indeed does a bottle of any design, a functional purpose in the sale of lemon juice. Apart from being a container simpliciter, it's a convenient size, it's capable of convenient use by squeezing, and it's so designed as conveniently to suggest the nature of its content without the necessity for further labeling or identification. But those purposes are capable of being and indeed are served by a variety of distinctive containers of configurations other than those of lemon-shaped lemon. But in other words, now what they are saying is any shape of container would have done. But why this? Why do you select this? You have a galaxy of shapes available. So I'm not dealing with that. Neither the appellants nor the respondents are in the business of selling plastic lemons. Both are makers and vendors of lemon juice. And the only question is whether respondents have acquired public reputation for Jif juice by selling it for so many years in containers of a particular shape and design, which on the evidence has become associated with their produce, can legitimately complain on the sale of appellants of a similar produce in containers of similar, though not identical, size and shape of color.
The association which is most important. Association between the product and the shape.
Right. And not that, as your lordship will find, not that association is finally decided not on evidence, that's a different thing. But at the prima facie, not at the ad interim stage, your lordship only has to look at this. Now, Lord, please see the next para. So, I, for my part, would reject the suggestion that the plastic lemon container is an object in itself rather than part of the get-up under which the respondent's produce is sold. So, my lord, shape is only one part of the get-up. Then, my lord, the next limb of the argument, it gets more complex. But it's argued that this is not the end of the matter. For the get-up which is protected is not just plastic lemon-shaped container, but the container plus respondents' labeling, and it's not open to the respondents to argue that though the labels themselves could not fairly regarded, possibly be confused, a part, albeit part, perhaps a dominant part of the get-up, can, as it were, be separated and made the subject matter of protection on its own right. So, the argument is, look, you can't remove this label and try and get the rest. I confess, I do not see why not, given that the respondents established the right to protection of their get-up as a whole. So, this is the get-up as a whole. The question is whether the appellants are, what the appellants are doing constitutes a misrepresentation that the juice is Jif juice, and whether the results from the similarity of their get-up to the whole of the respondents' get-up or to only the most striking part of it is wholly immaterial. It doesn't matter whether you're copying the distinctive part of mine or any other part of it. Why? Because they say, of course, this is critical, whether you take the distinctive part or not. But once it's established as a matter of fact that what they are doing constitutes a misrepresentation which effectively deceives the public into the erroneous belief regarding source of the product.
So, because if you permit them to dissect the different into components, the difficulties, then they'll never have a passing of action.
Correct.
Because everything can be dissected to its components.
One just needs to remove one little part.
You don't have a monopoly on the bottle, don't have a monopoly on the color, on the shape, and then as a whole everything goes.
Correct.
So you cannot dissect it. The whole impression is to be taken. The integrated whole.
Correct. So it's not one single part. It's not the color alone. It's not the shape alone. But you look at it overall and you decide.
Total impression. Yes.
So this is all that there is to it. So, and there are lots of nice parts in it, and it deals with each of them, arguments. Okay. Okay. Then it said, then the next para, again, I won't read all of it. If your lordship comes to line 15 of the next para.
Yes.
The line beginning with the application by a trader to his goods of an accepted trade description or of ordinary English terms may give rise to confusion. It probably will do so where previously another trader was the only person in the market dealing in these goods for a public who knows only of A and will be prone to assume that any goods are similar, any similar goods emanate from A. Now, this is one situation. It looks at all possible situations. I'll just point out what this situation is. In this case, Jif was the only person selling it. So if someone else comes up, people associate it because he had monopoly. This is called the monopoly argument. They don't know of anything else like it. So they automatically assume that. So this is the monopoly argument that is made here. There are three other arguments I'll show you, lordship. What if it's not a monopoly situation? What if it's common to the trade? All of these are examined here. So, now looking all this, considering all this, if your lordship comes to about line 40,
yes,
as far as this argument is concerned, every case depends on its own peculiar facts. For instance, even a purely descriptive term consisting of perfectly ordinary English words may, by a course of dealing over many years, become so associated with a particular trader that it acquires a secondary meaning, such that it may probably be said to be descriptive of the trader's goods and of his goods alone. And this test is coming from 1896. So, even a common word can become distinctive by user over a period of time. Then, if your lordship turns to the page 413,
just do it in that combination. Just do it in that combination, Nike. So Nike has this just do it logo.
Yes.
So in that combination, just do it are ordinary words. But if you use that in a context of selling shoes, then it gets associated. So you cannot use sell a Bata shoe and say, just do it. They'll say, don't do it. The courts will say.
But why go that far? There at least it's a combination of words.
Yes.
Let's look
here
at
it's not, words are not.
No, I'm not even looking at take something which is not normal, everyday English, classic for cigarettes.
Yes.
Now, classic, to say I can claim the word classic, well, it'll take a long time, but it'll build distinctiveness ultimately for cigarettes.
Right.
It's not that one is claiming classic for everything. But in relation to cigarettes, I doubt whether anyone could come.
You cannot use the term cigarette for cigarette. I mean, that cannot be.
No, you can use the term, but you can't claim monopoly on the term.
No, you cannot have a brand name cigarette, probably for cigarettes.
But I can have any brand name I want to. I mean, please don't mind my putting it that
No,
way.
no, we are asking you, yes.
But one can have any brand name, but it will not be registrable, number one. And number two, courts will be loath to enforce it in a passing of action because
in a passing of action, if suppose this was, say, your name is coconut oil,
correct,
then it would be very difficult for you to.
Correct. So the more descriptive a trade name is, the less likely it will get protection. Is the
more generic. I mean, anyway, let us not go
even
into
that over a period
that
of
is not applicable here. Yes, no.
So now is the next argument over here. I'm not starting at about line 5.
This page 413.
413.
Right.
I'm just above that.
Yes.
Sentence beginning with
because.
But just before that, I'll tell you, Lordship, what was before that. The only people selling Jif Lemon were them. Now, because there had in fact been a monopoly of the sale of this particular article, the public is led to make the erroneous assumption that a similar article brought to the market for the first time must emanate from the same sort. This is referred to as the monopoly assumption. Now, this is said to be not a mistake being made by the seller because he's making an incorrect assumption. Now, that is dealt with. The next para, the difficulty about this argument is that it starts by assuming that the only basis on which it can succeed, that is to say that the selling device which the appellants wish to adopt is ordinary and generally available, or is expressed in some of the cases as common to the trade. Now, not common to the trade argument. And Painton and Snelling, again, one of the classic cases, 1899. In one sense, the monopoly assumption is the basis of every passing of action. The deceit practiced on the public when one trader adopts a get-up associated with another succeeds only because the latter has previously been the only trader using the particular get-up. But the so-called monopoly assumption demonstrates nothing in itself. As a defense in a passing of claim, it can succeed only if that which is claimed by the plaintiff as distinctive of his goods and his goods alone consists of something either so ordinary or in such common use that it would be unreasonable that he should claim it as applicable solely to his goods. Now, he'll have to say, this is something absolutely ordinary, there's nothing new about mine, or it is common use. As for instance, where it consists simply of the description of the goods sold. So, for example, it was the shape of a coconut. Here, the mere fact that he was previously been the only trader dealing in goods of the type and so described may lead members of the public to believe that all such goods must emanate from him simply because they know of no other. To succeed in such a case, he must demonstrate more than simply the sole use of the descriptive term. He must demonstrate that he had become so closely associated with his goods so as to acquire secondary meaning, and not simply of goods of that description, but specifically of goods of which he and he alone is the source. So this is where it is a descriptive brand name. If it's descriptive, then you must show that you had full and only person doing it. Then, my lord, if your lordship comes to another of the tests at page 414. No. There is. There is. Yes, this one. Not para at page 414, starting with there is when one analyzes it. But I won't trouble your lordship with all of it. If your lordship comes to, I suspect, but about line 30. Line 30.
I suspect.
I suspect. I suspect that the only reason why it is suggested that a similar association in this case ought to occasion surprise is that the container is indicative of the nature of the contents. There is, however, no reason why it should not also come to be treated as indicative also of the source of the contents. In the end, the question comes down not to whether the respondents are entitled to monopoly in the sale of lemon juice in natural size lemon containers, but whether the appellant in deliberately adopting out of all the many possible shapes of container, a container having the most immediately striking feature of the respondents' get-up, have taken sufficient steps to distinguish their product from that of the respondents.
And also, this is not an action, monopoly action, in the sense that this is not a unfair trade practice action.
No.
This is on a different footing altogether.
Absolutely.
So even if you suppose you are having a monopoly and you are otherwise liable to be hauled up under some other act. Suppose that even that is so, then also I cannot pass in passing off. You may succeed.
Let me put it this way: any injunction your lordship not passes here is not a restraint on him selling coconut oil, whether hair or edible. It's not an injunction on that. All it says is, look, you cannot use packaging or get up which is similar to his, because it will mislead the consumer.
Whether you have monopoly or not, that is not even required to be looked into actually.
But no, that was the argument made. He's claiming a monopoly on the container
bottle.
without. So, Lord, then, Lord, again, Roma is not quoted. Lord, 508 page 414. So that portion I was reading from, Lord, as Romaji observed in Painton and Snelling, when one person has used certain leading features, though common to the trade, if another person is going to put goods on the market having the same leading features, he should take extra care by the distinguishing features he is going to put in his goods to see that the goods can be really distinguished. I stress the words, to see that goods can be really distinguished, for much has been made of the fact found by the judge, and indeed really observable by a lordship, that a careful shopper who read the labels attached respectively to the appellant and the respondent's product would have no difficulty in distinguishing them. Lord Alexander has submitted forcefully that the labels employed in connection with Mark 2 and 3 are so essentially different that, fairly regarded, they are sufficient to avoid any possibility of confusion. Lord, please make a mental note of these lines, because they go on to say, look, all three are restrained.
All three are restrained?
Restrained on all three.
Oh, after
even
this.
though, Lord, even though labels are different and all three look different. Not that they are different from mine, but Mark 1 is different from 2, which is different from 3. Now, in that connection, Lord, take my learned friend's case. He wants to make a modification. That is Mark 2. And your lordship will not find a comment over here. It's not the business of either the plaintiff or the court to decide whether he should get it or not.
No, exactly. That will be a dynamic injunction sort of scenario.
Correct. So, Lord, then, Lord, if your lordship, I'll just make it a little shorter. There's a quotation from Schweppes and Gibbons. Lord, if we skip that and come to the next portion, Lord, but of course,
Yes.
Lord, that would be line 25. But of course, statements such as this were made in the context of the particular facts under consideration. They cannot be treated as establishing a principle of law that they must always be assumed a literate and careful customer. Lord, there was another judgment which dealt with that. The essence,
depending on the product, actually. If it's
correct,
a book, then
product, where it is sold, who the consumer is, all of that. The essence of action for passing off is deceit practiced on the public, and it can be no answer in such a case where it is demonstrable that the public has been or will be deceived, that they would not have been if they had been more careful. So it's no defense to say, look, the consumer should look at, compare both the products side by side. Customers have to be taken as they are found. As Lord Blackburn observed in Johnston, now this was in another interesting case to do with export of goods to India.
Oh.
Lord, in 1882. Now, Lord, what it's quoting from there, if the plaintiffs had proved that the purchaser had actually been deceived by the use of the mark B, and the defendants, after being told that this had been had persisted in using mark B, the plaintiff would surely have been entitled to an injunction to prevent the continued use of B. Now let's see the next part. And it could be no answer that the purchasers so deceived were incautious. The loss to the plaintiffs of custom of an incautious purchaser is as great a damage as the loss to that of a cautious one. And Lord, this is coming, Lord, in 1882. But the facts here are very interesting. Lord, someone was selling, Lord, yarn in India under a mark called Ganpati. There was someone else who came in later, but without using the words Ganpati, he had, Lord, the picture of a Hathi. And they looked completely different. Now, in Gujarati, Lord, these goods had come to be known as Bhe Hathi, which meant one elephant. So the question was whether there's passing off. And Lord, the lords, Lord, deal with how natives would treat it. That's how we were called, Lord, in those days. So then, my Lord, your Lordship will see Like your lordship just observed, the next para, your lordship will find leather cloth company versus American leather cloth. Now, there, the test becomes descriptive mark, leather cloth. In that context, some observations are made, but if your lordship then goes to in that para itself, line 50, just after line 50.
Yes, yes.
It is, however, to be asked in every case against the background of the type of market in which the goods are sold, the manner in which they are sold, and the habits and characteristics of purchaser in the market. The law of passing off does not rest solely upon the deceit of those whom it is difficult to deceive. So it doesn't depend on a clever consumer. And then, side to side comparison is not the test, it goes on to say. And, that line that, court or us can't decide, what should be the correct thing he should do to distinguish. That your lordship will find at line 15.
Yes.
It inevitably follows from those findings that the appellants have not, in fact, sufficiently and effectively distinguished their goods from those of the respondent. And it is not for the respondents, who are the plaintiffs, or for the court to suggest what more they should do, although some suggestions were in fact made.
Exactly.
And then, if your lordship then goes to the next para around line 30, I do not accept at all that this is so, but in any event, the principle that no man is entitled to steal another's trade by deceit is one of at least equal importance. The facts, as found here, establish that unless injunction is continued, that is what the appellants will be doing, and it's not necessary for them to do so in order to establish their own competing business. For there is nothing in the nature of the product sold which inherently requires it to be sold in that particular formats which the appellants have chosen to adopt. I would dismiss the appeal. Then, your lordship find the next law lord also agrees. Third law lord agrees, and then he goes into a detailed judgment, many of which are the ones involved over here. So, they're nice passages. Yes, page 418, if your lordship comes to against line 15. Para beginning with, however, although common law will protect goodwill against misrepresentation by recognizing a monopoly in a particular get-up. So, get-up protectable, very much. It will not recognize a monopoly in the article itself. So, he can't be prevented from selling these empty bottles or manufacturing it. Thus, A can compete with B by copying his goods, provided he does not do so in such a way as to suggest his goods are those of B. Lawful competition will not be restricted by common law. So, this is a well-accepted proposition. Then, he also, deals with the arguments. If your lordship comes to the heading at 420, arguments in this house. And, there are a number of arguments made, but they are summarized, at page 420 at about line 15.
All right.
So, Lord Alexander argued, 3 points. There could be no monopoly in goods or containers. The monopoly assumption whereby customers assumed without regarding labels or other indica that all plastic lemons must be Jif lemons invalidated their evidence. And 3, that it's impossible to acquire secondary meaning in the shape of the plastic lemon. Now, this was a very strong argument made by a learned friend. And these are all dealt with. So, if your lordship sees one, the first argument is dealt with around line 30. And the argument is, look, even without getting registration, you are getting protection. And, your lordship will find Coca-Cola's case was relied on for that purpose. That's quoted over there. So, your lordship will find this is the argument that the article could not have been protected under the Trademark Act. That's dealt with later, but I think it's important your lordship reads this. A rival manufacturer must be free to sell any container, article, or similar shape, provided the container or article is labeled or packaged in a manner which avoids confusion as to the origin of the goods in the container or origin. The respondent, Register of Trademarks, has always taken the view that the function of the trademark legislation is to protect marks, but not the article which is marked. I agree. So, my lord, Coca-Cola said you can't have the shape of the bottle registered under the Trademark Act. My lord, that was in 1986. The act has since changed, but we are on an action for passing of. So this was in the context of whether it is registrable or not. Then, let's see what it says. In view of the different rights which are protected by common law in a passing of action and by statute in an action under the Trademarks Act, I do not think Lord Templeman's observation assists the appellants. So the fact that it's not registrable has no bearing in a passing of action. So that's also taken care of. Not one more argument gone. It was further argued that since a plastic lemon was a common shape, which it was open to anyone in the trade to use, no monopoly therein could be acquired for the purpose of protection of goodwill. This argument, if successful, would exclude from the get-up of the respondents lemon juice the shape and the size of lemon, leaving only for consideration the embossed letters thereon and the label attached thereto. So now, my lord, that is considered. My lord, all these judgments are, my lord, quoted, and my lord, they try and take out each element, and my lord, finally the conclusion. কত page? Lord, if your lordship comes to 421 after, my lord, analyzing the law, Lord, the last para, Lord, starting with my lords, and if your lordship goes to the 5th line after about line 46, 47, Lord, after, my lord, referring to, my lord, Snelling's case and, my lord, Williams,
As far
is that no one can claim a monopoly in the use of a container which is in common use. As Farewell said in J.B. Williams, after referring to the difficulty in acquiring a right to words which were merely descriptive of the article, it is even more difficult to acquire monopoly in mere wrappers or boxes which have been used for years in trade and which are common to the trade. The rationale of this conclusion is not difficult to find. The common law weans away from monopoly rights and is unwilling to support the acquisition by individuals of such rights in commonplace articles. Thus, a trader can only claim protection for such capricious additions to a commonly used container as distinguish his use of that container from use of other traders. He may prevent a rival trader from copying the label of his boxes, or perhaps a distinctive combination of colors on his tins, but he can't stop him from using ordinary boxes or tins simply because they happen to be the same shape and size. So, my lord, if I have something not completely common, not a box-shaped box, I can't claim monopoly in it. I may claim monopoly on the sticker or the label, but the moment my box is different from a normal box, but the moment it has a capricious addition to the commonly used container, that's good enough to get the protection. This is entirely logical, since where a container of a common shape and size is used by different traders, it's not the shape and size of the container which identifies the producer of a particular trader to the public, but the capricious additions to that container by way of distinctive labeling or combination of color or graphic design. It was to such a situation that the judge of the Court of Appeal in Painton and Williams were addressing themselves when they used common to the trade. Now, please see what they say. To extend these words to cover a case where one trader alone evolves and uses a container of a particular distinctive unusual shape, albeit other traders have the capability of achieving a similar result, would be both illegitimate and contrary to the principles whereby those cases are decided. In my view, common to the trade in a passing of action means in common use in the trade, from which it follows that plastic lemons cannot be disregarded as part of the get-up in this appeal. And then, Lord, if your lordship sees the monopoly assumption is also dealt with, and if your lordship sees para 3 of that, Lord, which would be line 35 or so.
Yes.
A trader must differentiate his get-up from that of trader B to avoid deception. If B's goods have been in the market for a relatively short time with a get-up which is not particularly distinctive, steps required to differentiate may not be very substantial. If, on the other hand, those goods have been in the market for a long time with a particularly distinctive get-up, then A, seeking to market his goods with a similar get-up, will require to take far more drastic steps to inform the public that his goods are not that of B, since the public, having long been used to such a get-up as identifying the goods of B, are likely to be less mindful of the differences in detail. They are all similar.
Same thing has been discussed in different.
Yes. But because different layers of argument.
Layers of argument.
Now, my lord, if your lordship sees another portion at page 423.
Yes.
Now, Painton and Snelling had a lot of things, and those are being dealt with. One of them is not at line 45.
45 years.
But in such a situation, if the label plays only an ancillary part in the get-up, I'm not persuaded that there is any principle of law which requires the evidence of consumer witnesses, who no longer find it necessary to examine the label should be disregarded. Then, my lord, secondary meaning, whether it can get secondary meaning or not. My lord, next page, para 3, that is dealt with. And my lord, they say that lemon can't ever get secondary meaning. That's dealt with. The conclusion is on the next page at page 425.
Yes.
So, my lord, here, my lord, dealing with the argument, the word lemon you can't get, therefore you can't get the shape. And my lord, your lordship will find the para at, my lord, beginning at after line 5. In the second place, I do not consider that it is legitimate to equiparate a plastic lemon of natural shape and size, which is unique in the market, to a word in ordinary use. Indeed, I can see no reason why a trader should not obtain protection for a get-up whose shape and color ingenuously alluded to its contents, but not for a phrase containing ordinary words which describe them. So you can't have the word, but you may still have the container. Then, my lord, the next para, appellants advanced a subsidiary argument to the effect that the article here was a plastic lemon containing lemon juice, and the get-up which forms part of the article can't be protected. The common law, it was said, will not recognize a monopoly in the overall shape of an article of commerce. In this context, Court of Appeal, my lord, Dolly Blue case, etc. Even if the plastic lemon were part of the article, I do not consider the proposition sound. In Dolly Blue case, the plaintiffs got up blues or tints in a simply unmarked bag with a stick in them, which performed a function utility when when the bags were dipped in water. The defendants copied the plastic bags and sticks, but labeled the bags with their own name. The House held that upon the facts of the case, the defendants had taken insufficient steps to distinguish the goods from those of the plaintiff. And Lord, it goes on in that vein. And that quotation, if your lordship takes, Lord, the last 6 lines of the quotation after line 41 or so, but when it is admitted that the defendants have copied the appearance and arrangement of the plaintiff's goods and distinguished theirs only by a label, not which is the case here, Shalimar KMP, and when it is perfectly possible to distinguish goods which contain similar elements of utility in many other ways, so that there should be no reasonable probability of mistake, it seems to me that the label alone in the particular circumstances is not, for the reasons that I have given.
The onus is on the subsequent user to make it distinctive.
Absolutely. Absolutely. So, I'm not simply having a separate label, although the getup is the same, is not sufficient. Not,
Yes. We'll just come back in 10 minutes. Yes.
Yes, back. This statement,
Let Mr. Bachawat complete today because I don't think he's a member of the association. I am. I have to follow the resolution. Kindly keeps it.
It's your choice, Mr. Bhattacharya, to follow the resolution or not. But don't mention a matter tomorrow and say include it in the list and then say we have a resolution, we'll stop midway. Very sorry. It's your choice. We'll close arguments. This cannot go on and on and on.
It's not
No, you can't have an entitlement on that. You are submitting as if it's an entitlement. No, he can continue. I will leave. In the midst of an argument, if you leave, it's your choice. We'll record the reason for why you are leaving and we'll record your name and we'll say that this is the reason he has left and we'll close arguments. There's a limit to everything, Mr. Bhattacharya. You cannot have an entitlement on that. No, the tenor of your submission is not a submission. You say Mr. Bachawat can continue. He's not a member of the bar. I'll leave. Leave. Your own choice. We'll record the reasons why you are closing arguments. He's in the midst of an argument. What sort of submission is this? And you are wearing a senior gown now. Unimaginable. It's your choice. Well, who told you to come in? We did not invite you. Your choice to leave or to stay. We don't have a say on that. It's your choice, independent choice. Our choice, we have a pen, we can write orders.
Of course, Your Lordship.
But please don't have that tone that he is not a member of the bar, he can leave. So why are you threatening him? This is not a proper way to this is not a proper way to submit, Mr. Bhattacharya. He's not a member of the bar, he can continue. His choice, he definitely can continue. I am a special member of the bar still, and I am continuing. I am a special member of the bar association still, I pay my money. But I am continuing. It's my choice to continue, it's your choice. But we will record the reasons.
Then I will continue if Your Lordship says.
We are not compelling you. It's your choice to leave.
My Lord, I will continue.
It's absolutely your choice to leave midway in a matter.
I will continue. Let him finish.
Yes, Mr. Bachawat, please continue.
Lord, I just read out a portion at
yes
at 425.
Yes.
Lord, if your Lordship turns the page,
yes,
so they consider another judgment. And Lord, a para beginning with in this statement, starting at about line 5.
Yes, line 5.
In this statement, the judge was clearly recognizing that the shape and configuration of the article could be protected against deception. In my view, these two cases are merely examples of the general principle that no man can sell his goods under the pretense that they are goods of another. This principle applies as well to goods themselves as to their get-up. So, Lord, principle of get-up, Lord, given full recognition, and Lord, the rest is not dismissing the appeals, appeal cross appeal, dismiss with cause. Lord, I won't trouble your Lordship.
So the association between the product and the get-up and the deception, these are the key factors.
Well, I would summarize this way.
Yes, yes.
But get-up includes many things. It includes shape,
yes.
It includes color combination, label, words, etc. Now, none of it is to be taken individually or on its own. It's the combination of all of it which gives the get-up. And if your Lordship feels that as a combination, my get-up is being copied and not individual features. Your Lordship doesn't take any one individual feature because that argument was also made here.
Yes, that is what we are saying. Yes. You cannot take out individual components, then you will never have a passing of action.
Correct. You have to look at it as a whole. And if as a whole, Lord, your Lordship feels that there is a possibility of deception because that's the test. Actual deception, not necessary. If there is possibility of deception, that's the end of the matter. And this is without even looking at other factors, not which are involved in our case, dishonesty, etc., which I'll deal with in a minute.
Yes.
Not even without looking at it, possibility of deception, end of the matter. So the arguments, principal arguments, my learned friends say that, look, you can't protect shape.
Yes.
You can't protect color. I'm not claiming on monopoly of an individual feature. And my lord, this copy is dishonest for multiple factors. Number one, my lord, he's admittedly the later user, so he comes in knowing I've been around. What steps did he take to distinguish? Nothing. Two, no explanation given about why he chose this particular getup. He could have chosen anything else. And the law says if you choose not to give a, or if you don't give a suitable explanation, then the law presumes dishonesty. That's the Supreme Court. I'll place that judgment. So, my lord, even if I can't prove dishonesty, it's presumed because of lack of explanation. Third, my lord, I show his conduct, that he is a habitual copier. I've already showed your lordship those annexures. He has closely tailed not every other manufacturer of coconut oil.
So, Bachat, were those materials before the launching?
Yes, yes. Shilo, my lord, I'll check.
Let's check up.
No. Lord, this is in my opposition to his application.
Yeah.
Yes, he filed an application wanting to change. In my opposition to that application, they are
That was in the
appeal.
in this appeal.
In this appeal, he has filed an application. It's in my opposition. So he is a habitual copier. Fourth, please deal with it. My lord, the false statements he has made that, look, this is hair oil, that's edible oil, there can be no confusion, which is turned out to be completely falsified by his accounts, which say 99.5% of his products are edible oil. And he has not showed your lordship, despite a question which fell from your lordship, well, if you are selling hair oil in a different container, where is that container? Or if you are selling edible oil in some other container, where's my lord? I have not put the wrong question. If you are selling edible oil in a different container, where is it? Because according to him, the containers which he has presently are only hair oil. So how is his 99% oil being sold? Obviously, it's the same. So, my lord,
chosen the hair oil ones to place before us.
No, he is selling not this oil only. So, my lord, these are amongst the few things which indicate dishonesty over here. Not knowledge, dishonesty, and then the attempt to try and change the label and get a snatch order on an application saying, look, I change it by showing immaterial changes without even not showing the bottle. Please remember, it's an action on get up. In his application, he does not show the get up. He only says, I'm changing my label. The application.
No, we remember. We remember clearly the
He
picture.
did not show the picture of the bottle.
No, did not.
No bottle, only the label.
In two places of that application, he has given the copies of the labels.
Correct.
The prayer portion and the
correct. So, my lord, therefore, conduct, lord, is also incorrect. Lastly, my learned friend did not show your lordship not what is the fault in the order itself. He has to show perversity.
So, intercourt appeal and all those things coming.
But no perversity has been shown, nothing has been shown. Lord, in fact, no attempt was made to actually place the order either. And Lord, may I just
place
show
the order on the first day?
very well. Then
When
I
we were online.
Yes. Okay. Lord,
It was
my learned friend says he has placed it. Yes. Now, CP target 0. Not on dishonesty, if I may just place the judgment. No, copy though.
Only a few important judgments, Mr.
Yes, not I am minimizing, not absolutely minimizing.
And to be fair, we also requested Mr. Bhattacharya to do that, and he has not multiplied too many judgments.
No, Lord, I will. But so far,
yes,
I have not cited anything. I have only relied on his judgment. Only in his judgment.
True.
Not to say that, look, monopoly on
judgments you had cited, Syed Mohideen and this Kabushiki Kaisha. That
yes,
was
not to say that in past, not this not restricted to class argument is now gone, and it's not applicable in a passing of action in any case. Amlet, other copy. Now, The explanation to question. Yes, para 35, not if your lordship would come to, I won't trouble your lordship, not it's got many interesting bits, not passing off in the context of not the internet and all of that. This was actually the first one, not to do with domain names.
Oh, Satyam.
Satyam. And if your lordship comes to para 35, the High Court's finding that no prejudice would be caused to the appellant because it had another domain name was a constraint which might have been relevant if this were a case of bona fide concurrent use and where the right to use was co-equal. Find that para where he's given that explanation. The doubtful explanation given by the respondent for the choice of the word SIFI coupled with the reputation of the appellant can rationally lead us to the conclusion that the respondents are seeking to cash in on the appellant's reputation as a provider in view of our findings, albeit prima facie on the dishonest adoption of the trade name by the respondent, the investments made by the appellant in connection with the trade name, and the public association of trade name SIFI, the appellant is entitled to relief it claims. So, dishonest adoption. Now, why?
Satyam was the acronym was SIFI or something like that.
Yes. Now I'll just show you a lot.
That paragraph also, yes.
They tried to say that not Satyam was SIFY.
Yes.
These people use SIFFY.
Oh.
So they tried to explain why SIFFY. It was the first letter of the name of each of the people involved in the business. And that was not believed. Not that your lordship will find that para. No. Please give me a moment. I'll just find that for your lordship. আমার দাগ দেওয়াটা আমি বার করছি না দাঁড়াও দেখছি তুমি ওটা দেখো আমি এটা দেখছি But please come to para 30. Yes.
Yes.
According to the respondent, the word SIFInet, which features both as its corporate name and its domain names, were derived from a combination of the first letter of the 5 promoters of the respondent, combination of the first of the respondent, namely Salim, Ibrahim, Fazal, Farid, and Yusuf, and the word net implies business. Stand taken by the respondent is that it was not aware of the appellant's trade name and trading style SIFI. This is not credible for several reasons. In answer to the legal notice issued by the appellant, no such case was made out. The refusal of the respondent to comply with the demand notice issued by the appellant was based only on alleged difference between SIFI and SIFInet and a claimed difference in the field of operation. The High Court has also not found that the respondent was unaware or ignorant of the use of SIFI by the appellant. Now, he also does not say he was not aware of me or my get-up. Nowhere does he say this. The reason put forward by the respondent for the choice of SIFI as part of the corporate and domain names, apart from the second written statement filed by the respondent before the trial court, where it had been said that the respondent company was the brainchild of its director, Baba Salim, and the word SIFI was invented from the first letters of the 5 persons involved in setting up the company. But only 4 names were given. The 5th name given was in a counter affidavit filed in this court. In the first written statement and the first answer to the interlocutory application verified by Baba Salim as director, no such case has been put forward. Now, regarding the choice of the name SIFI was made out. In fact, the original written statement, the respondent had stated that though its domain name was got registered in the name of one Mr. C.V. Kumar, now the said person does not have any connection with the defendant since the second defendant is no longer in existence as a partner. Thus, it appears the respondent may originally have been a firm because C.V. Kumar, in whose name SIFInet was registered, has been described as a partner. Even if this inference is incorrect and the respondent is always a company, we are still not convinced as to the reasons why the name SIFI was taken by the respondent. If the originators of the companies were 5 persons, Salim, etc., why the domain name of the respondent already registered SIFInet in the name of C.V. Kumar? Furthermore, the list of names provided by the respondent to support its case that SIFI was an original acronym was based on the initial letters of the company's promoters seems unsupported by any evidence, no document apart from a bare assertion that the 5 individuals had a special corrective role, etc.
Probably either Farid or Fazal was roped in later on.
Maybe they were not there at all. It was someone else. Not because there's nothing to show. Any of these 5 people were directors, promoters.
Farid, please come. We'll add an F to her.
Yeah.
Yes.
So, once the explanation is disbelieved or there is no explanation, dishonesty is presumed. And they do not say they are not aware of my business.
Why exactly are you citing this? I mean, for which proposition?
presumed dishonesty, where there is no explanation for adoption. No explanation for adoption given. When? Not he knows of my business. He knows of my product. He does not say he doesn't know of my product. He's come in later. Why did you adopt it? What is so special and what did charm you to take this get-up? He could have given an explanation.
Yes.
Now, in addition to this, not no, that's all part of that compilation of the Nadilo Chole, I think. One second, no, let me see if I can reduce it all down. Tonita দেখানো হয়ে গেছে. Broadcast is taken care of in that judgment. No? It's part of it. I'm showing it from this. Excellent. Don't. কোনটার জন্য ওটা? Disclaimer তো দরকার হচ্ছে না. He said so already. ওটা দেখিয়ে দেবে সেলিং ক্লোজারটা দেখাবে নাকি? আচ্ছা, you show those 3 judgments on, but court will not give advance. And have you arranged all those 1, 2, 3, 4?
He's not a portfolio holder of the bar.
Otherwise,
Bar association examination. The serious exception.
But I'm just trying to knock out not all the other judgments.
Yes.
Apart from those not mentioned in that chart. Not gives me one moment. There's
Chart a copy of handed over to them.
Yes. But on the change of label aspect, not he wants to change his label. On that, there are 2 judgments which I'll show you, Lordship, 1 line each from one English and a Bombay judgment. এটা আগে দাও।
কোনো রিকোয়েস্ট নেই, রুডলি বলা আছে রেজলিউশন দেখবে, রুডলি বলা আছে যে উই শ্যাল ডেজিস্ট ফ্রম ডুইং ওয়ার্ক। একটা রিকোয়েস্ট নেই যে প্লিজ ডোন্ট ইন এপিসোড, নট আ সিঙ্গেল রিকোয়েস্ট, নোবডি মেনশন বিকজ দলপতি কেউ ইনসাইড হিয়ারিং সবটা সীমা। Yes, this is on.
But this is on. Not the court will not decide whether a particular change label is to be done or not.
Oh, that.
Please come to page 152. That your Lordship has already seen in the House of Lords.
House of Lords, yes.
Saying that, look, it's neither for the party nor for the court to do it.
Yes.
This is not, these lines are interesting. So if your Lordship just takes this one, page 152, not about line 40.
Yes.
It has been said many times that it is no part of the function of the court to examine imaginary cases of what the defendant could do or could not under this form of injunction. The best guide, if he is honest man in his own conscience, and it is certainly not the business of this court to give him instructions or hints as to how near the wind he can sail.
Quite correct, actually.
Honest men do not attempt to sail near the wind.
Yes.
So, this is a line I show in this connection, and there's a small Bombay High Court note which I'll show your Lordship also. But what label is to be chosen or not is again not for the court to give. Change of label. I'll give you the reference. 2003 SCC online Bombay 718. Umar Boy court is Umar Boy to the But actually, the problem is the juniors have all worked so hard. They've pulled out 30, 40 judgments.
That is it.
So it's becoming a little difficult for them to murder.
Right.
They have a judgment down at the upper 27, 28. আরেকটা দাও other side এর জন্য। Yeah. Go on. Please come to para 27 straightway. On behalf of the appellant, I'm sorry.
Para 27?
Yes.
Yes. That is 26 in our copy, on behalf of the appellant.
I have a different copy. But on behalf of the appellant, it has been urged that the appellant is willing to modify the color scheme and get up, that the court may accordingly permit the appellant to use the mark Postiano together with such modifications to this color scheme and get up, which may be approved by the court. Counsel for the appellant submitted the appellant would be willing to carry out such modification as the court may suggest. This submission cannot be accepted. We have arrived at the finding that the adoption of the mark Postiano by the appellant was not honest, but was a transparent attempt to trade in the goodwill and reputation of the firm. The conduct of the appellant divulges a lack of bona fides. Application for registration of the mark maskman was submitted by the appellant within the week of the order passed on 31st July, recording the agreement between partners that they will not carry on any business on the basis of the trademark. Thereafter, no sooner was a further order passed on 8th November that an application
Right layman has been quoted, and
yes,
an assumption of good faith which underlies cannot be attributed to this.
Correct. And then not that, not the English authority, not in right layman is also quoted, not, and not the submission is rejected.
Yes.
So not.
So on this point, you need not cite any other judgment. I mean, this modification.
But there is one factual thing which I should also place. Not after all this huge argument that one cannot claim a monopoly in shape, this, that, and the other. The strange thing is that he himself has applied for the shape of the bottle.
How is it material, Mr. Bachar?
He says one cannot claim a monopoly on a shape because it is common to the trade.
He has applied.
If it's common to the trade, how do you claim a monopoly yourself?
So, very well.
But his application for registration, I'll just point it out. I'll give it to your lordship, the page number. एक बार जिस बात को ना Sam looking to খুঁজে পেলে তারপর দাও দাও ওটা আমায় দাও যা যেটা আগে পাও let's finish it quickly দাঁড়া আমার ডাক দেয়া আছে এখন
It's in the paper book.
দাও ওটা not 744 ডেটটা তাহলে দাও That's 744. Now, this is dated, it's important. 21st of April 2023 is the date of his application. This is after my notice to him. Further dishonesty. After my notice to him. And if your lordship sees over there, trademark type, shape of goods. He's applied for the shape. And the next page is not this very bottle, which is mine.
Yes.
And not disclosed by them, we have disclosed it in a reply. But I'm very sorry, but there's one other judgment I should actually, it's the wrong one. This one is the one we wanted. This is called distance data. Naam to beach.
Yes, sir.
আচ্ছা, ওটা Bombay. KLF Nirmal. Relevant parrot, I know, but it's put in nicer words. Other side category. Just take it out. Para 81, again, quotes Umar Bhai. I know, new young, recruit to the bench. I find much merit in this submission, para 81, of the plaintiff that the defendant cannot seek a seal of approval from this court to use a revised packaging which continues to be in violation of
Para 81.
81, I'm sorry.
I find much merit.
Yes.
Yes.
In the submission of the plaintiff that the defendant cannot seek a seal of approval from this court to use a revised packaging which continues to be in violation of the plaintiff, this court in Umar Bhai has held, and quotes it. And then the best guide, if he's an honest man, is his own conscience, it's certainly not the business of the court to give him instruction or hints as to how near he can sail. Honest men do not attempt to sail near the wind. Then further, I find merit in the submission of the plaintiff that under the safe distance rule, once a party infringes on another's trademark or trade dress, confusion sowed is not magically remedied by de minimis fixes. So that is what he was trying. That is fully dealt with now, and not as to Assam roofing to the Paratech cooperative bar করতে সময় লাগবে আমি বার করছি কনফিউশন হয়ে গেছে Please take para 89, and this was not approved by the Supreme Court. Para 89. But I don't need to go after every other person in the market, not just to meet that common to the trade. It is a settled position that use of a registered mark or essential features thereof by others is not a defense available to the defendant in an action for infringement and passing off. Merely because the plaintiff has chosen to sue one infringer first and has not at such time sued others for infringement is also no defense in an action for infringement and passing off. And it's well settled law that it's the prerogative of the plaintiff registered proprietor, owner of the mark, whom to sue so as to protect his rights. Further, it is essential for the defendant to demonstrate substantial and continuous use over a period of time of the mark by others, failing which no defense of common to law publicized juris can be set up. So he has to, it's not enough to not show one bottle and wave it around in court. And for this, corn products, and various judgments are given in support of this. And if your lordship turns the page, the defendant failed to prove that the number of entities over India or internationally that are using the word marine, or that such use is substantial or continuous over a period of time, as submitted by the plaintiff. Let aside proof, there is not even a pleading to the effect. 4 invoices produced by the defendant are insufficient and deserve to be disregarded. Here there is no invoice, none. They do not satisfy the test of extensive, actual and continuous use in the market, not by others, The defendant has tried to take advantage of the reputation of the plaintiff, not only by using the mark marine plus, but also by use of the copied impugning label, and hence cannot be allowed to stop. And in this case, there were different products. One was cement, the other was asbestos sheets.
Oh.
So
then also this was.
Yes. So in his case, taking his case to be not even believable, edible oil and hair oil, not again same product, really speaking, but even if they are different products, the court. And this is approved in the Supreme Court, I
do admit. It was reversed in the division bench.
And
the
then
division bench was set aside by Justice Gogoi.
I think that give me those judgments in your chart. Give me the
Approved by Supreme Court means SLP was dismissed.
No, SLP approved Justice
on merits.
Justice Sense, yes. It was converted into a civil appeal and set aside division.
So merger.
Yes.
1, 2, 3, 4 করে বললাম না, arrange করে দিয়ে দাও, এটা সমিতি আছে।
Don't cite all the 34.
No, since I've given the chart, I'm just giving the judgments. I'm not citing. I'm not citing because the chart is there to show, not because this question fell from your lordships, different name but similar get-up. What happens? So, we have prepared it if your lordship.
No, you can.
Whatever you have.
You have given the chart so we can pretend we have gone through the judgment.
No. We have all the judgments here. Just to show, we've
So
given
we
the
can
para
pretend we have
numbers.
gone through the judgment. That's right.
Right.
Anyway.
Then in that case, may I do something? Action though, chart though. But the judgments referred to here, all the judgments are here loose. We'll just bind them together and give it to your lordship. Not in particular, out of this, I'll tell your lordship, there's two judgments which your lordship may want to see. One is item number 3, Gorbachev.
1, 3, and 8, you said you'd be.
Yes.
Colgate is 1.
Yes.
3 is Gorbachev.
Yes.
And this 8 is.
Yes, Nivea.
Yes, Nivea is 1.
Yes. So these 3 in particular, your lordship may want to.
We have marked, yes.
I am not placing it unnecessarily, no point killing.
No, the flux has been.
Yes, it's been
written
put
here,
there.
yes.
Hey, 5টা 10টা বলো না চার্টের সঙ্গে just comparing করে দিয়ে দাও. Those are my submissions.
Thank you. Yes.
First of all, my lord, I apologize. Your lordship will not take me amiss, my lord. Your lordship knows the flack which we received. My lord,
Why? I'll tell you why I behave like this, because it's not expected of you.
No, my lord, I realize.
If it was expected,
My lord,
Mr. Bhattacharya, I
to
wouldn't
his
have said
defense,
anything.
My lord,
If it was expected, I would have just brushed it off.
I tell your lordship.
Not expected of you.
Mr. Bachawat himself.
rise to his defense.
Jayanta Dake. Mr. Jayanta Mitra, his senior, had violated one of our resolutions, and Mr. Bachawat was the one to take
We
initiative.
don't have any qualms on that, Mr.
That's the
Have you
reason.
seen whatever has been circulated to us? Probably haven't seen.
No.
So it's like going in a procession. When you are asked what is this about, you say yes, this act, but you don't know the full name of the act. It's like doing that.
I know, my lord.
You rushed in
There are
and
a lot
you
of
said,
rumors.
he may not be a member of the bar, but I am a member of the bar. This is not done in a court of law.
I'm sorry for
You
that.
must.
Because
you
the
have
flag
to-
which we
you are,
get, my lord.
you are seen in a different light after you get that gown also. Any advocate should not do this. And you should be a friend of the court. You are of similar status as a judge. Because you look upon you, we make you amicus curiae. In every case, you are an amicus curiae apart from canvassing your client's case. That's inbuilt in a senior gown. And you cannot do this sort of thing. And the resolution, there's no resolution. There's a resolution. What has been circulated to us by the Chief Justice is this has happened to isolated incidents of police atrocities, so-called, for which you have asked the Chief Justice, yes, take steps. Without giving him opportunity of taking those steps, and we shall abstain, we are abstaining from work, judicial work or something like that, as of now. So go and abstain. Not a single request even. Don't pass any adverse order. Nothing of that sort, unlike the previous ones. You have intimated in a rash manner the Bar Association, my association. I am still a member of the Bar Association. Special member, I don't go there. That we have intimated that, yes, Chief Justice, Acting Chief Justice, we are desisting from doing any work from now. So go ahead. Help yourselves.
I know, but
there is no request to us. We
as a
won't
matter of
accept any
fact, my lord,
request.
Mr. Jishtu Chaudhary was on my other side one day in a
And
matter.
I've communicated to my learned brother that henceforth, before vacation, before the winter vacation, we shall not take up any single mentioning of hearing matters, not to say the least. We'll think about inclusion of other matters also. We'll finish whatever is on our roster. We'll go up.
I know, my lord, even
Why
after-
don't give the Chief Justice 2 days time to take steps? Come on.
True, my lord, absolutely, my lord. This work actually affects.
I mean, this is meaningless. This is meaningless. Police, there's a Bengali saying, Kashidhame morlo ka, Kamrupete hahakar. This is precisely that. Police atrocities, yes. So if you can, please go. The Bar Association should send a contingent and before Lal Bazar sit in dharna. What can the acting Chief Justice or the judges do? And what will the poor litigants do if you go on like this?
True, my lord.
Absolutely have a strike. If the Chief Justice does not take any step, that's the extreme step. Yes, it's a democratic right. But why today? The Chief Justice, Acting Chief Justice, during court hours, he comes to know of this, that this has happened. And you give him an ultimatum and you go on strike. Why?
Especially in the.
Mr. Bhattacharya, you also have to have a say. You people also have to have a say in the bar association. I supported every strike of the bar association, but not on these things. And there were occasions, Mr. Bhattacharya, where movements were made by the bar against particular judges. Some of us opposed. If our conscience is not touched, we oppose. You can oppose. This is not the way. Storming inside in the midst of a matter. If Mr. Bachawat is just this, Mr. Bachawat may not be a member. I am a member of the bar association. So go leave, Mr. Bhattacharya. We don't want to hear. You are not welcome if you don't want to.
I apologize for that, my lord.
Because
But your lordship
this
knows
is
the
on
fact
that only.
which we
This is
receive
not
as
the way.
members.
This is
As
not the way.
members, my lord, I apologize.
Yes, absolutely. You should not have come in then. Anyway, please just reply.
My lord, first
Not
of all,
to be fair to him, Lord, possibly he saw that, well, no one will be here and he had to take responsibility. As Lord, he has
Not
to.
a single portfolio holder.
He may
Is he an
not have
office
put
bearer
it
of the bar
correctly.
association, Mr. Bachawat?
Lord, I noticed that. Lord, I noticed that. I
Not
didn't
mentioned.
say anything.
This is the
Which is
same.
why I was left a little puzzled and I was inquiring.
We were puzzled. Mr. Bhattacharya is the only one who has informed us. Not a single portfolio holder in the bar association. And if the decision has been taken in the morning and it's 12:48, why should we abide by that? And there is no resolution asking us to not to pass any adverse order. We will definitely pass adverse orders. You choose to abstain, we will not
There's
work
no
from now.
point getting into
Don't
that.
work. Don't work.
That would be a request. Please don't get into that controversy unnecessary that we will pass adverse.
Mr. Bachawat, if I feel
it's
that
not worth it
my
to-
conscience is satisfied,
No,
I can go into any controversy.
I appreciate that.
I'm going
Not
to any
all of us are
controversy.
people who are not.
And I have gone into controversies without hesitating.
Lord,
My
we are-
conscience is satisfied.
Lord, we are not scared of the controversies. None of us are scared to get into
No,
controversy.
you are
but it's
trying
no
to. You are
point, Lord,
it's for me only.
it's
For-
no
for
point
us
to
only.
not aggravate a situation is what I'm seeing. Lord, I think we are all old enough to know when not to aggravate a situation, perhaps. Perhaps, Lord.
Very. You cannot speak for everybody.
now, my lord, to make things lighter,
Yes.
It fell
Let
from
us come
Mr.
back to lemons and
Yes, it fell from
oranges.
Mr. Sengupta yesterday.
Yes.
Mr. Bachawat had relied on an advertisement with a picture of Hema Malini.
Yes,
If it was that old, as Mr. Sengupta said yesterday, they would have relied on a picture of Hema Malini from Sholay and not from Bagban.
This was from Bagban.
Look at the picture. Boys ko অবস্থা।
No, Mr. Bachawat is innocent of both. Sholay is not innocent.
Absolutely not.
Sholay
Lordship is not.
Bagban, we don't know.
No, I've seen that.
He's not
also.
interested in Bagban.
No,
Because I was
Bagban was told to me. I was told by
Suggested
senior Mr. Bachawat to go and watch it.
I went with my parents to see it.
I was asked by senior Mr.
And he's
Bachawat.
someone who never went for movies, never went for at least a Hindi movie that I can remember maybe once in.
Yes, Mr. Bhattacharya.
Yes.
Let us.
Bagban is 2003, by the way. Huh? That's 20 years ago. 22 years ago. But could I have your lordship's leave for 5 minutes?
First of all, to dispel whatever Mr. Bachawat has tried to prejudice your lordship, he has said, my refined oil, I have a 98% business. Yes, of course I do. I am a big group and I have edible oil business and I sell edible oil by the name Doctor's Choice, Sathi and all. Does it prevent me from doing hair oil business? Now, my lord will kindly come to one of their own documents which they have relied upon. I will not trouble your lordship with the documents much. একবার ওটা দেখানো ওটা কালার যেটা ছিল 716 হ্যাঁ 716 এটা আমার ভুল my lord kindly comes to page 716 না আমার ভুল
Yes.
But will kindly see from the left. It is volume, my lord. I am sorry, 4. I'm sorry. Volume 4.
716, yes. We have got volume 4.
My lord, they have this different bottles. My lord will kindly come to the extreme left. Absolute navy blue. Shalimar Popular Coconut Oil.
Right.
Shalimar Popular Coconut Oil. Third one we don't know. This we have seen since our childhood.
Yes, yes.
Then this one Shalimar Coconut Oil.
Then the impugned bottles over here,
Yes.
Shalimar coconut oil, Shalimar coconut oil. My lord, kindly sees the last one.
Coconut hair.
Hair oil. They themselves distinguish between their own products. The last one is the hair oil, rest are edible oil. Their own statement.
No, but a customer is not supposed to, when he looks at the other edible oils, he's not supposed to compare with whether they have a hair oil or not. They'll see only coconut oil.
But the classes are different. So in a passing off action, if it is a different entity, the test to for deception and confusion is much higher.
Mr. Bhattacharya, if I go and look at this bottle, suppose in a supermarket or any market or any. Now, I am not supposed to know that they also have a hair oil and they distinguish or all those things. Or when I buy this hair oil, I need not know that there are other products or other oils. I mean, that is an.
But your supermarkets, my lord, they have different categories for different things. If your lordship
Forget supermarket, if you go to an ordinary para shop.
Yes, but why would they call it this the hair oil and rest not? Because
they've been doing
the
it for
GST.
several years.
GST. It is for GST. The GST on this is 5%, and
Maybe,
the GST
maybe, but
on this.
how does
So this is a dishonesty on their part.
That's
now
dishonesty on the tax authorities, not regarding any processor.
Now, my lord, it has been candidly accepted by Mr. Bachawat that it is an action for passing, not an infringement. Now, my lord, let us look at the impugned order. And also, my lord, all this coconut oil are being sold under 5 different packaging.
Yes.
And they will claim monopoly over everything. How you are identifying which of the bottle is associated with the product coconut oil which you are selling? Your claim exclusivity is in respect of which? This tin box, which we have seen from our childhood. And in winters, your lordship would remember we had to.
Yes, everybody remembers what we had to do. That too with this immersion.
These bottles they don't. These bottles they don't.
No,
Because
not
they
these
contain some chemicals. They contain some chemicals.
Yes,
that
now
they
it's
don't
different.
freeze.
Yes.
They don't freeze. No, the rack they don't. Wait a second. Now, my lord, let us look at the impugned order. And the last judgment which Mr. Bachawat also relied upon, Assam roofing, well, it was a case of infringement. The lordship will kindly look at Assam roofing. It is a case of infringement, not passing off. Okay. Infringement, essentially an infringement. Because that paragraph which Mr. Bachawat relied upon.
That says both infringement and.
Because it's a rolled up action. But here it is a passing off. Because in infringement, my lord will kindly look at the judgment. It has been held that whether I do not use, doesn't matter. Once it is registered, I'll just take your lordship through. Under section 29, in an action for infringement, there is a presumption of likelihood of confusion. My lord, kindly gives me a moment. I'll just.
Yes.
Not the second. My lord will kindly take of that judgment.
But pattern 89, which was placed, fudges the difference between the two.
My lord kindly takes paragraph 70.
Right.
Once.
70, yes.
A trademark is infringed if the essential features of the registered mark, a mark is said to be infringed by another trader if even without without using the whole of it, the later uses one or more of its essential features. If a word forming part of a mark has come in trade to be used to identify the goods of the owners of the mark.
No, as you said, this was a rolled up action. This was a composite action For passing off as well as
infringement. No, but
there are separate portions, some of which deal with infringement, some say
no,
pass
it
off.
essentially deals with infringement, my lord. My lord, kindly looks at paragraph 85. There is nothing on record to show that the defendant, I'm sorry.
Just half a minute. Yes.
Filed any application for rectification of the trademark, even if the application is filed, mere pendency of an application for rectification was not to be ground to hold that the person who is having his registered trademark has no right to seek an interim injunction. Then paragraph 89, it is a settled position that the use of a registered mark or the essential feature is not a defense available to the defendant in an action for infringement and passing off, merely because the plaintiff has chosen to sue one infringer. So this is applicable in the case of infringement. Chosen to sue one infringer and has not at the same time sued others for infringement is also not a defense in an action for infringement and passing off. Now, my lord, so he has admitted that it is a case for infringement. It is a case for passing off. Now, my lord, kindly comes to the impugned judgment, which is at page 826, volume 5. My lord, the first line of the judgment. They do not clarify to the learned judge that no, it is not an infringement. Rather, they vociferously argue before the learned trial court that it is an infringement action. And I take the point that there is no prayer for infringement. Mr. Ghosh relies on the plaint, and I will show those paragraphs of the plaint. And the learned judge proceeds on infringement. My lord, will kindly see in the matter of cost title, your lordship kindly sees suit for infringement and passing off.
And passing off, both.
Yes, both. But the test in passing off, my lord, I will come to that. I will. Then paragraph 1, infringement.
And passing off.
And passing off.
Whenever you see infringement and passing off,
and passing off.
you cannot go out of it.
It has to be both, because mere infringement cannot, because a prior user has a better right. Even if I am registered,
yes,
a prior user will have a better
why should
right.
you give up that? I mean,
Yes.
it's there.
So, but then page 829, the arguments, it's premised on the basis that it is an infringement. First line, my lord.
829.
Yes, D, my lord.
D.
On the aforesaid premises, the plaintiff has contended that although the name of the infringed product, the argument here which is being made is completely different. The learned judge proceeded on the basis that it is an infringement action.
What would be the adjective for a passed off product? Passed off product.
Passed off product.
Infringement.
Infringed product.
Infringer or infringed product.
It is a deliberate.
My lord,
What would be, then what would you call a person who is passing off?
Passed off.
Passer bhai.
Passed.
Infringer and infringed product be pertain to passing off also.
Last few lines of, my lord, that paragraph, my lord, it is a deliberate attempt somewhere in the middle of the defendant to use the century-long kudos of the plaintiff in their infringed products.
But the trademark was not century long.
No, but that is the case which they have made out in their plaint. 1945.
That's the user. Probably.
29 subsection 4 has been quoted.
Now, my lord.
That was not the trademark. That was the user. So more you are reading, you are going on passing off. A century old is passing off.
My lord,
trademark is not century old.
My lord, the first.
No, their case.
Their case is with regard to this particular bottle. We are not disputing the fact that Shalimar is a big brand. Nobody is disputing. It's a household name. Obviously. We cannot dispute. But what is so distinctive about this bottle? Now, my lord, kindly turns the page over to page 830.
My lord, kindly look at it. Since the goods, has your lordship found that?
Which paragraph?
830, my lord, 10 lines from the bottom.
Therefore, the goods.
Since the goods,
Since the
goods are dissimilar, because I said theirs is a hair oil, mine is there's an edible oil, mine is hair oil.
Yes.
To show for maintaining an action for infringement, the shape of the bottle independently has become so reputed that it could maintain an action for infringement for a different product goods as envisaged under 29(4). The entire arguments are based and the judgments relied at page 833 are on the basis of infringement. Even my lord, page 832, I am not disputing what has been laid down by Supreme Court in Syed Mohiuddin. I am a registered owner, he is a registered owner, or passing off is maintainable by seeing who is the prior user. Now, my lord, will kindly see paragraph 7. Last line, as a registered at 832,
Yes.
petitioner is entitled to protection. So the learned judge proceeded on the basis of an infringement action. Though ultimately he gave passing off, but proceeded on the principles of infringement, because there is a statutory presumption under section 29.
But para 8 is also there, Mr. Bhattacharya. You
Yes,
must read para 8 also. No?
Superior right, of course. Nobody, that's there in the statute itself, section 27.
And
Now, my lord,
it's on both premises,
Yes.
not only infringement.
but
You are just culling out the portions where he dealt with
he has gone on both. And
both.
he has gone on both. But
Yes.
here, Mr. Bachawat has restricted that it is only,
Only passing off? No.
Yes. Now, my lord. Huh?
Understood. Yes.
Now, my lord. No.
But if he is entitled to
Of
an
course,
order
of
on passing off, then
No, but the learned judge proceeded on the basis of both infringement and passing off.
True.
Now, my lord, as I have argued, my lord,
yes.
in Warnick's case, the test of passing off. Misrepresentation to public to cause actual loss in the course of trade.
Yes.
So it's an action in tort, it's an action in deceit. My intention is to deceive somebody. How can I deceive somebody by adopting something? So forget about the label. I am just forgetting the label. Something so generic, a bottle shaped yellow like this.
Are the ribbed, the ribs.
What is so unique about this ribs? He himself, if it was so unique, he would have sold it in one bottle. My lord, your lordship was referring that day to other things. The other stuffs which are sold, it is under a particular shape with a particular brand. Dharan. It is in a particular brand. If I may, my lord, give an example, my lord, with your lordship's permission. Monkey shoulder, if your lordship has seen that.
Don't require my permission for that.
My lord has seen the shape.
Yes.
They do not sell it in 5 other shapes.
Right.
Now, my lord, so far as Jeff's Lemon case is concerned, if I may just trouble your lordship, my lord, it's a very big judgment. I did not want to trouble your lordship. The most important question there was that the customers did not look for the label. It was so distinct. Somebody came up with that idea of selling orange juices in a container
Lemon.
shaped as a lemon.
Yes.
So the customers did not go to look for the label. They just picked up thinking that, okay, this is from Jeff's Lemon.
That is
the distinctiveness of that shape.
That is not applicable here, definitely.
That cannot be made applicable. Next, in an action for passing off, they have to establish their goodwill. My lord, kindly look at their plaint. First volume, my lord. They have given, so to establish goodwill and reputation, they have to say what is their sales vis-a-vis this bottle, what is their advertisement? And now, my lord, there is a Justice Oka Division Bench judgment of Delhi High Court. Considering Moinuddin says it, though it was in a decretal stage, but even at an interim stage, that has to be considered. My lord, may I just?
But you did not cite that.
I did not, my lord. It has come. I'll not.
Judgment must have been there when you started arguing.
It should have
Justice
been
Oka
there.
has
No,
not
it
been
has
there.
come.
No.
No, I will not trouble, but that is, my lord,
You can argue the principle.
how do you establish goodwill and reputation?
Yes.
My lord, will kindly look at page 55. Do they say that this is the sales figure for this particular bottle? How would you bring that goodwill so far that as this particular bottle is concerned? Shalimar agreed. It's a household mark. Shalimar, Duckback, these are all household marks. Every child who had grown up in Calcutta, 80s, 70s, 80s, 90s, they knew about these marks. These are household marks. But what is so distinctive about this mark? Now, I'll say. If I had the
Bashar was saying something that from 2006 they have started using this plastic bottle.
What? How much are they
Is there
selling?
anything in the pleadings?
How?
If
But-
there is just please mention.
No, their pleading is 1945.
We have shown those invoices. Mr. Bachawat has taken the date from the invoices itself.
The invoices does not show that it is this bottle. It only says plastic bottle.
It shows the color of the bottle also, and HDP is written on those bottles.
HD
That's what Mr. Bachawat showed.
No, I'll show, my lord. My lord will kindly see what they have said. My lord will kindly see their registrations at page 49. My lord, paragraph 8 at page 53. Of course, it's a well-known, it would be a well-known mark. Shalimar is a well-known mark. Kindly looks at paragraph 9. This is all based on infringement.
This is the bottle. 1945.
But again, para 8 is continuous on it.
No, my lord will kindly look at it.
It's on and off, passing off and
Passing off and
not restricted to.
No, but Mr. Bachawat has been candid. They could have only maintained an action for passing off, not for infringement. Now, my lord will kindly look at page.
No, Lord, that's not what I said. I said that the order which has been passed is not passing off. There is no order.
But it has placed 3 portions of the order where infringement has also been discussed.
May have been, but not the order passed is only on passing off. That's what I said. The order passed is on passing off. There is no cross appeal by me, and it records that I only pressed the passing off. I showed your lordship that portion, that I only pressed for passing off. It doesn't mean that the action doesn't lie. There's a difference. There's a difference. But not in reply if my learned friend is to again address on facts which I've already dealt with. Not
yes,
that
Mr. Bhattacharya, don't do it.
No. I'm answering to the court's query. I'm answering to the court's query, my lord.
Which query?
That 2006.
Oh, yes, answer that by all means.
No, they have claimed user from 1945, so far as this is concerned.
Yes, that we have seen from
page 181.
Yes.
Page 181, your lordship kindly looks at it.
The paragraph 4 of the plaint is novel. Actually.
No, my lord will kindly look at the registration certificate at page 181.
The pleadings, paragraph 4 of the plaint, page 48. They say in or around the year 1945, the plaintiff conceived of and adopted a novel artistic get-up of its label stroke composite mark. Then it says for use on its containers within bracket metal and HDPE.
That's
it. Not have
page 181. My lord will kindly look at page 181.
Which is why I had made this submission. Lord, irrespective of that, all the bills are next. not the bills, not
It can
right from
it
406,
be, but that
407.
shows
But there are
that it is
40
in respect of
40
this.
such bills not showing user from 2006 onwards in respect of green bottles and not yellow bottles.
Manoj, kindly looks at page 181 once. I will not trouble your lordship with the facts anymore.
I've given the page
181,
number and
kindly
showed.
see
Not
user detail.
Page 406.
User detail 14.
But I'll just give your lordship the bottom, not the
And
bills
page
which say
182. Kindly
green
look at
bottle
page
is 406, 407, 408, 420, 419, 20, 21, 22. These are green bottles. And the ones which say yellow bottles, but again, they start from page 409 going up to 434.
420
And then there's not the others are more recent, but not the earliest ones which we have annexed are in those pages. And those bills are not under challenge.
Yes, Mr. Bhattaji, you are showing 181.
181. My lord, kindly turns the page over to and kindly looks at the date. User date
22.
1945. 1945.
That is what.
1945. Just above the certificate detail, 1945.
User detail is 40.
Yes. Now kindly see the next page. Are they using this bottle from 1945?
So,
that's facts. Do you want to give him a chance to reply again?
This document. Showing his document.
how do you benefit from this? I mean,
no, the falsity of his case.
But
So
his falsity is not to be looked into. I mean, it's immaterial.
Where had
Pure
he
deceit.
proved his goodwill, reputation, that had to be proved by way of sales under this particular bottle.
This
Where is
particular
it?
bottle they could not have used from 1940.
1945. Now, my lord, this this has been handed over. কোথায় গেল এটা? যে লিস্টটা দিল রঞ্জনদা ওই এইগুলো? No, it's listed. My lord, Chief Sleman case, your lordship will kindly
This
take
film
note.
we have now know
Yes.
by heart.
Now, my lord, so many of them has been handed over. Colgate, এগুলো আপনি কি রিলাই করেছেন রঞ্জনদা? সবকটা?
138 particularly and the
1,
others
3 and
also.
8. Okay.
And the others also generally.
These are all cases where the get-up is the same,
Yes.
different mark. This is an answer.
It is not a case, my lord.
They've given the craft
get-up.
also, the gist in the right hand column.
Yes. My lord, can somebody just forgetting this I'm that this is
But
Shalim.
we have to see the entire thing as a whole.
Yes. Now this KMP is there. And Durgadatt Sharma comes that if this additional materials, somebody who's going to buy Shalimar will not get confused because this KMP prominently, and I am showing if there was any dishonesty on my part, why would I indicate my source? And I am not a fly-by-night operator. I have brands like Doctor's Choice and all. This is very generic. I have shown other people are also using it.
He says nothing about doctor's choice here. Please don't.
So we'll close arguments, Mr. Bhattaji. I think we are repeating things. We are repeating.
But this is what Delhi has.
No, we won't look into that.
Supreme Court has said, my lord,
We made it clear.
that you have to, if you have to establish goodwill, you have to show.
Reply don't cite any
No,
further
no,
judgment.
I'm not citing, my lord. You have to show what is your sales figure, what is your advertisement. My lord, so far as a Nivea cream box, my lord, even if it is kept over there a blue, we will assume it's Nivea. We will assume because since childhood we have associated ourselves with that blue colored Nivea. Has your lordship associated yourselves with a yellow colored?
So we have to ask the children of now. The children of yesterday. That we'll have to ask them.
We are going back to all old things now, though. We are not
No,
that
one thing Mr. Bachawat said about the trademark manual. I never said that a shape of goods cannot be registered as a mark. What I said was there has
didn't
to
say
be
that.
something distinctive about it. Manoj will kindly look at that trademark manual once, which I had just.
But what I said was, it says it is only guidance and this
No,
is a
no.
draft. These are the two things which I should
No.
Just continue and we'll just end it with this.
I'll just take 30 seconds.
Oh, achha.
30 seconds, my lord.
Yes,
It
30
says,
seconds
my
is
lord,
fine. Yes.
my lord will kindly take this manual. Indeed, section 98 of the trademark gives statutory recognition. So it is a statutory recognition.
But this is only a draft. It says that. বার করে রাখুন ওটা একবার দাও প্রথম পাতা থেকে দাও
No, you showed that it's a draft.
But in any case, infringement is irrelevant here. But one sentence, if I may also not get in, because I forgot to distinguish one judgment.
Maybe just come back at 2 and just sum up, my lord.
Yes.
But can I just take one sentence? But AR 65 Supreme Court relied on by him. Not I'm distinguishing by saying that not that he will always escape liability with the added matter. It says may escape liability. You may.
You have earned the right to put that in your written notes. Yes, Mr. Bhattacharya, just conclude in 10-15 minutes after we come back and we'll get it over with and we'll fix a date for filing written notes.
Can I be excused after 2 if it's possible?
Yes, you have finished. Yes. We want you to be excused so that you don't argue further.
Lord, your lordship hasn't reckoned for Mr. Roy Chaudhary. He's a tougher opponent than
Just
me.
shut up. We won't let him open his mouth. Yes.
Just to sum up. Once more, that page 716, it's 5 different bottles. Okay, they say fifth one is for a perfumed hair oil. Rest are for normal coconut hair oil. My lord has seen in trade, my lord is aware. Nivea, traditionally blue. But now they have come up with variants. Because I buy for my daughter, I know. It's called Nivea Soft or something. It comes in a white chip container. For different variants, it is the trade practice to adopt different colors. My lord is aware, classic, the regular classic is in a red, the classic miles comes in a white, and ultra miles comes in a gold.
Miles can't be used anymore.
Whatever. So
miles can't be used. Why?
No, because there is an act, Cigarette Tobacco Prohibition Act. There is a rules now 2008. Now they have said that they can't use these words, miles, etc.
I will be committing an act of contempt if I have to take it out.
Now there is
it is there. He doesn't have this vice. He doesn't know.
No, but that is the law now.
No, of course, Blinkit could have that.
No, but
So for different variants, there
Challenge the virus, have it assigned.
No, your lordship is going to hear one of the matters. It has been assigned to your lordship, one of the ITC matters.
I'll have to release on personal bias.
No, not on the virus part, but on a trademark matter.
So, my lord, he comes up.
Yes.
So, if he has only been using this bottle and not the rest 4,
Understood. Yes.
I would be out of court. I have nothing, no defense at all.
Shalimar oil is not associated with this bottle. He has
I'm
wide range
grateful.
of containers and all.
Wide range of containers. Wide range of containers.
And if that has to be honored, then no shape, no bottle, nothing can be used.
Nothing. They adopt another 5 more shapes.
All right.
That is essentially what GIFS lemon. I just one passage, but it's a longish. I'll just.
Longish. Why do you use ish? It's a very long judgment.
Because it has trial court, court of appeal, house of law.
Yes, everything. Right.
But 399 of that class term 20, my lord. The court of appeal one, my lord. 399. The page number would be at the top.
Yes. Yes. That's around 20. Right.
To succeed, the plaintiff here have to establish an exclusive right to use plastic lemons containing fresh lemon juice. But that claim has to be viewed with caution. Though it was so distinctive, if their claim is acceded to, they will be able to exclude competition in lemon shapes, whereas they themselves will be able to compete in the bottle market. The plaintiff's get-up has always with a label attached. Passing off can only occur if the label is expunged. So the test is very high. And when you yourself are using in various distinctive bottles, the same, you don't say that in the green bottle, it is a variant. In the blue bottle, there is a variant. But with regard to this one, my lord, it was the submission, though it is not in the plain, if the submission was made, it is a perfumed hair oil. It is a perfumed hair oil. That's why it is different. That's why this bottle is different. The rest are all coconut oil. My lord, so far as Mr. Bachawat said that I have been copying, that is a trade practice. My lord will kindly look at my rejoinder. I will not trouble your lordship.
Copying the trade practice means?
Copying, no. I have been using these bottles that I have been copying from others like Parachute.
What is the trade practice here?
No, my lord, these are very generic. These bottles are very generic. My lord will kindly page 46, Shalimar Amla. This is actually Dabar Amla. Amla hair oil can only be in green, and this is the industry practice. In our reply to can 3. Then 47. This is Jasmine. This is Parachute Jasmine. These are absolute industrial trade practice. My lord, they essentially to succeed in this passing off, they have to establish the goodwill and reputation with this bottle. Where is that figure?
But Mr.
My lord, why did they come up and give up their case for infringement before your lordship?
Mr. Bhattacharya, wasn't it your onus to show that this is a trade practice and that
My lord, there are
oil is used in by others also?
I've shown.
No, their sales, whether they are negligible or not, any corner, nook and corner.
The onus
Mr.
is
Bachchat argued that
the onus is on them. What is their sales? How would I know their sales?
Your defense is, if your defense is that this is trade practice and others also use coconut oil, sell coconut oil in similar bottles. So you have to show their sales, the magnitude of their sales, or probably their sales figures or something.
It is his action for passing off.
Yes, but it's your defense.
No.
So
in order to succeed in passing off, he has to first establish his goodwill in relation to that bottle. Where has he established that? I have stated in my in my opposition that there are others also who are using this. They will kindly see. I have shown those Boidobati, Balaji.
Boidobati or
Boido, whatever. Will kindly.
So Bhatti is associated with something.
Boidobuti, sorry, Boidobuti. This is Balaji.
Boidobuti and all. Do they have any sale at all? I mean, you have to establish that, Mr. Boidobuti, I've never heard of Boido.
Balaji, Sampurn. This is a
that was intended for Boidonath and other things. Not for Boido.
Sampurn. This is a big brand. This is a big brand.
Sampurn.
Yes. And it's a registered
Have you ever
mark.
used Sampurn in anything?
My lord?
Have you ever used any product?
I have not even used KMT. I don't use a hair oil.
No, in any product, I mean, Sampurn,
my lord.
You had to show at least that these have some sales worth the name.
How would I? These are available in the market. They are aware of it. What is their sales figure? How can I obtain as an outsider?
No, those can be obtained from the. Those are public records. I mean, their corporate records will show that.
But I don't know whether Shalimar has been selling under these 5 bottles. What is the sale in respect of each of the individual bottles? That is very difficult.
No, but even if these companies haven't exist, Boido Buti, we have never heard of.
Well, forget it. Balaji and this Sampur.
Balaji is in everything. Whether this Balaji is that Balaji.
No, but they are complaining of the shape. They are complaining of the shape. This Sampur. Have they taken any action against them? I am also, as I told your lordship, I am not a fly-by-night operator. Now, when he feels threatened that I can be a competitor.
Yes.
After all these years, he has come after me.
How long have you been using this?
2019. 2019.
That is somewhere in the record.
Yes. Yes.
If it's there, it's there. I mean,
it's in my opposition. My lord, kindly give me a moment. Opposition to go there. My lord, they had also filed 551. 551. But they had also filed a criminal case. My lord, which was? No, 551, volume 3 of it.
You need not place it. If it's there, if you learn, Junior can find out.
Let me
before conclusion, then just tell us that it's there.
Oh, 774. But I'll just check my notes. 774.
ওটা দিতে বললো কোন পেজ কি দিতে বললো 590
But I'll just check and my lord. They cannot have monopoly over all the bottle shapes which I have just shown.
What these people have with New Lakshmi coconut oil, Chakravarti and sheets, and New Lakshmi and Jivan Jyoti. Jyoti spelling is wrong. Sampurn.
Is looking at.
These are not, sorry, these are 592, 593, 591. These are probably your annexures regarding others using the same thing.
Yes, yes.
But these are even non-entities in the market probably. And you have to show that they have some presence in the market at least.
Before that, they have to establish.
Trade practice means people who are there in the market who have at least entrenched to some extent, they are using this. So trade practice, I open a company, like you said, flyby company, and just have a something like that.
But I have disclosed my.
For all that we know, they might also be trying to copy them.
Malad will kindly take.
Yes.
Page 618. These are the sales of this herbal coconut oil.
618.
So these are from 2018-19.
এটা নিয়ে নিন পাঁচটা তিনটে
618
1
619.
These are sales
of my coconut oil under this.
Your
These bills I have all annexed.
Good.
Then 623, my lord, 2020. This is the green bottle.
So 2019 is the earliest practice.
Yes. My lord, I have stated that I have been using it since 2017. My lord, that's at page 557. Part of the vacating application, paragraph 80. No, my lord, this all these judgments which has been relied upon. But everity, we know it is essentially red. But even then, in that Eurosolo case, the court said it can only be over combination of colors, not a simple color. But this trademark manual, my lord, I will be candid, I will be honest to your lordship. My lord, this trademark manual is now saying, now also consider single colors. I'll just show it to your lordship.
Trademark manual is
It's
guiding principle.
No, it's a guiding, but it is also to be taken note of in view of section 98. But this manual, my lord, the registry actually tries to adhere to this manuals. My lord, I'll just show, my lord.
But they have a passing of action also.
Yes, yes.
Infringement.
Yes. No, this is for the purpose of registration. I do not deny. But this is the way they treat a shape of goods to be of distinctive. Then they would have applied for it. No, my lord, will kindly that single color also. Let me just show to your lordship. 4.8.1 is talks about combination of colors, and after that, because like Nivea, that blue bottle, you look at a cold cream blue bottle, you immediately associate yourself. You immediately associate yourself. My lord, initially they tried for criminal proceedings. That's in 2023. They come up in 2024, 16th August. 16th, after the date.
For what?
After the caveat expired.
Allegation of what?
Passing of an infringement. My lord, I know that a criminal court's order is not here. My lord, I'll just read out, my lord, it is...
it's an offense, criminal offense.
Yeah, it's a copyright infringement.
Criminal action.
Copyright infringement, my lord, just the order of the High Court, my lord. From the complaint itself, it is ascertained that the opposite party's grievance is with regard to the design of the container. Now, used by the petitioner, which has nothing to do with Copyright Act. If Copyright Act prima facie does not stand, question of cheating by way of criminal conspiracy also fails.
On a different footing.
Different, absolutely. But this is what they tried from 2023. They come up after a year.
We have filed a suit in 23 itself.
Sorry. Oh, sorry, 16th August 20. Yes. My lord, they cannot claim monopoly over all shapes and sizes. Chips lemon, it was being sold only in a lemon shape, not in a lemon shape, apple shape. different mango shape was only, and they are 5. And why have they given up infringement? Your lordship has seen the impugned order. There they had run both the cases. They know that they cannot claim monopoly on the basis of their registrations. They don't have a shape registration. And passing off, my lord, your lordship has seen it. So far as this particular bottle is shape is concerned, what is their turnover? What is their goodwill? Nothing. At different places, different dates of user. Some 1945, 2010, 2016, all different dates. I don't want to trouble your lordship with all those pages. I'll put it in my notes.
Thank you.
Grateful, my
Thank you very much. Hearing is concluded. When can you file your written notes, respectively? How soon?
Lord. A week's time.
1 week. 1 week. So we are putting it on next Thursday. Should we put it on that?
Very
You ask your juniors, both of you. Their junior has agreed.
We are not there on Thursday.
So
No, you prepare it, just have it filed to somebody. We'll just take the written notes.
Our presence may not be required, only the notes has to be.
Yes, absolutely. I will put it as to be mentioned. Hearing is concluded. Footstep Learned Counsel for the parties are requested to file their respective written notes of arguments on the returnable date. That is on November 27, 2025, when the matter shall be listed for such purpose under the heading to be mentioned.
Grateful.
Thank
you. It was a pleasure, my lord, to argue. It's not a
Okay, it was a pleasure hearing both all of you. I mean, you're so ready in the matters. এটা এগুলোর সঙ্গে থাকে
ভলিউম গুলোতে
অন্য কল করে দেখুন
তুমি ছেড়ে দাও, you will not carry it.
Item number 17.
Yes, Mr. Sengupta.
Now, my lord, from the passing off, now my lord, my lord will enter into the acquisition case.
Yes.
Land.
Yes.
My lord, here, my lord, first, my lord, on the last occasion, a point was argued.
Mr. Sengupta, if you remember, Mr.
Yes,
Beda,
yes,
you have given a reply. You have not yet started, right?
No. But my lord, at an earlier point in time, it was given. However, my lord, I am not.
Different matter.
My lord, I am not.
Different matter. So, Beda, please take your seat. Yes.
The only thing, Lord, on the last option, can see your lordship order on.
Yes. I have brought the records. My lord,
Records,
before that.
records,
Yes, I have brought the entire records. Well, I am not on that. My lord, I will produce. My lord, then my lord, certain things are there. Then I have to file an application under order 47 rule, 41 rule. My lord, before that, apart from that, my lord, my lord, I am beseeching to my lord, kindly formulate an issue. First issue, my lord, I am kindly formulate an issue. So for this case is concerned, because it has got a far-reaching effect, because everybody is waiting for this the judgment.
What issue are you talking
First issue, my lord, whether, given the fact situation of this case, whether 2013 Act is applicable or not. First issue.
All right. Yes.
Second issue, my lord, whether, given the fact situation, even if possession has to be deemed to be withdrawn, according to my lord's observation, because possession was taken after that. That's why it's 8, as per section 8. If possession along with the section 6 to be invoked, then my lord, it is not a vesting. But the next issue would be whether in a given fact situation, whether 2013 Act is applicable or not, or what act, that is the act applicable, that is the 2013 Act. Given then,
same question you are.
No, my lord, because first, my lord, 2013, apart from the fact whether possession was illegally taken or not, then if it is initiated under the Act, it is not initiated under Act 1, then whether 2013 Act is applicable. First point.
That is the only question up to now.
Second point, even if for argument's sake, assuming but not admitting, that the possession was deemed to be an illegal one, as per the observation of my lord, I will
Acquisition Act yes.
even if my lord that possession is deemed to be an illegal, as per observation of my lord, and then I will satisfy the possession was not to be treated as an illegal, I will satisfy that. Section 4A, because notice of hearing was not given, because at the same on the same date you have issued 4, Section 6, Section 7. Even assuming that possession was taken illegally, then whether the provision, which act is applicable, whether 2013 Act or the 1894 Act, Act 1, that is repealed. Because of that is the, on the basis of principles of my lord, this is incorporation and not by reference. Third issue, my lord, may I make it clear to that? Because my argument would be, so far the second point is concerned, that the Land Development Act only refers to Section 11, how the assessment can be made ready with Section 23 of the Land Act. In the Land Development Act itself, it is clear. So far as may be applicable. If that is there, then Section 11A is not to be applied, and the provisions under, even if that act was repealed, Act 1, and the Development Act is in subsisting, then the compensation part or award to be given under the provision of Section 1894, not 2013 Act. So, my lord, first these two, on the basis of the proposed issue, I will first address the Honorable Court regarding if it is not initiated under the Act 1, then 2013 Act is at all applicable or not. First two issue, my lord, I will discuss, then my lord, later two issue I will kindly. First, my lord, I will refer the judgment of the Honorable Division Bench of our High Court. That is my lord Niladri Chatterjee, state of ওনার কপিটা কোথায় গেল? আচ্ছা এই নিন আমার কপিটা নিন। এটা রিপোর্টেড হয়েছে, আমি রিপোর্ট
If it's reported, then give the citation.
I think it is reported. My lord, however, my lord, for the timing, my lord, kindly.
It is reported, but unfortunately.
Yes. I have already.
Unless they reported, because if you refer to a judgment which has been reported, you cannot say unreported. It is reported, but I could not.
Right now, my lord, I cannot, because it is reported. My lord, I will. Yes.
It is reported.
Yes, my lord. My lord, the issue was before the Honorable Division Bench. If the act is not initiated under Act 1, there no award was passed, no compensation was paid. Then what will be the consequence? Whether it will be governed by starting from fresh initiation of the proceeding under 2013 Act and culminating to the Section 26 regarding compensation award. The Honorable Division Bench, first, this is the case, my lord, comes up on the premise that Section 41 notice was issued, and after that, nothing was done. No award, no compensation. So after discussing everything, I will only rely the relevant part. I just. My lord, kindly come to inner page 26. Inner page 26, the last two lines, it starts with undoubtedly. Undoubtedly, it is only duty to the collector's failure to issue notice under section 93B of the 1894. The land acquisition proceedings stood lapse. However, without whether ipso facto such a lapse translate into a claim for compensation under the provisions of Act 2013 can be answered simply by visiting section 24 of the Act 2013. I have already placed, my lord. It will be noticed from a plain reading of the section, there is a phrase, proceeding initiated under the Land Acquisition Act. In the facts of the instance case, it cannot be held by any stretch of imagination that proceedings were ever initiated under the said Act of 1894. As such, abdication of statutory duty on the part of the collector pursuant to issue notice under section 93B, either due to sheer carelessness or negligence on his or her part, cannot ipso facto translate into a claim for compensation under the Act of 2013. We do not know what prevented the writ petitioner from approaching the writ court anytime preceding initiation of LA case number 77 at the year 2014 for the purpose of seeking appropriate reliefs. Merely by making two representations on 20th December 2011 and other 30th July 2014, they have sought for an issuance of writ in the nature of mandamus for getting compensation on the Act of 2013 after filing a writ petition only in the year 2014, by which time the said Act has already come into force. We find that in the facts and some writ petitioner were sleeping over their valuable rights to get, by that time, when the Honorable Division Bench passed this order, this constitutional bench judgment was not delivered, because it is very important. One fine minding, when the Act 2013 has come into force, in other words, compensation under Act 2030, upon invoking section 20, when proceedings were never initiated under the Act of 1891. However, the respondents are entitled to claim as applicable such and such compensation at such and such within period of 8 years. So, my lord, the first argument would be, my lord, subject to my lord's kind approval. This was challenged before the Honorable Apex Court, my lord, because I am not sure, because I didn't get the copy. SLP was dismissed. I have learned, but right now, my lord, I cannot disclose unless I go through that. My lord, now this is the, my lord, these things, my lord, is in compliance with the statutory provisions. Section 24. It is clear if it is initiated. There, section 4 of Act 2, my lord knows that 1940, that act is was a temporary act. It expired on 31st March 1997. Yes, 1997. So, my lord, after all, this is the division bench judgment. It was not set aside or, my lord, varied, modified. This judgment remains. Is it? So, resued accedendi would be applicable. Yes, if my lord disagree with that, my lord can refer to the judgment. Yes. However, it has, my lord, as per.
Section 24 is also specific.
Now, my lord, kindly consider the second point. Second point, my lord, I am relying, because on that, because when the judgment was delivered, this judgment was delivered August 20th, 2017.
This is also unreported.
No. The just now, my lord is going through. Yes, it was judgment was delivered on 23rd August 2017. So at that point of time, the Constitution bench judgment regarding interpretation of statute has not come, or judgment was not delivered, and that I am now relying upon that the judgment of the Honorable Apex Court that is reported in 2022 4 SCC, 14 SCC, page 173. This is touching the second, my lord, the issues. My lord, দিচ্ছি আপনাকে দিচ্ছি আমারটা কোথায় গেল আমার জাজমেন্টটা কোথায় না না এটা নয় ধুৎ, এই জাজমেন্টটা আমারটা কোথায় গেল
Into development, into
just a minute, my lord.
Yes, yes.
এই জাজমেন্টটা দেখ না
Indo development.
No, no, my lord. The recent judgment I have 2022 Supreme Court. Just now I have handed over regarding.
Yes.
Yes.
So what are you searching for?
My lord, that judgment, my lord.
You don't have another copy?
I have no copy, my lord. I have a copy, but my lord, because I have marked it.
Where is that?
My lord, no, that in that judgment I am not. Because it is my lord's judgment. Because in my copy I have.
You're not getting that? Fine.
I am not getting that right now.
Mr. Beram might have stolen that judgment, your copy.
Yes, my lord. Sorry, my lord. I am extremely sorry, my lord. 2022 14 SCC, page 173. My lord. Yes, my lord. Party number হচ্ছে Bangalore Development Authority and another versus State of Karnataka and others. The question, my lord, I am just, my lord, need not read.
Paragraphs will you
My lord, I will read, but some of the paragraphs I have to read, my lord. And vis-a-vis, my lord, I have to compare with the statute of the West Bengal.
Have you noted somewhere that which paragraphs you rely on? That's missing.
That's missing. But my lord, I can remember. My lord, here the question arose,
yes,
my lord, that BDA Act was a state act.
Right.
And 1894 Act is an earlier act. BDA Act is a subsequent act. In the BDA Act, there is a provision, section 36. Likewise, section 8 of the LDP Act. I'll satisfy my lord. There, the question arose that whether after expiry or after repeal of 1894 Act, what will be the provisions to be governed or to be guided for making an award and making an compensation? The Honorable Division Bench of the Apex Court of India held same thing, my lord, it is not initiated under Act 1.
The first head note is very clear.
Yes.
The 2013 Act repeals only LA Act, not any other central act.
Yes.
Expression contained in section 24 cannot be given extensive interpretation by adding words.
Yes.
It only says initiated under LA Act.
Head note something, my lord, may be different. My lord, yes,
no,
but
section 24 is very clear.
Very
You are right on that.
so, my lord,
Only says initiated under the LA Act.
first, my lord, point, my lord, kindly see the issue. What was the issue before the Honorable Apex Court? We kindly.
Mr. Sengupta, the learned single judge relied on the 2013.
Yes.
For completion granted on 2013 Act.
2013 Act. My lord, an entire proceeding was quashed. My lord, kindly come to page 170. What were the issues before the Honorable Apex Court? My lord, page 176, 3, 5A, B. My lord, I am reading.
Yes.
Whether the repeal of Land Acquisition Act 1894 has the effect.
In a previous matter, probably.
176.
No, this arises from those writ petitions. No, it says notifications.
My lord, notification. My lord, kindly come to clause 5A.
5B of
5A and B.
Is of Sudhakar Hegde's case, another case.
No, my lord, I am referring.
Questions formulated in the said cases whereas under.
My lord is looking 176.
You please read para 3, you'll get what you'll get.
Yes, notification both preliminary final. Yes, then kindly come to Hegre, then 5.
Before 5, see the previous sentence. The learned
Yes,
single judge of the
question formed in the said case whereas under.
said case. This is
Said
not
case,
this case.
yes.
Of a different case.
Yes, the question formulated in the said cases, Sudhakar Hegre versus State of Karnataka. When Honorable Learned Singular Karnataka decided this matters on 21. The question formulated in the said case. Kindly see whether the repeal of the Land Acquisition Act 1894 has the effect of frustrating any provisions with reference to the section 36 of the BDA Act. Whether the acquisition proceeding can be said to have lapsed by virtue of the right to fair compensation and transparency in land acquisition derivative consideration have come into force. My lord, now, my lord, kindly come to, my lord, I am not going into the, because there is a Supreme Court constitutional bench judgment based on that offshore Bangalore. My lord, it is reported. Kindly come to paragraph 6, which is page 176.
Yes. Offshore holdings.
Yes. Constitutional bench judgment, offshore holdings versus BDA. My lord, I am just referring, my lord. Now, my lord, what is important? Kindly come to 178, on the basis of which the Honorable Supreme Court has come to a finding that yes. Page 178, paragraph 11. Chapter 4 of the BDA Act deals with acquisition of land. The chapter contains 35 and 36, relevant provision for the purpose of present case. In the subsection 36, which is under 36, in the BDA Act. The acquisition of land under this act, otherwise than by agreement within or without the Bangalore development, shall be regulated by the provision so far as they are applicable of the Land Acquisition Act 1890.
Similar to LD Act.
Yes. So far as they are applicable. Now, my lord, kindly come to the ratio. Yes. My lord, kindly come to the issues, my lord, before the Honorable Apex Court. Paragraph 181, 19. Paragraph 19, page 181. Madam, I'm sorry, my lord, I'm again, my lord. No, my lord, this is not fair, my lord, on my part. It is very, you can both of our judgment. Bag ওখানে কোথায় রেখেছি? Bangalore development. In fact, আমি ওখানে কাজ kindly come to 19, paragraph 19. The question may also be examined from a different angle. Section 24-20 expressly refers to the land acquisition proceeding initiated under Act 11. Subsection 24 is and such and such. My lord, I am not on that.
Same thing.
My lord, same. Now, my lord, page paragraph 20. 2013 Act repeals only LA Act, not any other central or state enactment dealing with acquisition. Therefore, what is sought to be saved under Section 24 of the is only acquisition which had been initiated under the LA Act and not those acquisition which had been initiated under any other central or state enactment.
Yes.
The expression contained in Section 24 cannot be given extensively interpretation by adding words into the provision in the absence of the provision itself giving rise to any such implication. We are of the view that 2013 Act would not be regulated the acquisition proceeding made under the BDA Act.
Yes.
My lord, kindly consider this is, and my lord, section 36, my lord, there is also a judicial ratio decidendi. Just a minute, my lord. Whether legislation by incorporation or legislation by reference. The Honorable Single Judge,
yes,
he just held that it is a legislation by reference. That's why, my lord, the 2013 Act is applicable. But here the Honorable Apex Court is a legislation by incorporation.
No, this is not, I mean, this is legislation by reference means it's limited to the extent to which it is referred.
Yes, that is why
Very
that
clearly
the
says,
Supreme Court has gone into that.
LD Act says that after
Yes.
this stage, LA Act will apply.
Only I will show that portion, the 11 and 23.
Yes.
So 11A is not at all applicable here.
All right.
That is the thing, Ballard. It was discussed in this.
So according to you, they should not get compensation, or they should get
They
compensation
should
under
go.
LA
Of
Act?
course,
They have to get compensation
they have to get
under the LA Act
under the LA Act.
as provided in the LD Act.
LD Act.
Even after coming into force of the 23rd,
Even
because
after all that,
that has no application.
acquisition didn't lapse.
All right.
What I mean to submit, well, subject to matters approval, acquisition did not lapse.
So this has nothing to do with that proposition. This says that 2013 Act does not apply because of the language of 2013 Act itself.
No, another is subject to balance like a kind of approval. And another thing, my lord, this is the Honorable Division Bench has gone into that principle of law, whether if it is a judgment by reference or it is a by incorporation. That was discussed here. So through two ratios. First initiation, then my lord, the whether 2013 Act, why it is not applicable? Because my lord, it is my lord the legislation by incorporation, not legislation by reference. These are the two ratios in this judgment. And here it is, my lord, I am showing that. My lord, kindly come to page 179. Two ratios are there, my lord, subject to my lord's again kind approval.
Yes.
My lord, 179, paragraph 14.
Yes.
Because Honorable Single Judge, both the court held that it is a legislation by reference, not legislation by incorporation. If the legislation by inference is being held by this, then I have got nothing to say. Because here, my lord, incorporation of an earlier act into a later act is a legislative device for the sake of convenience in order to avoid verbatim reproduction of the provisions of earlier act into the latter act. Once the incorporation is made, the provisions of incorporated statute become an integral part of the statute in which it is transferred, and thereafter there is no need to refer the statute from which incorporation is made, and any subsequent amendment in it, it has no effect on the incorporating statute. Now, my lord, next, offshore holding that held. All these provisions show BD Act has provided for a complete adjudicatory process for determination of rights, and only in regard to matters which are not specifically dealt with in BDA. Reference to Land Acquisition Act in terms of 36, I have already shown that terms 36, has been made. For example, acquisition of land and payment of commission. This also a pointer to the being a self-contained code. Applying to the above principle of the facts, it will be clear the provisions relating to acquisition like passing an award, payment of commission, legal remedies available under the Central Act would have to be applied to the acquisition under the State Act. But the bar content in section 611A of the Central Act cannot be made an integral part of the State Act, as the State Act itself has provided specific time frames under which various provisions as well as consequent default, the same as does not admit such inward. The sequel to the above principle is the BD Act has already been held to be a valid law. This is, I am not done. Yes, my lord, section paragraph, then kindly turn over the next page, my lord, page 180, my lord, paragraph 16. In Eleo versus Anusua Bhatt, this court was considering an identical question. There it has been held 11A of the Act and Section 24 are not applicable for acquisition under KIDAB Act. It was held, having regard to the resident data for non-application of the old LA Act on the parity of the provision of 24(2) of the new Act, making Section 11 would obviously be not applicable. We would like to refer the judgment and state of MP such as on this behalf for the following provision, where a subsequent act incorporates provisions of previous act, then the borrowed provisions become an integral and independent part of the subsequent act, are totally unaffected by any repeal or amendment in the previous act. This principle, however, will come in the following cases. Well, these are the principles, it will not be applied, but will not come on this that. So, my lord, now, my lord, kindly come to the BDA, my lord, the submission made by the senior counsel at the material point of time. No, that the hearing was not done. Since hearing was not done as per section 4A of the LDP Act, so possession is held to be illegal. This is the point he has taken, my lord. He cannot deny that. Now, my lord, kindly see, this is very why I am searching for that, because first LDP Act, this is the first time LDP Act has come into effect, 1948.
That judgment, you give back his lordship's copy.
Oh. LDP Act প্রথম যে first যে gazette notification.
Yes.
My lord, this was the first. 7th October, my lord, assent of the governor, my lord, at the top. 7th October 1948.
Yes.
My lord, kindly come to 4, section 4. There was no section 4A at that point of time.
Yes.
No 4A. Now, my lord, kindly come to 7, section 7 and
that Niladri Chatterjee reported in 2017 for CHN Cal 451.
Oh.
I have, for your lordship's convenience,
I have already that
reported.
made it was reported, but right now I cannot recall. Could not recall.
2017
Thank you very much.
2017 4 লিখে নিন।
Thank you.
আমার কাছে লেখা আছে, আমি এখানে
2017 for CHN
CHN.
451.
Yes.
I remember, but today, every day he's shifting his stand.
No.
That's the difficulty.
My lord, I have learned from Mr. Sir Shoktinath Mukherjee. I actually, he just made an advice. I think it is a
Change your
treasure.
stand every day.
It is a treasure because you just think out of the box.
Yes.
And critical thinking has to be there. Otherwise, you will not get promotion. I should say.
Provided it does not
Yes.
end up to be a jack in the box.
Yes. My lord, kindly see, my lord. Then, my lord, there, admittedly, the gazette notification first, it was published 7th October 1991. There was no section 4A was there. Kindly come to section 6, section 7. My lord, section 6, 7, there is an urgency, my lord. In case of urgency, my lord, kindly see. In case of urgency, if in this section 7, my lord is looking.
Section 7 is
No, I am in earlier act. I am saying whatever is there in the earlier act.
that is also there in the present act, section 7.
Section 7 is there.
Same.
And same. That is that I am
not there. 4A
same. 8, same. At that point of time, vesting was because at that time provincial government was that. Now it was, my lord, amended in the state.
Yes.
My lord, now kindly see, kindly compare with the thing with the, my lord.
What thing?
With the, my lord, the
scheme of the act was the same, Mr.
scheme of the act is same.
Section 4 notice first, then section 6 notice.
Section 6, 7, my lord, yes.
These
My lord,
were
kindly
there.
see. My lord, kindly see. My lord knows that in section 17(1), my lord, in the same date, section 4 as well as section section.
So you said that point of time
17(1),
it could be done.
it could be done.
So what would be the distinction between a section 4 and a section 6? What would be the purpose of a section 4 notice?
My lord, section 4 notice,
objections
my lord, kindly see. Section 4, if it is an if there is an urgency, because section 4 is an initiation. Not what I mean to submit, that without section 4, 17(1) cannot be invoked, but simultaneously it can be invoked.
What would be the purpose of different sections then?
My lord,
Could be only one section for the notice.
my lord, this is, my lord, kindly see. This is section 17(1) in the Act 1, the now repealed, is a urgency clause. And there, my lord, I can show so many, my lord, documents that in the same date, section 4, because it is an initiation, has to be read with section 17 and 17(4). I'll show so many documents. My lord, what I am on here, my lord, 4A, my lord, at that point of time, when the notification was issued, my lord, that section 4A was not there. And my lord, kindly come to which I have handed over this this copy of the LDP Act. My lord, got it?
Yes.
Yes, my lord. Kindly come to 4A. My lord, before that, 2 is inserted, 4A when it was, my lord, kindly come to now the section 4A. My lord, got it? 4A. In front of 4A, 2 is there. 2 is incorporated now. 2 means when the amendment has come into effect. Now, my lord, kindly come to the last portion. 1, the first 1 has to be read. Otherwise, the EBIT is actually the same as earlier one, the first one.
EBIT means that.
Yes. EBIT means that I have checked it. My lord, kindly see the words or other relief.
Yes.
Revenue officer of the district or omitted by section 3 of the West Bengal Land Development Planning Act Amendment Act 1955, West Bengal 23 of 1955. Section 4A 2. Kindly see. Section 2 was inserted by section
1955.
1955.
Say that. That is
yes. No, my lord, I have to show, my lord, that yes.
We have seen.
Yes. Now, my lord, kindly come to the very material thing. Kindly come to section 8. So far as they be applicable.
In your case, notice was given when? These notices?
1951 or 50, something like that. I will show that. I will bring that all records.
Before 55.
Before 55. Yes. And before 55, position was handed over. Nobody's case. My lord, now, my lord, kindly see the section 8. Section 8 of the, my lord, that is the this
new or old?
New. Kindly, only I will point out so far as they may be applied. Likewise, 36 of BD Act.
Yes, that you have seen.
Yes, but after, I'll show, my lord, to what extent, my lord, I'll show that 11A, it is, my lord, kindly see, after making a declaration under section 6 of the state government may acquire land, thereupon the Provisional Land Acquisition Act 1894 in this section referred to as the SAL so far as may be applicable. If any case the state government so directs, the collector may at any time after declaration is made under section 6 takes position in accordance with the rules, any bill, beer, tank, waterway, any waste in respect of declaration is made, and thereupon such land shall vest absolutely in the form of government. Now, my lord, kindly see, in determining the amount, what is incorporation? Not by reference. In determining the amount, compensation to be awarded for the land acquired in pursuance of this act are market value referred to. First of subsection 1 of section 23 of the said act, means, my lord, 1894 act, shall be deemed to be the market value of the land on the date of publication of the notification under subsection 1 of 4 of the notified area in which the land is included, subject to the following condition. That is to say, if the market value, my lord, I am not skipping over, then, my lord, 2 is important. When the amount of compensation has been determined, got it, my lord? Clause 2. When the amount of compensation has been determined under subsection 1, collector shall make an award in accordance with the principles set out in section 11 of the said act. And the amount referred to in subsection 2 of section 20 of said act shall also be included in the award. So, my lord, even if the central act is amended afterwards, that does not frustrate this act. That is the ratio of the Honorable Apex Court in this case. Now, my lord, go back to the, my lord, the And my lord, kindly see, my lord, I have gone through the records. Record is in such a condition, even my lord will. My lord, records can get up. My lord, I think 1951, 2013, more than 60 years. And the father has accepted that 80% and saying that the 20% to be given. Fortunate enough, because of my lord, I have gone through that records and I have got it.
Because of Mr. Bera.
Because of Mr. Bera. My lord, this is very precarious condition, my lord. And my lord, whatever my lord I have got, my lord, that is what is troubling me at that point of time when I have made my submission, that page 16 withdrawn 4 point out of 12.40, 4.04, that is troubling.
You have corroborated the documents which were placed before us are actually there on record.
Yeah, are actually there on records, but two documents, my lord, three documents I have to rely because there are no such records. But because it was not taken into consideration by the honorable senior. But my lord, the page,
that bunch you handed over to us, those are there.
Yeah, it is there.
So all papers in the bunch are actually in the records.
It is apart from that, three documents I have to rely upon.
That is not in these records.
No. In these records, that is the original records, yes, but not in this application.
No. Those are in the original records. That is what
original records. Yes,
those are there. If necessary, Mr. Bera will be given an inspection of the original records.
Yes, right now we can inspect that, but I will show, my lord. Kindly consider one thing. I will show one thing, my lord.
That will take care of the thing because
is 16 page 16 of my stay application. It was cancelled by your notification.
Yes.
And 51, my lord, I failed to understand why, if the 51 at the time of position was taken, why
cancelled? Exactly.
Why 52 another position? I failed to understand because, my lord, I know all those officers are corrupt. These all of them, some of them.
Two of them are sitting behind you.
No, they are actually, I think they are the honest.
They don't look to be corrupt.
That's why, my lord, I have got good faith on them. My lord, kindly see, this is, my lord, heavy.
Not necessarily all are corrupt, but Mr. Sengupta, there may be certain communication gaps also.
No, my lord, I know, my lord, I have, my lord, knows
maybe
that.
You know the corrupt officers.
I know, because the department, my lord, I am accounted with that excise, essential commodities, land, and revenue. Well, I should not say that, but my lord, most of them.
Come back.
Yes, come back to. Yes, well, record shows position it at actually I have annexed 24 on 20 position was taken on 24/5/52. But however, record shows, my lord, that it was taken also on 51.
You must have been surrendered in between. Who knows?
51. 51 position was taken. Well, I'll show that this is very. না এটা document disclose হয় এটা সত্যি কথা and my lord, fortunately I have found this. It is very difficult to found. This is the land in, my lord, the estimation, because after acquisition,
keep it with you.
Yes, that is land total 8.73 acres. হ্যাঁ এগুলো সব দেখবেন স্যার, এগুলো আস্তে আস্তে দেখবেন আপনি তো। আচ্ছা দেখবেন এটা কিন্তু একদম অরিজিনাল, কিছু ছেড়ে ফিরে একাকার হয়ে গেছে। না খেয়ে ফেলবেন না, অনেক সময় খেয়ে ফেলেন। আমার একজন ছিলেন এখনো আছেন, খেয়ে ফেলেছিল। যা পেয়ে এখানে আছে ইয়েগুলো আছে, এগুলো সব ছেঁড়া ফেরা। ও আমি আর এই যে টাকা ফাঁকা সব নিয়েছিলেন 80% এই সময় 1956 এটা ট্রায়াল করে ডিসক্লোজ হয়নি তো কি করা যাবে? তো জজ সাহেবের কাছে এসেছি তো আমি ওই জন্য। আরে my lord will decide whether 2013 Act is applicable or not. Even if my lord assuming but not admitting is not there. Only on the basis of two issues, my lord, I have a case subject to my lord's approval, kind approval. আরুন দেখে নেবেন, আপনি সব দেখেন, আপনাকে দিয়ে দেব।
Questions whether it has lapsed and whether
Yes.
2013 Act will apply. These are
Yes,
the main.
this is the case, my lord. My lord, দাঁড়া, আরেকটা কোথায় গেল? আরেকটা ফাইল কই? ও এনারা যে দুটো ফাইল এখানে রাখলাম, আরেকটা কই?
They have given everything to it. You
এটা
must have missed.
হ্যাঁ, দেখবেন এগুলো আমি কিন্তু
Don't mix it up with your papers, own papers.
একদম।
Then your papers will be a part of
এটা
the record.
স্যার এটা দেখবেন ক্যান্সেলেশন অফ নোটিফিকেশন, ওই যে ওইটা
4.04 তো
হ্যাঁ, যেটা 4.04 এ ক্যান্সেল নোটিফিকেশন, এটা হচ্ছে না, এটা স্যার দেয়নি। Yes, my lord. Kindly see, this is the thing I have got. That is 19, but no original. But my lord, 1950, my lord, kindly the last 20th November 50 position was taken. My lord, and the land schedule is there. But my lord, original I didn't find. I didn't find.
This is a part. This photocopy.
This is yes. My lord, the
That's in your
3065, 3067, 307.
These are on the in the original records. These were there.
Yeah, these words they are there. But my lord, the original, my lord, the original I didn't find. I think it is not original, because kindly see.
It's not original.
It is not the original, because kindly see, the original was such a condition that it was misplaced or something like that. But the my lord had taken into secondary evidence. If the original is lost, my lord knows that. I did not remind to my lord. My lord, kindly consider one thing apart from that. This is very important. That's why, my lord, I am beseeching to my lord that fortunately
you have given copies of this to us. No, you can
no.
give just photocopies to us.
My lord, this
photocopy.
Kindly this thing, kindly see. This thing, that is the. This is the father of that writ petitioner's hearing. Kindly see the date.
Some amount of compensation. That is 80%.
80%. Kindly see. That means I could have understood that person concerned.
These are not. None of these are part of the records.
No, the part of.
Then how can you look into it? You file a formal order for 27.
Order for Rule 27. That I will. But my lord, apart from that, but I want to show, my lord, that yes, I know.
Or at least since these are the part of the records, you give copies to Mr. Vera.
Yes,
take
yes,
out
yes.
copies.
My
And
lord,
give
kindly pass on.
Request your officers to take copies of these, and no, you complete your arguments now, and
Yes.
the remaining portion we may have later.
Yes. My lord, now, my lord, kindly consider first, my lord, the.
Mr. Sengupta, before proceeding, please come to section 8 once more.
Yes, that's why I am coming.
Yes, just come there.
Yes.
Now, up to section 4 and 6, there are two notices.
Yes.
First notice is, yes, that these are required for public purpose such and such.
Yes.
Section 6 is after section 5, when
Yes.
the state government directs the authority to
Yes.
development scheme and all,
Yes.
then section 6 notice, yes, we need this for the purpose of execution of these schemes. That declaration is made.
Yes, my lord.
And under 6(3),
আমার যে এফিডেভিট আমার যে কপিটা কোথায় গেল? কোথায় সব চলে যাচ্ছে? আরে স্যার রিভিউ এর যে স্টেটা এটা কোথায় গেল? হ্যাঁ? আরে সব কপি করে আপনাকে দিচ্ছি। দাঁড়ান আমার স্টেটা কোথায় গেল?
The বৈঠকখানা style of argument.
এটা যে এইমাত্র যে রাখলাম কোথায় গেল? ব্যাপারটাই বুঝতে পারছি না। দেখি ওটার সঙ্গে কি kindly come to page 16 of that.
So you please kindly come to the act first.
First act. My lord, section 8 I am reading.
Yes. Section 4 there is a notice. Section 5 there is a scheme and all these
yes.
all these inquiries are made and all.
Yes.
Report. Section 6 there is
Section
a scheme,
7
public purpose.
And section 7 urgency clause was
6,
invoked.
7 also there.
Yes, invoked.
Yes.
And now my lord, kindly come
7
to
only
8.
says that without a scheme you can invoke 6.
No, even without or within. Kindly see. I am reading. My lord, kindly see. Even if my lord, in respect of such notified or any part of the has no development schemes has either been prepared or sanctioned under section 5. So even if development scheme
without section 7, if you proceed without section 7, then in any event you have to comply with 5.
Yes.
4 comes, then 5, then scheme
6, 7.
Scheme 6. If you comply, if you invoke 7, then what is dispensed with is without any development scheme under section, you can skip 5.
Yes.
You can directly take after 4, you can take position under section, you can take steps under section 7.
Yes.
That is what you have done that. Section
yes, I have done that.
You say
yes.
you complied with.
Yes.
Now, 7 says in cases of urgency, if in respect of any notified area, preparation of development scheme is likely to be delayed, the state government may at any time
make a declaration under section 6. Yes.
So 7 only dispenses with this scheme being formulated under section 5.
If it is not formulated.
When 7 says that you have to publish a declaration under 6.
6
I takes you back to 6.
6 I have got.
6 is a declaration.
Yes, I have made.
Now 6 is not the acquisition for completion of the acquisition.
No, never.
No.
Never.
Achha, come to section 8 then.
Kindly
you have section 7 means
yes,
urgency,
yes. Even if there is no development scheme,
there is urgency, only scheme can be dispensed.
So
let us see.
Madam, kindly see. Because
let us come to 8 now.
Madam, kindly see. After making a declaration under section 6, state government may acquire the land and
therefore, let us stop there. Yes. After making a declaration, section 6 declaration is an absolute necessity. After that, the state government may acquire the land.
Yes.
Achha, now this language is very crucial. And thereupon, the provisions of Land Acquisition Act shall, so far as may be, applied.
So far as may be.
Now, so far as may be is there.
Yeah, applicable.
Now, when this thereupon, does it mean thereafter? After the land is acquired, then provisions of land acquisition?
No, after making declaration.
After making declaration?
Yes.
So immediately after making declaration, then whatever provisions are there, similar provisions in the Land Acquisition Act become applicable.
No. My lord, 8 is, my lord, only what I have shown to my lord, only as per this act, only regarding award and compensation to be governed by the LA Act 1890.
Now this, therefore, after the publication of section 6,
yes,
and before an award is passed,
yes,
under section 11,
yes,
you know what happens? The LA Act is not, there's a vacuum of law.
Yes, my exclusive submission would be, my lord, the issue is before my lord that if there is a vacuum, assuming but not admitting.
No, what actually happens?
Happened that after declaration, my lord, kindly see, the position was already taken over. It was not handed over to the, it was not returned back to the.
What is the provision for taking possession under these sections?
8. My lord, kindly see.
Please read 8.
After making declaration to may acquire land, thereupon the Provisional Land Acquisition Act referred to as so far as may be applied, if any case, kindly see, if any case The state government so direct collector at any time after declaration is under section takes position in accordance with the rules
That
of
is a special case. If the
That
state
is
government so directs.
direct.
If
So-
the state government does not so direct, therefore this A presupposes that possession had not yet been taken.
Yes.
At the stage when section 8 comes in, possession has not yet been taken.
Yes.
A says yes, if state directs, possession will be taken.
Yes.
And thereupon the land shall vest absolutely.
Absolutely.
You are saying, are you saying that you took possession under A?
Yes, I am saying that 19 because my lord, at that point of the record was not with me. I frankly confess, my lord. But I have seen that so far the dogs which are under consideration of before my lord, some of the dogs are, my lord, the position was had already been taken over in the year 1950. At the time of 51, that after passing of this
So if A was not invoked, then what happens?
4A, because why I am submitting? Because 4A, my lord, kindly
No,
consider.
if 8A is not invoked, if possession is not taken.
His position is taken.
If it is not taken.
Oh, what will be the consequences?
Complete a sentence,
Yes, sorry,
at least, Mr.
sorry,
Sengupta, you
sorry.
speak too much.
Yes.
8A, if 8A is not invoked, then what happens after section 6 declaration? According to you, what act will apply, what will happen? Doesn't the LA Act apply from that stage?
Suppose section 8 was not invoked, assuming.
Section 8 has to be invoked. Section 8A is not invoked.
Section 8A, my lord, it has come into effect, my lord, kindly see. If any case...
8A says, if any case the state government so directs, the collector may at any time after declaration take possession.
Yes, at
State government
1955.
does not direct. It's optional. It's in the proviso.
Yes.
If it directs, then it takes place.
Yes.
If the state government does not so direct.
What will be the cause? Yes, I followed.
Provision according
My lord,
to LA Act will
according to me,
LA Act
the
has to
LA Act, my lord, whatever provision is inbuilt in the LA Act is to be applicable.
applicable. Now, therefore, see 8(1)A, that's why you are saying it's akin to 17(1).
Yes.
So we draw parity there.
Yes.
If it was an LA Act acquisition,
Yes.
then 17(1), whatever would happen if 17(1) was invoked, similar thing happens if this 8A is invoked. So therefore, you say it cannot lapse any further. It vests.
And my lord, apart from that, my lord, initiation, if it is initiated,
That is on the
yes.
2013 Act.
Yes, yes.
That's different.
That is different. But my lord, the issue, my lord, which comes down.
Vesting completed.
Yes.
And like some judgments, it has been stated that then the proceeding continues only for the purpose of compensation
And our yes,
And
all right, all right. This is absolutely, my lord, is absolutely right. But facts, record shows that position was taken in the year 1951 because I have to, my lord, file an application or my lord.
Because 8 was there.
Yes, section 8 was there, my lord.
So
And my lord, kindly consider one thing, my lord, that is very vital, that the 1956, my lord, as per the fact of the case, my lord, I think.
Have you given us a list of dates? Can you just prepare a very short?
I will prepare the list of dates.
3-4 dates.
Yes.
The relevant dates.
My lord, kindly consider.
Papers also give some other date.
Yeah, kindly consider for the first time.
Yes.
On the basis of the court's order, my lord, kindly come to page 32 of my stay application. That remaining 20% was paid, and the share is mentioned, and plot was also mentioned. Kindly see. This is for the predecessor interest of the petitioner respondent's hearing.
So at the time of possession, 80% was also
given. Yes. My lord, kindly consider. Now, my lord, go back to that, my lord, which my lord, order 41 rule 27. That the person concerned, the
payment was made long thereafter.
আরে ঠিক আছে পেমেন্ট পেড এটা তো লেখা আছে স্যার এটা তো আপনাদের আমার
document
my lord it is paid
55 when
my lord that is after the passing of the repetition that is WP number
records you were handing up something some sellotape document
documents just a minute my lord
others later
এই দেখুন তো এই টাকাটা কবে দিয়েছেন এই যে এদিকে আসুন একজন ওর রেকর্ডস থেকে বার করুন
you had handed over a copy of a sellotape letter by his father.
এর মধ্যে হতে পারে না my lord this is the file where
54 page 28 of the stay petition.
you had handed over today right now from the record some documents, some sellotape letter written by their father. Who received some amount, that document. And I've received a part of the compensation.
Yes.
What is that? See the date of that.
না এটা অরিজিনাল আছে এখানে অরিজিনাল আর নেই তো স্যার দেখবেন এটা অরিজিনাল আর জেরক্স হলো ওটা তো আর আমাদের কিছু নেই Yes, my lord.
What is the date?
12 February 1957.
So much later.
80% payment was made on 12 February 1957, and the person concerned who was alive at that point of time, up to the 2010 when he expired, that the person concerned has not come forward challenging this acquisition proceeding.
Like in section 17, there is
Yes.
a provision that 80% has to be paid.
Yes.
Here there is no corresponding provision.
Corresponding provisions, but because the urgency clause is there,
Urgency is different.
but my lord, this is my lord,
there.
yes, but my lord, my lord, kindly consider, because after all, I am taking position
But this
without making any award.
very draconian then.
But kindly consider section 6, 7, and if my lord it's in a whole, my lord, kindly consider one thing, 4A. 4A is like 5A of the Act 1. 5A, that is the hearing is to be given. If the 17 one is being invoked, then 5A is not applicable. I am saying, my lord, the
5 is on a different footing. A scheme is to be formed.
no, that I am not talking about the section 5A of this act. I am talking about section 5 of the 1894 act, where the hearing, like 4A, hearing has to be given, objection has to be sought for.
We are proceeding on the basis of your submission that at the relevant point of time, 4A was not there. This
4A was not there. That is
this
admitted,
the
yes.
scope of hearing. That we can appreciate, yes.
Yes.
Very well. That was not there.
Yes.
Even
And
then,
yes.
then also section 7, 8 were the same.
Yes.
So even if it was an acquisition under section 7, you had to make a declaration under section 6.
Yes.
And if the government so directed, collector may at any time take possession. Similar.
Yes.
Now there is
And my lord, declaration, my lord, kindly come to page 19, my lord, where again further declaration, I do not understand, my lord, my lord, however, my lord, it is there, is part of the records I have to point out. My lord, kindly come to page 19. Kindly see 7.89 acres. My lord, kindly see. I am reading. 7.89 acres, my lord, declared as such and such 19th May 1950. My lord, go back to my lord 1950. My lord, the section 467. My lord, kindly see part 1 of the Calcutta Gazette dated 1st June 1950. Not that it was published on the same day, but Gazette notification on 1st June 1950 is needed for public purpose, namely for the purpose of settlement of immigrants. Why? Because they have invoked the urgency clause because of the fact immediately resettlement has to be there, has to be made, because they have come from Bangladesh. So, my lord, for the settlement of immigrants who have migrated in the state of on account of circumstances beyond their control, it is hereby declared that land is needed for appostate public. The declaration made under the provision of subsection 1A of section 6 of the West Bengal Land Planning Act, to whom it may seem. A plan of land may be inspected in the office such and such. My lord, the land and in question, my lord, are there. And my lord, what my lord, made humble submission that there is no question of taking back another fresh position, because position has already been taken, and assuming but not admitting that if it is withdrawal is permissible under the law, the my lord, kindly consider I need not take further position of the land, because position has already been taken over in the year 1951. Yes, there is no question of, my lord. However, my lord, whatever is there, my lord, I have to make my submission on the basis of that. But my lord, here, my lord, 2, 3, because another thing most interesting, my lord, that the 1957, the original owner, my lord, has accepted that acquisition proceeding is right. But after 2013, that same my lord, the Honorable Division Bench has said, why you are sleeping so tight over this matter, As soon as you get the 2013 Act, then you have filed this application. There is a complete waiver, because my lord, principle of waiver does not apply to the state, but it is applicable to the person concerned in whose interest the right has been created. My lord, kindly come to, my lord, the page of the, my lord, 2028 SCC, my lord, I already handed over. That is the Constitutional Bench judgment, page, my lord, doctrine of waiver. My lord, this has to be settled. Unless, my lord, there has to be, my lord, kindly consider one thing. There is a huge amount of money, not more, less than, my lord, 10,000 crores or something like that. They will come in one fine morning and file an application, and obviously the officers are happy. Some of the officers, they will supply that. But after all, it is a public exchequer. Because it's a public money. Now, kindly consider the judgment I have relied upon. 2028, I have handed over that the Indo development, the constitutional bench judgment regarding interpretation of section 24. Even, my lord, assuming but not admit, even by interpreting section 24 of the 2013 Act and read with section 140.
Section 6, that notice is, what is the date of that notice? Section 6. Where you just please, page 19.
19, yes.
Let us see that once. That says,
the land has come down from 12.40 acres to 7.89 acres.
But there is one difficulty. There is one difficulty here.
8 November 1979.
The difficulty here
8 November 1979.
No. 19th May 1950.
Yes, it is mentioned.
Now, if you kindly see, if you come to the amended act, this LDP Act.
Yes, 4A.
4A.
1955.
Not 4A. Not 4A, come to 6.
1A
has been inserted in the year 1955.
55, yes.
Right. Now, there is a distinction between 6.1 and 6.1A. 6.1A is
where the state government is satisfied,
the government is satisfied
after taking the report submitted.
Please, 6.1 is that if it is needed for any scheme under section 5.
Yes.
1A is needed for public purpose under section 2.
Yes.
D1, DI. So there's a distinction between the two. There can be two sorts of 6.1 notices. One is 6.1 and one is 6.1A.
Yes.
6.1 is under scheme.
Yes. Under scheme.
1A is only for public purpose.
Yes.
Now you say in your at page 19 in your 1979 notification, section 6 notification.
Yes.
That on 19th of May 1950 it was
79 and 1950. Yes, referred to. Yes.
Yes, it was taken for public purpose, namely for the purpose of settlement of immigrants. But Mr. Sengupta could not have done that because in 1950 6.1A was not there.
Yes.
It could only be under 6.1.
I follow. I have understood.
So therefore, this declaration itself quotes is absolutely contrary to law. This declaration says in 1950 it was taken for public purpose.
Yes.
For accommodating immigrants.
For total area about 12.40.
Whatever.
Yes.
Now public purpose is under 2D. 2DI is settlement of immigrants.
Yes.
And only section 6.1A, under section 6.1A, that notice could have been published for immigrants purpose.
Yes.
But 6.1A was not there in the statute in 1950.
1950.
How could it be there?
Yes, what I am on, my lord. I followed my lord's query.
That notification was bad.
My lord, that notification, my lord, kindly consider.
You're trying to cover up in 1979.
Yes. My lord, kindly consider one thing, my lord. Even if the learned honorable single judge has not taken.
Forget the learned single judge.
Yes.
Forget us.
Yes.
How could this notification, this declaration, then this declaration under section 6.1A is bad?
Sections, even if it is a bad one, assuming but not admitting. But my lord, the compensation is to be governed by the process to be governed by the LA Act, 1894. 2013 Act is not at all applicable under no circumstances. But kindly come to the main issue, whether 2013 Act is to be applicable or not. Given the facts and circumstances, even if for arguments assuming, but on this is an illegal one. But possession.
No, Mr. Shengu, I was wrong. Section 4 covers public purpose also. So
Yes.
it might very well be that in 1950 the notice was given under Section 4 for public purpose.
Yes.
61A notice is in 1979, so it is after this amendment.
Yes, after this amendment, my lord, it was.
So then this is the notice which has to be looked at.
Yes.
Your 50 possession and all those go then.
Good. Even if it is there, now my question comes up, then how I can proceed with this acquisition proceeding?
After this LA Act.
Yes. Whether I will follow the provisions in 2013 Act, whether I follow the provisions in 1894 Act. This is the main issue.
From where do you start in the LA Act? As per 8.1, according to you?
8.1 according to 1950, because 1957 it is accepted by the.
When did you take possession under Section 6?
1951.
8.1A?
1951. That another is 1952, but I have shown 1950. Sorry, that is the malad. That is the original one.
Sorry, you could not, because
1951.
If your notification under Section 6.1A is in 1979, then in 1950 you could not have taken possession in terms thereof.
1951.
Because 8.1A says at any time after a declaration is made under Section 6, you can take possession.
Yes, after that I have taken 1951.
Section 6,
November.
Section 6 is of 1979.
Well, 1951 November. I have shown that. Well, just a minute. Well, I will show the original.
No, 1979 is here.
1979, this is another. Yes.
1979 was the Section 6 notification. You
Yes.
have relied on this.
Yes.
If 1970, the Section 6 notification is in 1979, possession has to be after that, even under 8.1A.
Well, may I submit kindly look at another angle. Well, if the position, well, kindly consider that section, page 14.
19.
No, page 16 of the stay application, my lord, if it is cancelled later on, my lord, the position I could have understood that after withdrawal of that, page 16, after withdrawal of that certain portion of the land, the position was handed over to the writ petitioner at that point of time. As the records suggest, 1957, the petitioner, the owner, original owner, he has accepted
that for the acquired portion.
Yes. Now, 2013, after lapse of 60 years, due to, I should not make any submission on that. But now after 60 years, they are coming. And on the very date, fortunate enough, this original handwriting and original person.
No, those have never come on record. You have
No,
never
no
proved
record.
those documents.
No.
Don't know whether those are original or not.
Now, my lord, kindly see.
It was the
That is what we are saying.
They have, that's why I say they did not disclose it.
আর সেটা তো যশ সাহেব বলেছেন তো
আবার বলতে দিন, in the stay petition, they have not annexed the affidavit in opposition used by the state and the reply used by us. Therein they say we have award has been passed, we have taken away the money that has been considered by the trial court. Those are there. They could have been annexed the affidavit in opposition with the stay petition.
My lord, sorry to say, my lord, I have instructed my officers, you anyhow, then I will make a complaint against you. Anyhow, to give or hand over the original copies. Whatever is there, I will see. And my lord, most funny thing, my lord, I cannot disclose, my lord, before this honorable court.
These are the opposition.
My lord,
I am handing over.
Okay, don't hand over like this.
আমি তো
This will
বলছি
happen that. Could have
আমি
handed
তো
over to you.
বলছি তো যে এটা নেই, আমি কি বলছি না, but my lord, sorry to say, my lord, after all I got this gentleman, and my lord, in the office, that is the Xerox, the original records which was kept lying, my lord, that my lord, is nobody, actually 1951, nobody is, my lord, it is more than impossible to collect those. However, the person counter has come and handed over this original document, some of this, and it is relevant. What is relevant? 1957, the original owner has accepted that. There was no challenge. Even he say, with objection, I am receiving.
Mr. Sengupta, please come to section 48 of the LA Act.
Yes.
Your
48 of the LA Act that did
Your questions will be answered there.
Yes.
And that will also explain why their predecessor took some compensation in 1957.
Yes, yes, yes. I am.
You have followed, we have not followed. Please come to section 48.
48, yes.
Please just kindly read out section 48.
Except in the cases provided for in section
Caption,
36.
read from the caption, Mr.
Yes, completion of acquisition not compulsory, but compensation to be awarded when not completed. Yes, I admit.
Read on.
Yes.
You don't have to admit that statute.
Except in the case provided for in section 36, the government shall be liberty to withdraw from the acquisition of any land of which possession has not been taken.
Please continue. Please continue.
Whenever the government withdraws from such acquisition, the collector shall determine the amount of compensation due to for damage suffered or owner in consequent notice of any proceeding thereunder, and shall pay such amount to the person interested together with all costs reasonably incurred for in prosecution of the proceeding under relating to the said. Provision part 3 of the said shall apply as payable may be to the determination of compensation.
Now please come to page 16, which you are placing. Just read page 16 notification.
Yes, my lord.
Just read out.
Yes, yeah, I know.
You know, but
17th
we don't
March
know.
1951. 17th March 1951. Well, kindly see. In exercise of the powers conferred by Section 8 of the West Bengal Land Development Planning and reduced Section 48 of the Land Acquisition, his governor is pleased to withdraw from the acquisition proceeding of 4.404 acres, while others remain out of 12 forms. Well, now, let us come to a conclusion. Kindly consider. This was cancelled, and the original is
saying on the first day that how you don't know how it was withdrawn.
Yes.
In the section 48, it was withdrawn.
But my lord, kindly consider if
withdrawn from acquisition.
If my lord, kindly see if the position is not being taken. Here, my lord,
it's a matter of calculation. How much portion was taken and how much was withdrawn.
Yes, so that my lord calculation I will hand over
something by 12 point something minus 4.04.
9 point something. That is there, my lord.
7 point something.
7.83. Koto jane 8 point na koto. No, it is there. I mean, 8.73 acres.
So that was then retained by the state.
Yes. And my lord, not everything position. What I mean to submit, respectful submission I am making, that the authority, it was not their case, and it is not the case that the after withdrawal that the position was the so far land in portion that was handed over to the petitioner at that point of time, 19 in favor of the petitioner. That is the original order. As it would be evident from his letter.
What is this nonsense in page 18 then?
Nonsense.
Page 18, what is this nonsense then? Governor is pleased to cancel so much of the notifications such as under section 4. Under which provision?
No, only point that is not related to his case. Well, point 86 and plot number is there. He is not come with. He has not come with. But our my lord, it is absolutely funny. I should say. That is point 86 and lands definition and land sports the plot number 3067.
3067 is not.
Yes, 30 is not the subject matter.
Not his.
No. But however, it is absolutely illegal. I should say. আরে বাবা আমি তো বলছি আপনি তো
it is not his property. Then why have you annexed it in the first place?
My lord, actually I was under the impression that I can cover up this lacuna, I should say, by making a submission which is germane to the instant case. Because I will rely upon that initiation and second judgment, incorporation or something like that, not reference.
So that
2013 Act is not applicable.
So you could not cover up ultimately.
Yes, my lord, 2013 Act is not applicable. First of all, it was not initiated.
No, if this was not regarding their land, why have you annexed this?
It is my mistake. My lord, I should say.
This has no relevance.
No, this is no relevance. Those are no relevance. My lord, kindly now, my lord, kindly the last one. My lord, I am completing my argument. I will show the judgment I have handed over 2028 HCC 129 page. Just a minute, my lord. I'll show the only relevant paragraph. Hey, Indo development, sir.
Sir, Shenmukti should have prepared a chart which portion was.
Yes, I'll
portion was withdrawn.
Yes.
And the remaining.
Yes, I will.
List of dates.
Yes, I'll do.
So you can just bring that.
My lord, I am concluding, my lord, only
Conclude
just
your
showing-
arguments
yes.
on law and then.
Yeah, yes. I am concluding, my lord, then, my lord, I.
Best.
Yes. Only question of waiver, my lord, I will rely upon that the Constitution Bench has taken note of it, that laches, negligence, and my lord, this is not a my lord, it is not hit by Article 21 of the Constitution of India. Because you have the right, you didn't exercise that. You have the right, but you cannot exercise your right. My lord knows that limitation that is squarely applicable here. I have a right. I didn't exercise for a certain period of time. Whether I have no remedy, but I have the right. But I cannot, I am remediless. Just a minute, man. এটা কোথায় লিখলাম 256 এই আরেকটা কোথায় রে বইতে ওটা পার করতে হ্যাঁ দাঁড়া আমি পেয়ে গেছি 353 349 Well, I'm sorry, man. Yes, my lord. My lord, it starts with that laches negligence. My lord, it starts with that from page 340, paragraph 348 of that Indo Development Constitutional Main Judgment.
Yes.
My lord, I am only referring 353 paragraph. একটাই দেখো আর দরকার নেই ওগুলো সব স্যার বলে দিলাম all those judgments were taken into consideration by the Honorable Apex Court, my lord.
Yes, 353.
353, my lord, paragraph. My lord, kindly see, I'm reading. UP Jal Nigam such and such, this court has observed that if a claimant is aware of the violation of his right and does not claim his remedies, such inaction conduct tantamount to waiver of the right. Because a right has been created in a particular person, not I cannot waive, because state cannot waive their right, because it is based on the principles of public policy. So ever, if it is given, the right, if it is given to the individual person, and if they did not exercise and they slept over quite a 60 years, after that they come with an application, I want to get 2013 compensation in terms of 2013 control. This is absolutely over. And the moreover, I will come up with that the copy of that. The owner itself admits in 1957 has taken the money without any objection, and 353 without any objection. But condition 353 tantamount to, in such cases, lapse of time delay at most material and cannot be ignored by the court. In such the constitution of the court cannot go into the stale demands after a lapse of several years. Only I am pointing out, my lord, so many paragraphs are, my lord, were taken into consideration by the constitutional bench. I am only referring this part. Here, my lord, after 60 years.
Mr. Sengupta, according to you, on a composite reading of the LTP Act, now once Section 6 notice is that declaration is made and position is taken, now the applicability of LA Act is limited to the calculation of compensation.
11 and 23. It is there.
Only that.
Yes, my lord, I show that. My lord, that is this one, the latest one.
Yes, yes.
My lord, 8B and my lord,
and 2.
2.
Right.
So, my lord, if the legislation by incorporation is to be applied, if it is applied in my case, then I have a case, because of the fact that 11A, even if any subsequent amendment be taken place in the earlier act, that has got no value so far this West Bengal Land Development Planning Act 1948 is concerned. It will not frustrate the acquisition proceeding. All these are my all sufficient. And one more thing, my lord, sorry, my lord, I'll point out.
And that chart.
It's chart and
which was acquired.
Yes.
And which was withdrawn subsequently, and the list of dates.
List of dates, yes.
Yes.
List of dates. And my lord, one thing, my lord, well, these are my submissions. Well, I do not want to. Well, may I take a glass of water, my lord?
Yes, yes. Anything, a glass of anything.
No.
Yes, Mr. Bera.
My lord, not technical, but to some extent, I will make my submission. I have no problem making submissions. Before the trial court,
yes,
only one point was taken, that the compensation has been paid, award has been declared, compensation has been paid. But actually, our reply was that the chart, that old document which was, so to say, copy of that was disclosed in the affidavit in opposition. And that is not now before your lordships. So I think, my lord, and other relevant documents for which, my lord, no application has been filed, your lordship.
But you, on the last day, you said the records be called for.
Records has been called for. I have no objection.
So we can look into the records
but,
directly. But you did not have any opportunity to rebut.
Yes, without any paper book, if your lordships wants to.
You have already heard the matter.
Heard the matter, then, my lord, I have to, your lordships have to see the opposition and our reply. Which our reply to copy the record. So your lordships kindly.
You can just hand over adequate copies of whatever documents are not there in their application. Because they have annexed some of the documents.
Opposition.
But you give them copies also, and 2 copies for both of us.
My lord, today I am opposition.
Then very well, Mr. Bera, you come back with copies, adequate copies. You have 2 copies of the opposition.
Yes, I have handing over to, I am also handing over to them. Mirror,
Oh, then that's sufficient.
আমাদের রিপ্লাইটা কোথায় গেল? রিপ্লাইয়ের কপিটা মিরর রিপ্লাই ইজ নট উইথ সাফিসিয়েন্ট কপি ওখানে আছে নাকি দেখো রিপ্লাইয়ের কপি করা আছে করে মিরর
This is opposition to the writ petition.
opposition to the writ petition. Mirror, I have got my reply. Mirror, today possibly mirror I have not bring the sufficient copy of the reply, but very well.
পিটিশনের কপিটা কি এটাতেই বলেন আসেনি? এটা আছে? রিট পিটিশন
ট্রায়াল কোর্টের রেকর্ড আছে?
Yes, it's there. Then need not. We can get everything from there.
No,
But there is only one copy.
No, only one copy. Mirror reply, Milor. But very well, Milor. Let me proceed.
Yes, reply one copy, then give to us. The other one of us will look into the original. And if do you have one copy? No, you don't have.
Yes, only একটু ভালো করে. The reply, Milor, I am giving handing over to your lordships, Milor. Your lordships, এটাকে একটু স্টেপলার করে দিন তো, এটা একবার সেলাই করে দিন তো. It is complete, Milor. রাজু রিপ্লাই কি
একটাও মার্কিং করা যায় কোনো অসুবিধা নেই।
ঠিক আছে।
Reply one copy will suffice. The other.
ওটা একটু জসিপকে দিয়ে দিন রিপ্লাইটা অপোজিশন I have given, Milor.
Opposition you have already given.
Not much.
Yes, reply and opposition.
তো ঠিক আছে। Milor, but your lordships has possibly gone through the judgment of the trial court. The judgment of the trial court has held that yes, in the writ petition so many plots were mentioned, but when the writ petition was ultimately taken up for hearing, the learned judge, Milord, relied upon one notice whereby the government.
You can place before us the trial court judgment again, Mr. Vera. That will be easier.
I am not placing just now because the
relevant provisions, the
relevant
portions.
First of all, let me give answer to the points raised by
you. In your own way.
Yes. Milord, whether 2013 Act will be applicable,
yes.
that is
not applicable. Probably that is not applicable.
That will be.
How do you say that?
I will give answer to that subsequently. But before that, Milord, one important question. He has, Milord, if your lordships wants to hear the whether it is a legislation by incorporation or legislation by reference, that makes the provision 11A applicable. If it is a legislation by incorporation, then by virtue of the definition of the law, the other amendments which are brought in the act, which are on the basis of which the act was relied upon, then the other amendments will not come. That is by simple definition of legislation.
Act is very clear, the LDP Act. 8(1) applies, acquires, and thereupon LA Act shall apply.
Then all provisions will come.
Thereupon what provision? From which provision should it start?
From 11 onwards. All. Now, your lordships kindly remember, I will come to that. Your lordships kindly for a moment. If the act says that only 2 applications, as my learned friend has argued, 11 and 23 will apply, then can my right of reference will be taken away under Section 18 of the Land Acquisition Act, if I am aggrieved by the award?
No, but then, Mr. Bira, the consequence will be different. In the sense that if 8(1)A says that after land is acquired,
yes,
then it happens.
Then
not after the declaration. Because
no, I am not saying.
If it is already acquired, then
yes,
the acquisition cannot lapse.
Yes,
so only
I am not
coming for passing award.
I am not coming lapsing, I am coming subsequently. I am only saying applicability of the Land Acquisition Act. Your lordships, the first decision, before 1956.
No, this is very important, Mr. Bira, because before you say that 11(11) everything applies,
yes,
so we have to look into the scheme of the LA Act also. What is the scope of 11(11)?
I am coming later on. First of all, your lordships kindly take the 48 Act, which was handed over to your lordships before 56 amendment, where 4A was not there. Now, today, Milord, I must confess that the declaration and Section 4 can be made simultaneously because 4A was not there. I am confessing to that, no problem. But your lordships have to read Section 8.
And particularly 5 is not involved. Here 5 is not involved.
5 is not involved.
Because it's public purpose, not
Public
scheme.
purpose. 5 no.
So
and,
therefore,
and by virtue of
4
section
and 6
7, by virtue of section 7.
This is Belgoria Express.
No, this is
The
not.
Belgoria Express.
No.
we don't know whether
This is
exactly
a
that's
post
the
for-
shape of the Belgorian.
This is for settlement. No. If it is Belgoria Express,
No.
there
It
is
is
no urgency.
sorry. Another matter I will, because I have read.
So many matters of
Not,
state.
it is
Yes,
not,
because another matter will be coming before my lord that I have read, my lord.
Not for-
This is not.
if it is not for, my lord, the settlement of the
So many
immigrants,
matters, my lord,
then, my lord, the LDP
No,
Act
we
will not
are just trying to visualize the immigrants being settled in the middle of the Belgorian Expressway.
That is for settlement of immigrants.
That is
I am not
possible.
disputing that. I am not disputing that. This is
Immigrants will be settled in the middle of the Belgorian Expressway.
no. Different place.
Belgoria Express, my lord,
Mouja.
I am saying Belgoria Express. Just now I have read because another matter will be coming.
It's a very agree that it is possible.
No. Nowadays, everything is possible. Your lordship.
No, it is not.
Nowadays, in Newtown, what is happening? Everything is they are squatting, and ultimately it is to be
Cannot take judicial
regularized. Very well, my lord. Kindly come to. I am not going to that.
So section 7 is not involved at all then. Section 7, section 6 says there can be two types of this. 4 says notice will say either public purpose or scheme.
Yes.
6 says, 6
Kindly
1 says
one
scheme.
point also we will remember under section 4, any kind of lands, all kinds of land can be.
Not on that. We are saying section 4, it can be either for scheme or for public purpose under 2.
Yes.
6 1 is for scheme.
Yes.
1A is for public purpose under section 2.
Yes.
If there is 6 1,
Yes.
only then there would be necessity of 5, that scheme.
Yes.
And then only 7 would be relevant without scheme.
Yes.
But if it's 6 1A
Yes.
coupled with 4, then 4 and 6 1A can be simultaneous. And not only that, that is for the public purpose immigration.
Your lordship is speaking of 6-1A.
The notification was under 6-1A. 79 notification.
That is, I am coming to that later on. Let there be
everything to do everything later on, then what will remain?
No. Let there be no confusion. Your lordships kindly see. Initial notification is 1950.
Under which provision?
Under which provision? Section 4. The act which was existing at that time.
Yes.
Not after 1956 amendment. 6-1A came into operation in 1956. So we have to look into the act as stand on 1950.
Absolutely, yes.
Then your lordships kindly see, by section 4, all kinds of land can be taken. No problem in it. Then, my lord, since my lord, the 4A was not there, so by virtue of section 7, my lord, declaration can be published anytime.
Section 6.
According to section 7, my lord,
7.
According to section 7, in case of urgency, I am.
No, Mr. Bera, you are totally confusing. Section 4, please come to 4. 4 says collector shall cause public notice.
No,
if it is of the
original at that time, the language of the provincial government.
We are reading that only.
No. Kindly
State was. But after that was provisional government.
Provisional, not
state. That after that state.
Let us not dissipate. Mr. Bera, please understand what we are saying. 4, forget state provincial, all that provincial. Section 4 says the provincial government shall.
Has your lordships got this copy of this?
Yes. Please read follow with us.
Yes.
4.1 says the provincial government may by notification in official gazette.
Yes.
If it is satisfied that any land in such area is needed or is likely to be needed for any public purpose.
Yes.
And collector shall cause public notice of the substance of such notification. It's for public purpose.
Yes.
Now, section 5 says provincial government may direct the prescribed authority if it so things to prepare in a development scheme in respect of any notified area.
Yes.
And thereupon such scheme shall be prepared and accordingly submitted.
Yes. Then section 6.
Now, 2 says, 5.2 says development scheme submitted under 1 may be sanctioned.
Yes.
6.1 says when a development scheme is sanctioned under subsection 2 of section 5 and provincial government is satisfied that any land in the notified area for such scheme has been sanctioned, then a declaration to the effect that such scheme is needed for a public purpose shall, unless already made in 7, be made.
Then
2,
section
come
7.
to 2, 6.2. 2 is applicable here, not 1.
Yes.
2 says the declaration shall be published in the official gazette and shall state the district or other territorial division in which the land is situated, where a plan shall have to be made. Now, therefore, the public purpose, before the coming into force of this amendment, it was public purpose only.
Yes, any land can be acquired.
Any land can be acquired.
Any land can
Till
be
now,
acquired.
yes.
Then section 7 says,
Yes.
if urgency is there,
Yes. Without
no
that,
sanction plan,
no sanction.
no sanction plan.
Yes.
They applied that.
It only dispenses with sanction plan.
Dispensing with. So simultaneously they publish the 4 and section 6. So I cannot take
All
the
right.
point that on the basis of declaration
No,
this
we don't take
possession is illegal. I am not saying that.
No.
Now kindly come to section 8
Yes.
at
Yes,
the, of
yes.
this act. A declaration under section 6 shall be conclusive evidence that the land in respect of which the declaration is made is needed for a public purpose, and after making such declaration, the provincial government may acquire the land, and thereupon provisions of the Land Acquisition Act in this section referred to as the said act shall so far as may be applied. Now this is important, so far as may be applied. So he is saying so far as may be applied, it is incorporating Land Acquisition Act. I am saying so far as it means the remaining sections after section 6 of the Land Acquisition, all provisions of the Land Acquisition Act
Land
will
acquisition
apply.
applies is attracted from when? You see 8. 8 says after making such declaration,
Yes.
the provincial government may acquire the land.
Yes.
And thereupon the
Yes.
provisions of the Land Acquisition Act.
Act will apply.
So does this thereupon mean thereafter?
Thereafter.
If it means thereafter, then it will only happen after acquisition.
Yes.
After acquisition means acquisition is not the declaration only.
No, certainly.
Acquisition is completion of the acquisition process.
Completion of the acquisition.
That means land vests in them.
Land vests in this time, but
if land vests in them,
yes,
then what remains apart from only calculation of the compensation?
Calculation of the compensation. That's right. Then the compensation.
So therefore, there is a question of lapse.
Compensation is to be calculated under the Land Acquisition Act.
Exactly.
No problem.
No.
But if land acquisition compensation is to be assessed under the Land Acquisition Act, then, my lord, what are the provisions regarding the calculation of compensation? First section, after 6, my lord, the measurement, etc., section 7, etc., is there. Section 9 notice is there. All those notices are there. Person to interested persons. Then section 11.
There is some doubt on that. If it's only for the purpose of compensation, why is the question of notice? Why do you give notice if it has already vested in the state acquired?
Very well. Then we will kindly come to 11.
11.
Award is to be declared.
Yes.
Then, if it stops there, then 12 to notice is to be given. After assessment of compensation, it is regarding compensation. 12 to notice is required to be given. If 12 to notice is given, then the person has a right to file reference under section 18. Can it be said under this act that right of reference has been taken away?
Cannot be said.
Just a minute.
No.
Definitely cannot be said.
Cannot be.
Then, if anybody, the reference code will decide the under section.
But 11A lapse is taken away.
That's 11. How that's the question. That's the question I am telling you, lordship. Now, my lord,
if it lapses, then you don't get the compensation because land has already vested in them. Land acquisition is complete, land vested in state.
The land vested.
Now, then if it lapses, what lapses? Only the calculation of the award lapses then.
Then compensation is to be assessed under the land. I am coming to that, mirror.
No lapse. 11A does not operate.
11A, why 11A will apply? There is a judgment of the Supreme Court that has been relied upon. Your lordship may say that the legislation by incorporation or legislation by reference was not discussed, but the Supreme Court in LD.
We are not going on theories in thin air.
Not
the act is very clear.
Judgment has said 11A will apply. Supreme Court.
Judgment, before the judgment, you have to take the statute.
Yes.
The judgment is only a precedent for whatever it considers,
yes,
and not anything which can be derived from it.
Lord.
Here the statute is clear that Land Acquisition Act applies after the acquisition.
Land Acquisition Act, yes.
After making such declaration, provincial government may acquire the land and thereupon the provisions of LA Act. So therefore, what remains in the LA Act? Only calculation of compensation and 12.2 and definitely reference. They are not denying that.
No. Your lordships, kindly see. There is some
you said you agree that land vests and acquisition is complete.
Vesting is coming subsequently after taking possession. Now, my lord, the question is, your lordship kindly see the word may, not acquired.
This may has to be read as shall. Why we are telling you? Unless this may happens, then land acquisition, compensation, nothing comes.
May acquire the land and thereupon the provisions of the land acquisition act will
Exactly.
apply. Yes.
If that may acquire does not have any even land acquisition, you don't have any right to get compensation also.
Yes. So, my lord, this is
this may is shall.
Yes. So what I am saying, my lord, the next subsections your lordships you will see that therein there is no mentioning of section 23 at the time when this was passed. When this was passed. Only this was the language. Kindly see provides 23(2) that was added in 1956. 23(2) was not there.
Not there.
But no section was mentioned.
So Land Acquisition Act.
No, if no section is mentioned.
No section is mentioned by it written and may acquire the land and thereupon provisions of LA Act. So therefore, by necessary implication, only those provisions of the LA Act which relate to assessment of compensation and passing of the award.
Yes. Then question will be, if the acquisition proceeding lapse, then what will happen? Suppose, for the example, for example, suppose
lapse under what provision?
Lapse under if the possession.
How can it lapse? It has already been taken. There is no provision of lapse in this statute in 48 Act.
Yes, that's why, my respectful submission is that the when 11A will come into play. If the
11A, how can it come into play? There is the 11 Land Acquisition Act itself comes into play only if there is an acquisition.
Yes.
So if there is an acquisition and vesting, then 11A, by virtue of 11A, there cannot be any time limit for that. Because time limit, the consequence of not following the time limit is lapse.
Yes.
What lapse is? Everything has they have acquired, it has vested.
No, the question is this. Now, here, the second limb of submission is that first, that the declaration can be made, I am not saying that. Second is in
only section 11, 12, 23 for the purpose of calculation.
Your lordship is saying that means amendment made in 1984 will not happen. Your lordships, not final, but your lordships is of the view that 11A was not there at the time.
We are seeing what we are trying to say, Mr. Beda, is
yes, 11A was not there.
Lapse, this proviso would not apply because 11A, suppose 11A is applicable, then what happens? Then 11A says the collector shall make an award under section 11 within a period of 2 years from the date of publication.
Publication of declaration.
It is the proviso which says that in a case where the declaration has been published before the commencement of LA Act, 1984, the award shall be made within a period of 2 years from such commencement.
Yes.
Suppose it is not made, then what
the
happens?
Proceedings will
lapse. Now, if the proceeding lapse after they acquire, here they have acquired and it has vested, because only after that LA Act
only
comes.
Question of vesting. Only question. Award has yet to be declared. Award has not been declared as yet.
You're completely, because if you agree that that LA Act application has to follow acquisition.
Yes.
It says provincial government may acquire the land and thereupon. You said yes. Thereupon means thereafter.
Yes.
So once they acquire, only then LA Act will apply.
Yes.
So if they acquire, automatically that presupposes that the land has vested.
Then when
without vesting, there is no acquisition.
Acquire when acquisition is complete. I am asking
case of 1948 Act. Once they acquire, only then LA Act applies.
Apply. Then ultimately they are required to.
Can there be any acquisition without vesting?
Very well. They are required to declare an award under LA Act. Unless
what we are saying that once acquisition is complete, acquisition vesting goes hand in hand with acquisition. There cannot be an acquisition without vesting.
Not the,
provincial government may acquire the land.
Yes.
Once they acquire means land vests in them.
No.
It can.
With due respect to your lordship. Acquisition completes only after declaration of award. A proceeding only on taking.
That is under the LA Act. Under 48 Act, the scheme of the Act is once the government acquires,
says only vest. Acquisition is not complete. Vesting is one thing. Completion of acquisition is different thing. Language of A, proviso A, it says once possession is taken, property vest in the state. title goes on pass. I am not disputing title passes on to the government. This complete acquisition. They are required to declare an award. When that award will be declared? Suppose, my lord, your lordship is saying 11A will not apply. Then they are also required to declare an award under the Land Acquisition Act. Can
Yes, that
Yes.
they will.
That
For
they
that
will.
limited purpose, the act applies.
Yes, for the limited purpose. Very well. That's what I am admitting. Whether 11A will apply or not, that's I am coming later on. Next, my lord, kindly read it very carefully, my lord.
Yes.
পুরনো Land Acquisition Act দাও তো একবার। LA Act. My lord, I am reading it. My lord, that's why I say your lordship has said Section 4 provides any kind of land needed for public purpose can be acquired.
Yes, that you are saying also.
That then, but provided that kindly read, if in any case the provincial government so directs, the collector may at any.
You are reading proviso to which?
Proviso provided where the land speaks about vesting.
Proviso of which section?
Section 8(1)(a) regarding vesting.
Yes.
Or old. Kindly see the old act.
We are seeing the old.
If in any case the provincial government so directs, the collector may at any time after a declaration is made under Section 6 takes possession in accordance with the rules of any bill, bower, tank or other watery area or any other waste or arable land in respect of which the declaration is made, and thereupon such land shall vest absolutely in the crown, free from all encumbrances. Now here kindly see that even if all several lands were, my lord, notified for acquisition, but you can't take possession of all lands. Only the land specified therein, only you can take possession of that. So before taking possession, the government is required to classify the lands which comes within this definition. You cannot take all kinds of land.
Right.
Now your lordship has seen 3 possession certificate is coming. One, they are saying, my lord, in 1950. No, not 2. He has handed over me 1 immediately after that. কেন কথা বলেন? আমাকে দিয়েছেন কপি, সেটাই আমি দেখেছি।
সেটাই তো
দেখাতে পারি সাদা কাগজটা কোথায় গেল? Yes, I think possibly this document has been handed over to your lordship.
Was we returned? So many documents are handed over because that is a part of the record. We asked him to produce certificate.
Then my lord, it says several plots. It also, my lord, it will also appear from 79 declaration. Here, this is possession that they are delivered 20th November 1950. Plots are mentioned 365, 3065, 3067, 3074, 3078, and part of CS plot number 3075, 3077, measuring about more or less 9.33 acres. It is government owned records. Here, some plots are mentioned of the same nature. My plots are also covered by these plots. I am not different. I will subsequently give the details of that. This is one. Here, no mentioning what are these lands, whether which of the land is bill, which of the land is bower, where of the land are watery area. Nothing has been stated here.
But you have never challenged that.
You know,
You have never challenged.
they are bringing it for
rather your predecessor has taken some part of compensation. They have also produced a letter.
My lord, that is not the award. I will come to that. That is not the award. That is provisional estimate.
No, I am not saying that is an award.
Then
part of the award, provisional.
Not part of the award. There is no scheme to pass ad hoc compensation under the Land Development Planning Act or under the Land Act.
That is what we were wondering. What is that about?
Yes. Then this was not, unless these
there are other discrepancies also. In 1979, they published.
They
rely on a section 4 notice of 19.
Also,
they rely on a section 4 notice of 1950 when the amended provision was not there, and they say under section 6(1)(a) I am doing it. 6(1)(a) was not
what
there.
I am saying, if without specifying the nature of the land, even in all cases, in 52, no specification. In such cases, my lord, I think that the possession taken is illegal. Without specifying the nature of the land.
Unless you rebut, there is a presumption of correctness in official acts.
No, my lord, they must specify.
40 years
I may be wrong, my lord.
that was wrong.
Then, my lord,
We have to
This is
presume
my
that that
submission.
was bill
in
bound or
nowhere.
something.
Then, my lord, your lordships kindly come, section 17, as originally stand prior to 1984
Section 17 of?
of the Land Acquisition Act. No, I am taking, my lord, I am trying, my lord, to
17
assist your lordship.
17, why are you?
That is urgency clause, that's why 11.
That's he has relied upon.
Here also. No, he has not relied on. He says this 81A is akin to that. 7 is akin to
81,
that.
that's why, my lord, I am coming to that, my lord. Your lordships kindly
17
come.
is not applicable here. Let us
Not
not confuse
applicable,
ourselves.
but I will. He has said it is perimeter like that. What I want to say, relying upon this, that my lord, these points were not canvassed much, but there are some judgments on the Land Acquisition Act that before taking possession, the lands must
All
be
are on LA Act.
under LA Act.
All in LA Act.
But the provision,
LDP Act.
but our provisions are like similarly section 17.
No, there's something here, Mr. Beda. Now there are 3 terms here.
Yes.
4 terms.
Yes.
Please consider those. Notification.
Yes.
Under section 4.
Yes.
Declaration under section 6.
Yes.
Acquisition.
Yes.
And vesting.
Well, your lordships, here in the original.
Unless you look at us, Mr. Bera, we cannot go on speaking with you. Please complete what you are doing and then we'll speak.
No, but your lordship ask me.
There are 4 concepts under both this act and that act. One is section 4 is a notification, 6 is a declaration, acquisition is a general term, and vesting. Vesting under section 16 of that act or 8A.
8A.
Now, what is acquisition? When is acquisition complete? According to you, on declaration, can it be?
Yes. No. On declaration, it can't be.
Achha, acquisition, what is the meaning of acquisition? The state acquires the property.
Yes.
Unless acquisition is complete in every respect, it cannot be said to have been acquired.
Yes.
So once you say acquire, doesn't it automatically mean that it has vested?
No.
That is our question.
My lord,
Can
I
there
say,
be acquisition
I say, concept of vesting is this, that the property, unless divested, property right.
Unless divested, how can something vest?
No, the vesting means title of the property passes.
You are not answering your question. Our question is whether acquire
yes
includes the expression vests. Because isn't
it's a part of
vesting is a mirror image of acquire. If
yes.
I acquire,
yes.
you write vests.
Yes.
Otherwise, I cannot acquire.
Yes.
Acquire means take away.
Yes.
So language of section 8, because LA Act is somewhat different. LA Act proceeds on the premise 4, 6, notification, declaration, then certain paraphernalia, then award, then whatever, then 16 says possession and if unless it's under 17, then possession previous 80%. Now that's a different thing. Here in LA Act, nowhere it is used, the expression acquire. Acquire is not used in notification section 4 or 6 or 17 or even 16. 16 does not say acquisition. 16 says when possession taken, vesting happens.
Yes. And 17 also vesting.
Only place where the term acquire is used
yes.
is in section 8
yes.
of the LDP Act.
But
section 8 says, now please forget LA Act for the time being, because LA Act, we are not speaking about the LA Act. LA Act has not come in as yet.
Yes.
We are only on the LDP Act.
Yes.
LDP Act says a declaration under section 6 shall be conclusive evidence that the land in respect of which the declaration is made is needed for a public purpose. And after making such declaration, the provincial government may acquire the land.
Yes.
And thereupon the provisions of the LA Act will apply.
Yes.
So LA Act, we cannot look into the LA Act unless there is an acquisition under this Act.
My
what do you mean by this acquisition?
If your lordships, even if you use the word
what do you, shall may forget. Unless there is an acquisition, LA Act does not come in. So you don't come in at all.
Lord, my respect to it is to be read as a whole. If you want my respectful
it says may acquire.
Yes.
And thereupon provisions of may shall is irrelevant, because if it is may and it is not acquired, then LA Act does not come in. Your arguments will go. LA Act does not come in at all.
No.
LA Act comes in only if there is acquisition as per section 8.
Yes.
Because this is an enabling provision which attracts the provisions of the LA Act only upon some happening. Yes. What is that happening? After making declaration, the provincial government If it acquires the land,
Yes.
only thereupon elect shall come.
Come.
So acquire, doesn't it mean the state acquires mean automatically the person is divested of his rights? Otherwise, how can there be an acquisition without you losing your rights?
My lord, with respect, my lord, what my interpretation is that
What is the meaning of acquisition? Dictionary meaning. See the dictionary.
acquisition means acquired, property has been acquired.
Somebody
But
acquires
here-
means other
here,
side goes.
Here not the acquisition. Here language is you can acquire, may acquire, you can acquire thereupon. Then
May acquire. If you acquire only, then elect
Then-
comes in.
only end, but it is to be done under LA Act. Acquisition is to be done under LA Act. Not acquisition is complete before application of Land Acquisition Act.
No.
But it can't be mirrored.
No. Language is very clear.
Because
After making
my,
declaration,
my interpretation
this
is
is plain English, Mr. Where there is no scope of interpretation.
My-
Provincial government may acquire the land.
Yes.
May or shall, once they acquire
Acquire
only,
may
then it comes in.
Yes.
May acquire the land, and thereupon the provisions of LA Act apply.
Yeah.
So far as may be.
Correct.
So,
So-
what do you mean? We asked you specifically whether thereupon is equivalent to thereafter. You said yes. If it is after, then only after the provincial government acquires the land, the LA Act mutatis mutandis, so far as applicable, may apply.
My respectful submission is acquisition cannot be done without the help of a Land Acquisition Act. Acquisition cannot be done.
All
If
right.
you- my lord, that's my understanding. But I may be correct, but that's my interpretation. Acquisition cannot be done without the help of Land Acquisition Act. It means so. But that's
So
my
then this
interpretation.
portion will become redundant.
Not redundant.
No,
Because
no.
may require, may acquire.
May acquire the land.
May
and
acquire means
may acquire.
Yes. Acquisition is not
Then
complete.
you are saying may acquire,
Means
that acquired will be, acquisition will be under LA Act.
yes.
And thereupon LA Act shall apply.
No. It is to be read as a whole. My submission is that may acquire means acquisition is not complete. May acquire under the provisions of Land
May
Acquisition Act.
acquire and thereupon LA Act applies.
Yes.
We are reading as a whole. You are reading in a truncated fashion. You are separating may acquire and thereupon. We are reading as a whole. We are saying provincial government may acquire the land. Acquire.
Yes.
Thereupon is a suffix of acquire.
Yes.
It qualifies acquire.
Yes.
May acquire the land and thereupon provisions of LA Act apply.
Then
So
when
how can you put the cart before the horse?
no, my lord, what I am submitting, may
LA Act
acquire
comes in only once it's acquired. May acquire and thereupon, that word is there.
there. But how the acquisition is complete before declaration of award? We are to complete the
You are going by the notion of LA Act. You are entirely superimposing your concept of the LA Act into this Act, which cannot be done. LA Act comes in only after it is acquired, property is acquired as per the LA Act, LDP Act. LA Act, under LA Act, unless there is an award, there cannot be any acquisition. Unless there is section 617.
But my lord, my respectful submission is this: may acquire and thereupon after suddenly after declaration land acquisition will
It does not
apply.
say after declaration. It does not say declaration will happen and thereupon LA Act will apply. It says after declaration it may acquire.
Yes.
After acquire, thereupon LA Act applies.
My lord, if we read in this fashion, first of all declaration is made. First of all,
Read it out. We cannot read in any other fashion than the statute provides.
The
Please,
statute-
you read out and you make your own. view.
Yes.
You read out as it is.
yes. But after
No, read
But
from the beginning.
Wait.
Section 8.
A declaration under section 6 shall be conclusive evidence that the land in respect of which the declaration is made is needed for public purpose.
No,
Nothing-
stop there. Please read the sentence.
Yes, needed for public purpose. This is one part. Then, after making such declaration, then the declaration is published. Then the
Mr. Veda, please.
then
For
the-
once, please don't introduce your comments into it. If you say read as a whole, please read as a whole.
Yes,
From 8
I-
up to the semicolon, colon, please read as a whole. Don't introduce your comments.
After making such
No, read from the
a
beginning
declaration
once.
under section 6 shall be conclusive evidence that the land in respect of which declaration is made is needed for a public purpose. And after making such declaration, the provincial government may acquire the land and thereupon the provisions of the Land Acquisition Act hereinafter in this section referred to as the said act shall so far as may apply. So, my lord, what I say, what is my interpretation or what is my submission, that the may acquire, this acquisition is to be done under the Land Acquisition Act.
And thereupon provisions of Land Acquisition Act shall apply.
No, that is to be read.
That is the language, and thereupon the provisions after acquisition, the Land Acquisition Act applies.
Here I am, kindly don't take it otherwise.
Cannot
Your
override the statute.
Acquisition cannot be completed because vesting is comes
Under the LA Act, acquisition cannot be completed. If it is an acquisition under the LA Act, we are not speaking about an LA Act acquisition.
I understand, Mira. I am not saying that. I am saying the use of this language. My understanding is this. This acquisition relates to
Plain English
Mira, my submission is this, that this acquisition
তাই তো এলিয়া একটা কনসেপ্ট উনি এলিয়া একটা কনসেপ্টের বাইরে বেরোতেই পারছেন না, ভুলে গিয়ে এটা আমি এটাই বোঝাতে পারছি না এতক্ষণ ধরে। এলিয়া একটা আমাকে ভুলে যেতে, এলিয়া বলে কোনো অ্যাক্ট নেই যতক্ষণ না এই অ্যাক্ট ঢোকাচ্ছে। এটা পুরোপুরি এই অ্যাক্টে শুরু হচ্ছে, এই অ্যাক্টে শেষ হচ্ছে। এই অ্যাক্ট যতক্ষণ না বলছে আমি এলিয়া কেন কোনো এক্সপ্রেস অ্যাক্ট ঢোকাতে পারবো, এলিয়া অ্যাক্টে কোনো অ্যাপ্লিকেশন নেই যতক্ষণ না এই অ্যাক্ট বলছে। এই অ্যাক্টে সবকিছু কমপ্লিট হবে আপ টু অ্যাকুইশন, মে অ্যাকুয়ার দ্য ল্যান্ড, তারপরে ওটাকে ঢোকাচ্ছে, ওটার আসছেই না তার আগে। কাজে ওর কনসেপ্ট আমি এখানে অ্যাকুইশন ঢোকাবো, এই বাংলা কথাটা বোঝাতে পারছি।
Subject to don't take me otherwise.
We are not taking.
My submission is this, that this acquisition relates to acquisition by under the Land Acquisition Act. That is one point. Then, my lord, I have your lordship, that point was never taken, but I say that without mentioning in the possession certificate, I am not saying about in the section 4 or section 6, but when you are taking possession of the land, you must specifically mention that the nature of the land which you are acquiring. In none of the possession certificate, specification of land is there. So, my lord, to that extent, my lord, the taking of possession is bad in law. My submission is that with regard to that aspect, I have some judgment on the Land Acquisition Act, but since your lordship is not inclined to say that,
those are on Land Acquisition Act,
yes,
not on LDP Act.
Similar
not a land acquisition proceeding. We are failing to
similar provision was there in section 17. So what I want to say that before
section 17 nowhere speaks about any acquire. After acquisition, this applies.
No. This similar provision was there previous 1984. Only certain specified tracts of land can be taken, not all land. In 1984,
Mr. Bera, occasionally you must take a stroll and go out of the LA Act. There are other acts in the world also.
The land,
you may be a specialist on LA Act, but there are various other acts in the world.
Various other acts, I am not.
Like the LDP Act,
if your lordship says
which only bring in LA Act.
Yes.
After the, as per the Act,
yes,
the Act says after acquisition, LA Act comes in.
Very well. Your lordship, I leave it to your lordship. That's my submission I have made. Your lordship, whether your lordship.
Second submission is that unless it's those under those categories, bill and all
are mentioned
in the notification.
Not in the notification. Before taking possession.
Mentioned where?
In the possession certificate.
So those have to be mentioned in the possession certificate that this is of
because
this category.
Otherwise, suppose my vastu is there, suppose my building is there, you cannot take possession of that.
But doesn't taking possession presuppose that it falls under these categories?
I do not know. They have to do it.
Under which provision they have to do it?
Under proviso.
Assumption of correctness is there in official act.
Under the proviso.
Proviso does not say that they have to write in the possession notice. Proviso only says
proviso
they can take possession of this category.
Only categories of land can be taken.
And they have taken the land. There is a presumption
without
that
specifying the land. Then if your lordship so desires that I am saying that in my writ petition I have annexed my records of right, whether all these are lands coming under this.
You have stated what?
I have not taken that point in the writ petition. I have taken on the basis of section 11A. Various classes of lands were there that to prove my title I have annexed it. Your lordship need not go into that, but my second submission is this, that without specifying the nature of the land in the possession certificate or specifying or deciding by the government that these lands are come under this head or under this classification, they cannot take possession under 81A. This is my second point.
And 2013 Act?
2013 Act, Mirror, I am coming. Suddenly, Mirror, I cover that. Well, just a minute.
Yes.
Then, my lord, if, my lord, for, I do not know, my lord, if the possession is taken illegally, then, my lord, 11A will apply. Your lordship has not that the daily airtech service, no? Daily airtech service. No, my lord, I am not saying whether the possession has been, but by my submission, the possession is taken illegal on the second point, not on the last occasion. I say section 4 that goes there because originally
saying that.
I have
Fair enough.
Kindly bear me for the moment. আমার গুলো কোথায় গেল? আমারও উত্তর কোথায় গেল? আমার এখানে better I will rely upon the judgments.
Yes, 60 years কি করলেন? 60 years.
60 years. Mirror those daily mirror these judgments I will rely. I am handing what to renew. Mirror that I will rely upon. Mirror, I am not. In any case, mirror, I say that since no classification is, possession is illegal. If possession is illegal, then mirror section 11A will apply. Your lordships kindly come.
Yes. Yes.
Mirror, I will not miss paragraph 1, 2, and 3. This appeal has a checkered history. Oh, sorry. Your 2022 SCC online SC 1408. Delhi Airtech Services Limited versus State of UP and another. Delhi Airtech Services Private Limited versus State of UP and others. This appeal has a checkered history. The appeal was heard by a bench consisting of two honorable judges, Justice A.K. Ganguly and the Sadan Kumar, and was decided by a judgment dated 18/8/21 with divergent opinion. In the process, after consideration of the honorable court.
Mr. Bera, we'll start from here on the next day. And please, both of you, please, if you can, please bring that chart.
Generally, I do not ask for accommodation.
No, no. In difficulty
next Thursday, I have some personal difficulty.
No difficulty. We'll keep it after that. The Thursday after that. But in the meantime,
yes,
since you have the records, Mr. Shenguti, please take the lead in that.
আপনার ইয়েটা দেখে নিন, অরিজিনাল ইয়েগুলো দেখে নিতে পারেন, ইন্সপেকশনটা করে নিন।
Yes, you can look into the documents and they'll just just give us a chart of the lands which were withdrawn later, the quantum of the land and the plot numbers. This plot number, this quantum, total quantum, and what remains. And the on one list of dates, the entire things, the first position and all those things. And if you please refer to the page numbers.
Yes.
Where you give the list of dates, just give the page numbers. And both the chart and the list of dates, give a copy to Mr. Beras Jr. Hard in part.
And my lord, the whether inspection আপনি কি inspection
নেবো একবার।
Yes,
নিয়ে নেবেন কবে?
কালকে দিয়ে দেবেন?
কালকে তাহলে
they'll have to come again. Today, take it. No
আজকেই
you're ready with the matter, so take the inspection right now. It's a document.
Personal difficulty today, Miller.
Today I have to leave court. Immediately.
Immediately.
Tomorrow they will come.
His officers knows my chamber. He will come to my chamber. I will know.
A dangerous proposition.
Dangerous proposition of law.
Not dangerous proposition. I will not destroy anything. I can assure you, Lordship.
Sir, এখানে কোর্টে এসে
not that. They are knowing your chamber. That is it. The hard in part for further hearing on November 26. Sorry, November হচ্ছে না তাহলে December 4, 2025.
Much obliged.
Thank you.
I will try to assist your Lordship.
Yes, yes.
I may be wrong in my submission, but your Lordship.
Any one of us may be wrong.
No.
If the matter is hard, we don't know who's wrong.
Because
all these are tentative. All these are tentative.
Only one thing I am submitting because
everything is tentative.
We have to rely upon Land Acquisition Act. There is no other.
You have an obsession for Land Acquisition Act.
No obsession.
Yes, yes.
No obsession.
Even in matrimonial suits, you'll find another Land Acquisition Act. If you are interested with a divorce suit to be filed, you settle the matter and you will put in provisions of Section 11A.
With my limited knowledge.
For separation, Section 11A, it has lapsed, the marriage has lapsed. Desertion, lapsed.
I try, I am with my limited
You are an
knowledge.
authority on.
No, no, Mirror, no, not authority.
Everybody knows that, Mr. Vera. All the judges know, all the advocates. You cannot deny that.